ಮೇಡಮ್ ಬರ್ಬೇಕಾ?
ಹೌದಂತೆ. ನಾನು ಹೇಳಿದ್ದೆ ನಿಜ. ಅಲ್ಲಿ ನಾನು ಬಿಡಲ್ಲ, ಬಿಡಲ್ಲ. ಯಾರು ಹೇಳಿದ್ರು ಗೀತಾ ಮೇಡಮ್ ಹತ್ರ ಬಿಟ್ಟಿದ್ದೀವಿ? ಕೈಯಿಂದ ರೊಚ್ಚಿಕೊಂಡಿದ್ದಲ್ಲ ಮಾತಾಡ್ತೀನಿ. ಸಮೀಪ ಆಗಿದ್ದು ಸುಮ್ಮನೆ ಇದೀನಿ.
ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಏನೇನು ಕೇಳಲ್ಲ, ಏನನ್ನು ಕೇಳ್ತಾರೆ ಈಚ್ ಏನು ಇಲ್ಲ, ಏನು ಕೊಡೋದು ಅಷ್ಟೇ ಅಲ್ಲ. ನನ್ನನ್ನು ಮೂವ್ ಮಾಡಬೇಕು.
ಡೇಟ್ ಕೊಡ್ಬೇಕಾ? ಡೇಟ್ ಬೇಕಾ ಬೇಕಾ? ರೆಸ್ಪಾಂಡ್ ಪ್ಲಸ್ ಇದು ಬೇರೆ ಇದೆ, ಕಲಬುರ್ಗಿ ಬೇರೆ ಇದೆ. ಒಂದು ಮಾತ್ರ, ಇನ್ನು 2 RTF, ಒಂದು ಆಲ್ರೆಡಿ ಬರ್ದಿದ್ದೀರ, ಇನ್ನು 2 ಬರಿಬೇಕು. RTF ಮಾಡಿ ಕಳಿಸ್ಕೊಡಿ. ಎಲ್ಲ ಹಿಯರಿಂಗ್ ಆಗೋಗಿದೆ. Any memos? Any adjournments? This one, page 3, serial number 8 and 9.
Number 8 and 8.1. Respondent Malaysia. Last week, NOC Wakalat Malaysia. Inform the petitioner. 1 week press button.
Counsel for respondent press for time. Both the counsel undertake to address their arguments on the next date of hearing. Next. Yes, date will be given, sir. Next.
Page number 4, serial number 10 to 15.
Serial number 12, my. The petitioner. Serial causing not billing. Only 1 week. Counsel for the petitioner press for time. This time. Next. Increment exchange. Yes.
Page 5, serial number 16. List 1, page 1, serial number 1.
Serial number 19, my lord. My senior is having some medical emergency, my lord. Bisnir bidide swami avare kaalge. 1 week time ಬೇಕು swami avare.
Counsel for the petitioner press for time. 19.
Serial number 26.
Much obliged.
On behalf of my colleague, he is down with severe food poisoning.
26, sir.
26.
Counsel for the petitioner press for time.
Interim order may be extended.
Yes.
Malaysia.
Serial number 25. Convenience for the senior. Have it after a week.
Petitioner press for time.
Malaysia. Serial number 22.
Yes, it will be extended, sir.
Malaysia. Serial number 22. Malaysia. Request on next week. Malaysia.
This time. 22.
Intimate exchange.
Yes.
Much obliged.
Serial number 1, AV Gangadharappa, GS Patil.
Appear for appellant.
Respondent bundle. Counsel for respondent number 1 is absent on representation. Allowed. Appeal is allowed with cost. Reasons to follow.
Both the appeals.
Yes.
Serial number 2, CN Satyanarayana Shastri, BM Siddhappa.
Okay. ಮತ್ತೆ ಇದು ಮತ್ತೆ ಇದು ಟ್ರಾನ್ಸ್ ಆಗಿತ್ತು ಮತ್ತೆ ಅದೇನಾದ್ರು ಇದ್ರೆ ನಾನು ಗಮನಕ್ಕೆ ತರಬೇಕಿತ್ತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು ಯಾಕೆ allowed with cost.
Serial number 3, BB Shivakumar, Rambhat Shripad, connected matter Jagdish Shiremath.
Even complete agida argument. Argument is completed. Already completed.
Some RTF.
Yes, appeal is allowed with cross.
Serial number 4, A Sampath.
First of all.
Government, my lord, has to say whether, my lords, and the
My lordship, last time, the last occasion, it was instructed to me to get the proper instruction, my lordship.
Drugs.
Whether procedure is followed or not. Procedures are followed, my lordship.
4
Well,
samples.
4 samples were taken, my lordship. 1 sample on the spot itself, it was given, my lordship. I have the records also. May I pass on my lordship records?
The other one.
And the second portion was sent to lab, my lordship, under Form 18, my lordship. And third portion, when they indicate the first, from where the sample was drawn, if they indicate from which
Retailer.
retailer they got it, for them, the third portion was given, my lordship. And also for the petitioners, we have given the sample and took the acknowledgement that it belongs to
Fourth
them.
one court ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lordship.
Court ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, my lordship. In our petition only, it is mentioned as a document in the list of the documents, my lordship.
Your acknowledgement is there for having received.
my lords, I need to check because no documents is.
Okay.
I'll just collect. I will check it, my lords. If there is such a process followed, my lord, no much case. If that is followed, my lords, the second aspect.
ಅವರಿಗೆ ತೋರಿಸಿ ಅದನ್ನ.
Bani.
Yes.
And also, my lordship, we have not received any letter from them, my lordship.
Requesting for the sample.
Requesting for the sample. They given the acknowledgement also for receiving the sample.
Lords, may just
number
take
87.
pass over for 10 minutes.
87 notification page. They have accepted it, it belongs to them, my lordship. And they have not challenged their this complaint, my lordship. Directly, they straight away came for the 482.
Pass over.
Serial number 5, Ganapati Bhatt, connected matter BS Sachin.
Yes.
Please, the question is whether parallel proceedings are permissible is the contention, and honorable court's
Whether
query to us was
invoking section 92 is sufficient.
is sufficient. Is sufficient is the exact question.
Mm.
Now, what my crux of my submission is that the parallel proceedings is impermissible.
Mm.
And this question has always agitated the minds of the honorable courts.
Mm.
Because both actually general law is, my lord, as far the penal offence is concerned, he can be punished under different statutes.
Yes.
But only a exception is if a special statute provides for certain punishment,
Mm.
that overrides. And a general penal law cannot be applied, is the established legal principle. Whether that legal principle is applicable here, especially when the punishment for example, 304 would be much severe than under 92.
Yes.
So this is the question.
Mm.
My lord, I was earlier referring to one of the decisions of this honorable court. Before I refer to the decisions, kindly see how the Factories Act is framed, the entire Factories Act as it is. I'm referring to Factories Act because
One minute.
please.
Why 304 cannot be invoked? Only 304A could be invoked.
In the present facts of the case, no such ingredients are made out. There are absolute no ingredients for 304 in the present case. Last judgment, clear.
Yes, 92.
92, please, my lord. May I read 92? May I first take out how the Factories Act has been framed, just the outline, please.
Yes.
The Factories Act concerns and refers to and covers all the accidents in the factory and all the mishaps that would occur in the factory.
Mm.
It's a very exhaustive legislation, very exhaustive. It in fact provides for licensing of the factories and how inspection should be conducted, how the health and safety of the workers should be secured, and how hazardous processes must be undertaken and regulated.
Yes.
And if some accident happens inside the factory, what is the procedure?
Yes.
And the duty on the employer is also specifically mentioned, and it then provides for a penalty. Now kindly see the content itself, of the act itself. One thing is section 6, approval, licensing and registration of factories. And 7A, the provision capital 7 capital A, general duties of the occupier. Here, the duty to take care is specified. Then the inspecting staff is also there. Chapter 2 deals with the inspecting staff.
Yes.
Chapter 3 deals with the powers of the inspector is also there. Chapter 3 deals with the health and the safety.
What happened to the proceedings under 92 Factories Act?
That has report has been filed, complaint has been taken cognizance, and they have been held guilty. Of course, probably what was running in the mind of the honorable court is regarding the punishment.
2 years.
Yes, 2 years, and it's not only that aspect; it's 2 years or 92. With the contravention so and so, which may extend to and so and so, the punishment may extend to 2 years or with the fine. It's with fine. It's like many statutory offences where there is also 2 years fine plus 2 years or fine. So whenever they plead guilty, there would be the learned magistrate in his wisdom, even he may impose a fine.
Fine, but we paid fine.
Please, that offense has ended with conviction.
What is the fine imposed?
1 lakh each.
Pleaded guilty.
Pleaded guilty.
After that, we have paid these, he asked us to pay compensation. We have paid compensation.
Now, two aspects. What would run in the
The factories, the proceedings under Factories Act was held before whom?
before the run JMFC Mangalore,
JMFC.
JMFC Court Mangalore.
We have paid compensation to the victim also.
Now, one thing that would naturally, from experience also, I would fairly inform the honorable court, that would run to every honorable judicial mind is whether any compensation is paid or not. Compensation is covered under the Workmen's Compensation Act, and that has been paid. And affidavit is also filed before the learned magistrate about the payment of the compensation is concerned. Page 1.
Yes, page 39.
Page 39, page 39 of the petition
Of my IA in my petition.
in the IA ಒಟ್ಟಿಗೆಲ್ಲ documents ಹಾಕಿದ್ವಿ.
ಯಾವುದು criminal petition number?
Filed by Sri Sachin BS, that's WP 8879 of 22, 8879. There, IA for documents ಅಂತ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ವಿ. 13/11/25. 13/11/25.
IA for this.
IA for disposal we have filed in view of the criminal case launched and culminating with the conviction. There, page 39. A letter submitted by the employer firm to the deputy commissioner regarding the payment of compensation to rightful kin of deceased who died on account of the accident occurred on so and so. And we have released some compensation of 15 lakhs. Amount has been disbursed by RTGS by so and so. Details are also furnished.
No, where is the order of the learned magistrate?
Please. And one more thing at this moment only, page 42.
Page 28.
Page, please, before that kindly, page 42.
You be a complainant.
He is the complainant. Hasanur Bondal, after the payment has been made, he says, I have no complaint or grievance against Sri Alka LLP, that's the employer. And my lord's
Page 28.
direct question to me regarding the order of the learned magistrate, page 28. Accused under acting under section so and so, convicted for dash dash of the Karnataka Factories, of the Factories Act. And acting under so and so, accused one so and so, together sentenced to pay fine of 1 lakh each. In default, undergo SA for 3 months. Then upon the payment of this fine amount, page number 29. 29, matondu 30. And so therefore, as far as the prosecution case as narrated in the complaint,
Why there is no reference to section 92? Complaint.
in, please, my lords, though contravention of the rules learned magistrate has mentioned, the complaint speaks, my lords, of the offences. Kindly see the,
All the offences
Please.
which was done in the Practice Act is an offensible under section 92.
92 is a general provision because there are many contraventions and magistrate refer to the
No,
contraventions.
penal provision 92 ನೇ ಅಲ್ಲ.
ಹೌದು ಅದು ಹಾಕ್ಬೇಕಿತ್ತು ಅವ್ರು ಹಾಕುವಾಗ. Please kindly see the complaint itself, my lord,
Page 21.
because complaint is page 25. Accused person the above case have hereby committed 25 committed the offence under section 92 of the Factories Act. And what are those contraventions are detailed in page 22. Because in Karnataka there are rules, please, my lords. Page 22, Roman number 8, contravention under the Factories Act and Karnataka Factories rules. Which are those relevant?
Non-taking of safety measure also is not included in this.
There are several contraventions, several rules. In fact, not taking the proper safety measures is also part of the complaint. All these are covered. And there may be some mistake by the London magistrate, my lords. London magistrate referred to Karnataka Factories Act. In fact, it's Factories Act Center Statute, Karnataka rules. Karnataka Factories Act. Please, ma'am. So, in the light of this,
Not taking of safety measures.
once we have accused numbers 1 and 2 have already been convicted. And the honorable court's question to me regarding non-taking the safety measures, negligent in not taking the safety measures, it's also one of the contraventions.
Yes.
Inspection ಮಾಡಿದ್ದಾರೆ factory act. Report ಮಾಡಿ based on the report, complaint is filed.
And this complaint is filed by the statutory authority under the Companies Act. Now,
Practice.
under the, Factories Act, under the Factories Act.
Yes.
Now, next question is one aspect you'll have to kindly see, page number in the complaint itself at the top, page number 6. There, page number 6. Prosecution under section so and so, otherly documents, number 1 complaint, number 2 spot inspection report. 3 form 17 along with the enclosures from the management, endorsement to the objection document submitted by the management. Next, statements of so and so workers.
Now this complaint is so motor complaint.
My lord, under the Factories Act, every accident that happens, employer is duty bound to inform.
Yes.
And the factory, the authorities under the Factories Act, they are duty bound to hold inquiry regarding the same. And they are entitled to file the complaint.
Report is filed, submitted based on report, private complaint is filed.
And they have the power to conduct inquiry and file the complaint. This procedure,
This 92 of Factories Act.
Please.
Complaint was by the official.
before the magistrate,
Deputy
because
Director of
there is a procedure for cognizance is mentioned 105, please. 105 of the Factories Act. It provides a procedure. I mean,
Cognizance has to be taken only after.
yes, please, may I read 105 with kind permission? No court shall take cognizance of any offence under this act except on a complaint by or the previous sanction in writing of an inspector.
Deputy Director of Factories Division 1 to file a file.
And therefore, there is a recital in the complaint that there is proper inquiry held and the complaint is filed by the concerned authorized person, who is the Deputy Director of Factories himself has filed the complaint. So, since there is a bar under law for
Now,
taking
who is the complainant in this proceeding?
Deputy Director of Factories.
What I thought. On the basis of.
ಅಲ್ಲ
the same-
ಇದ್ರೊಳಗೆ ಬಿಫೋರ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕಿಂಗ್ ಅಂಡರ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಲೇಬರರ್ ದಟ್ಸ್ ಪೇಜ್ ನಂಬರ್ 42. Complainant is Hasanur Mandal, who is filed the affidavit at page 42. Just now I pointed out the affidavit at page 42. He is a worker, a third party. He has filed a police complaint.
He is the injured,
He was present there at the.
he is the eyewitness.
Oh. I beg to take the kind consideration of the honorable court to 2 or 3 important provisions in the Factories Act.
Now FIR is registered.
Yes,
Investigation.
the investigation is stalled because there cannot be an FIR at all. As far as this offence is concerned, this honorable court has stated it. There cannot be an FIR of this nature at all. There cannot be a prosecution at all. There is a total bar for the prosecution under law.
Yes, what is it?
Before I conclude, may submit the compilation of the citations which we have please, with kind permission, please, my lords. It contains I feel how this honorable court and honorable Supreme Court has viewed the matter. I just conclude. Please, my lords, the exact question, my lords, fell for consideration very recently before the coordinate bench of this honorable court, page one in GV Prasad. There, the question was framed. The exact question was also framed, and it was also a case of accident. Please kindly see page number 8. Page number 8. In the decision, para 10, I beg to read, after referring to all the decisions.
Yes.
Para 10, in the decision set to supply a similar circumstance, following questions were framed. Whether initiation of prosecution under section 304A, while prosecution for offence under section so and so is legally permissible. Whether parallel or simultaneous prosecution is legally impermissible. Whether contravention of so and so and so and so punishable section 22 be clubbed with the offence under 304A, etc. Next, para 11. Insofar as question number 3 raised above, contravention are of different provisions of the Factors Act. However, a question remains as to whether initiation of prosecution under 304A is legally permissible, while prosecution for the offence is launched, and as to parallel and simultaneous prosecution is legally permissible. While answering the above questions, the following observations made in the aforesaid decision relying on so and so. Beg to read the relevant portion, my lords. Referring to section 300 of CRPC and section so and so of the General Clause Act and relevant decisions on the point, this court took note of the fact that section 92 of the Factors Act provides for punishment of imprisonment for a period up to 2 years for contravention of. Next, page number 10. Any provisions of this act, and if such contravention resulted in accident causing death or serious bodily injury, etc., minimum fine of so and so in addition imprisonment. Likewise, section 304A prescribes that whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with the so and so and so. Considering these provisions, the light of 219 of CRPC, it was held that the offences made punishable 92 and 304A are of the same kind and are punishable with the same quantum of punishment. Hence, section 26 so and so becomes applicable, requiring the offender to be prosecuted only under the enactment. Consequently, proceedings initiated so and so quest. Ratio laid down the decisions are followed by this court in so and so. Para 10. I am in respectful agreement with the view taken by this court in the above decisions. Even otherwise, scheme of the Factors Act does not permit parallel prosecutions under two different acts against a person accused of committing offence under Factors Act. 92 is the only section under the act which makes the contravention of offence punishable as a criminal offence. Para 14, you have the above factual and so register FIR against the petitioners by so and so consequent investigation submission so and so 304A cognizance etc. Quest. Para 13, have regard the facts of the case. This court the considered view that prosecution under 304A etc. is quest. Next, my lords. Next, I directly beg to take the kind consideration to.
Which is the decision that is extracted here?
Anant Kumar.
ನನ್ನ
And within the writ petition we have already produced, please, my lords. Kindly see that petition.
page 126.
Page 126, please, my lords.
Annexure Q.
Annexure Q, page 126. Yeah.
Yes.
It is already there. 304 la ಕಾರಣ ನೀವು ಬರೀತೀರಾ 304 Please, my lords. Anant Kumar is there. Your lords got this decision, my lords. Page. Anant Kumar.
Page number.
Annexure Q.
page number.
Annexure Q 126.
ಅದನ್ನ ಮತ್ತೊಂದು ಕಡೆ ಹಾಕಿದ್ದೀರಾ?
ನನ್ನ writ petition.
Writ petition ಅಲ್ಲಿ ಇದೆ.
Page number
126.
126.
And also
ಸೇಮ್ ಅದೇ ಜಜ್ಮೆಂಟ್ ಅನಂತ್ ಕುಮಾರ್ ರಿಲೈ ಮಾಡಿ ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ಬರ್ತದೆ.
yes.
And also one more aspect, my lords, the next decision also, that Arun next decision in the same we are compiled together, my lord, in the old
Same then?
ಅಲ್ಲ ಅದು 304 ಇದೆ ಅದರಲ್ಲಿ 304 ಇದೆ, ಅದಕ್ಕೆ ಅದನ್ನ ಆಗ್ತಾ ಇದೆ.
ಸೇಮ್ ಪ್ರಿನ್ಸಿಪಲ್ ಅನಾಲಜಿ.
304 ಸಹ ಕವರ್ ಮಾಡಿದ್ದಾರೆ, therefore we are mentioning it.
ಯಾವ್ದ್ರಲ್ಲಿ ರಾಜೇಶ್ ಅಗರ್ವಾಲ್?
ಅಲ್ಲ my lords, we are referring, sorry, ಆಚೆ ಈಚೆ ಆಗ್ತದೆ ಅಂತ ಹೇಳುದು. I was referring to writ petition 126, my lords. Writ petition 126.
ಏನ್ 126?
ಈಗ ಹೇಳಿದ್ದು ಅನಂತಕುಮಾರ್.
ಅನಂತಕುಮಾರ್
ಅನಂತಕುಮಾರ್ ಆಯ್ತು. ಅನಂತಕುಮಾರ್ ಆದ್ಮೇಲೆ ಅದರಲ್ಲಿ ಅದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 133 ನೆಕ್ಸ್ಟ್ ಡಿಸಿಷನ್ ಅರುಣ್.
ರೆಡಿ ಕೋನ ಸಾಹೇಬ್.
Yes, yes.
ಓನ್ ಡಿಸಿಷನ್ ರಿಲೇ ಅಂತ ಬರುತ್ತೆ ಹೊಸ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗ್ತದೆ.
304
ಆಯ್ತು.
ಪ್ಲೀಸ್.
Then
304 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್.
Please, my lords, now kindly I beg to continue with this list of citations.
ಇದಕ್ಕೆ ಬರಲಿ ಸರ್. ಗುರುಚಿ ಇಡೀ ಬರಲಿ.
ಅದರ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್.
ಅದರ ಹೈಕೋರ್ಟ್ಸ್ ನಾವು ಓದ್ತಾ ಇಲ್ಲ, ಅಲ್ಲಿ ಬಿಟ್ಬಿಡ್ತೀನಿ. ಅದು ಬೇಡ ಬಿಟ್ಬಿಡ್ತೀನಿ. ದೆನ್
304 ಇಂಪಾರ್ಟೆಂಟ್ ಸರ್. ಹೈಕೋರ್ಟ್ ಆಫ್ ಮದ್ರಾಸ್.
My lords, I will not read all these decisions. Only one thing I beg to read is last decision, my lords. Last decision, my lords, your lordship was asking about 304 Supreme Court decision. Last decision, my lords, page 55. Yuvraj, there's a recent decision. Ingredients of 304, my lords.
Paragraph 4.3.
May I beg to 4.3, please, my lords.
Yes.
On after more than, it's also a case of accident in the factory, etc. FIR was lodged at so and so police station, registered on so and so. About it was stated the appellant did not provide any safety equipments like belt, helmet, rubber shoes, etc. to the two deceased employees. Accordingly, the two accused persons had not taken proper care and caution by providing safety shoes, safety belt, etc. to the employees, though the work assigned to them was quite risky. In fact, both the appellants were responsible for unnatural death of the two employees, and since they had knowledge that there were risk to the lives of the employees, therefore the FIR summed up saying that both the accused were responsible for 304 and 304A. Both were covered here. Now, my lords, kindly see the discussion. Kindly see, my lords, 12, para number 12, my lords. Para number 12. We have noted that the appellants have been charged for 304 part 2 with the section so and so. Punishment for the culpable homicide is quoted. Then 12.1 is important. Ingredients constituting 304 are as follows. He must commit culpable homicide not amounting to murder. The act must be done with the knowledge that's likely to cause death, but such act is not done without any intention to cause death. Therefore, the first important expression is culpable homicide not amounting to murder. Culpable homicide is defined in 299. It says that whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that is likely to cause death, commits the offense. All 12.3, all culpable homicides are murders, except in the cases accepted in 300 IPC. Except the cases specifically exempted in 300 IPC, all other acts within the meaning of 299 would amount to committing the offense of culpable. However, what is important to note is that for committing offense of culpable homicide, a positive act, not negligent, a positive act must be done by the doer with the intention that such act would cause death or cause such bodily injury is likely to cause death, or having the knowledge by such an act death may be caused. What therefore is significant is that the doer of the act must have the intention of causing death. Let's test on this. You should have the intention of causing death, or the intention of causing such bodily injury is likely to cause death, as the knowledge that by doing such act so and so. To commit the offense of culpable, the intention or knowledge is of crucial importance.
Yes, this is important.
Para 12.4. Coming back to 304 part 2, we find that the said section would be attracted if anyone commits culpable homicide not amounting to murder, if the act is done with the knowledge is likely to cause death, but without any intention to cause death or to cause so and so. Therefore, the requirement of 304 part 2 is that the doer must have the knowledge the act performed is likely to cause death or to cause such bodily injury likely to so and so and so. Basic ingredient of 304 is the presence of knowledge, the absence of intention. The doer must have the knowledge that the act performed by him would likely to cause death, etc., but there should not be any intention. Then, my lord,
13 is important.
13. The legal framework, let us now examine the charge. According to the prosecution acts of the Trial Court, High Court, accused person had not taken proper care and caution by providing safety shoes, safety belt, etc. to the two employees, though they were asked to perform the job of working on the sign board as part of the decorating the front side of the shop, which was approximately at a height of so and so. Accused persons had provide only an iron ladder to the two employees, but while working, they were struck by electricity, result of which they suffered electrocution and fell down, suffered multiple injuries. Both the accused persons were declared to be responsible for the unnatural death. Even if we take the allegation against the appellants are correct, we are afraid no prima facie case can be said to have been made out against the appellants for committing the offence of 304. From the record of the case evident, there was no intention on the part of the two appellants to cause death or cause bodily injury likely to cause death. It cannot be said that the appellants had knowledge that by taking the two accused persons, two employees to work on the signboard as part of the work of decoration so and so, they had the knowledge that such act is likely to cause death. As such, no prima facie case of culpable homicide is said to have been made out, etc., etc. Therefore, my lord, for case of this nature, implying, my lord, 304 is too much. And one more edition of the Honorable Supreme Court at page 32, Ravindranath Bajpayee. This page 32, please, my lord. On vicarious liability, my lord, the recent view of the Supreme Court. This, of course, the view of Honorable, this which edition your lordship is just now reading. That view is on the 304, ingredients of 304. It's very clear, my lord. Sir.
1 minute.
Please, please, please. Oh.
Yes.
One more aspect is, now they want to implicate everybody in that. So many accused are implicated, my lord. Whether it is permissible in the same list of citations about the vicarious liability in criminal law is concerned. It's unknown to criminal law unless settled principle, my lord. That Supreme Court has said something happened, for example, something happened in the SEZ, Special Economic Zone, Mangalore, and where all the employees were implicated, all the employees, contract. Factories Act, vicarious liability is fixed. IPC does not provide for vicarious liability except under section 34 and 149 of the IPC.
Yes.
It's only on that point, my lords. In fact, this is the view that Ravindranath Bajpayee is the view of which your lordships had taken, and it's upheld by the Supreme Court. It was decided by the Honorable Court, my lords. One last one. Page 6, Page 47 in the same list of citations.
Yes, sir.
That was 304. In a situation of this nature, para 6. Here also it was left to the contractor. Para 6 says a job was left to the contractor.
Which list you are referring to? In the petition or in the
Memo list. Memo. Page number 47.
Delhi ಇದೆಯಲ್ಲ 47.
Delhi though, adrolli exhaustively they discuss about these factories and place of work where there is collapse of the building, etc. Whether 304 would be attracted. Exhaustively it decides. Para 6 also same thing, where the work is entrusted to the contractor. In fact, contract has to take the responsibility, etc. And about the 304, same thing, para 11, my lords. So in case of this building collapsing or the workman falling in the pit or dying, etc., there cannot be any 304. So my lord, the crux of the matter is, Factories Act is special statute. It covers all the situations of accidents happening. It's a case of accident. Now here is a case where there is a report of the inquiry by a report by the concerned statutory authority, which is concluded that it's an accident.
Yes.
Of course, one sentence I would add, we are not in a case of where intentional fire takes place, intentional bullet shots happen or somebody is murdered inside. That's a different case. If an accident happens, accident is always, my lords, may I submit this, accident is always attributable to this or that, one or the other negligent act or lapse on the part of the employer. Therefore, in some cases, what they do is they add 304A, 304 together. In some cases, they don't. Please.
Yes.
Great.
My lordship, even though section 304 of IPC attracts, my lordship, they have already punished under Factories Act, my lordship. And also the compensation has been given to the victims, my lordship. And they have given the judgments which states that 304 and Factories Act.
The petitioner being accused number 1 in WP 8879 of 2022, and the petitioner being accused number 4 in WP 4548 of 2022 are seeking to quash the criminal proceedings initiated against them in crime number 52 of 2022 Bajpur Police Station for the offence under section 337, 338, 304, read with section 34 of APC. Pending on the file of the Leonard JMFC 6th Court, Mangalore. Heard affirmative for the following reasons. Accused number 1. ಏನವರು accused number 1 ಏನಾಗಿದ್ದಾರೆ?
Accused number 1 is managing partner of the firm. My lord, Sri Olka LLP is represented by the managing partner. Sri Olka LLP is the
Partnership firm.
firm. Represented by its managing partner.
And who is accused number 4?
Accused number 4 is shown as a supervisor subsequently. He is not arrayed as accused even in the report made by the under the Factories Act.
Measures Sri Ulka LLP is a partnership firm. Accused number 1 is said to be the managing partner representing the firm. And accused number 4 the supervisor. It is stated that on 17/4/2022 at 18:10 hours, a mishap had occurred within the factory premises. Within the factory, which is running fish processing, mishap has occurred in a fish processing factory owned by the partnership firm. As a result of which, how many deaths? 3 na? 4?
3 days.
3 days.
3 workers died. And how many injured?
3 injured.
And 3 sustained injuries.
5 injured.
5.
5,
5 injured.
5 injured, my lordship.
5 injured. It is alleged that the owner of the factory, production manager, area manager and supervisor have not taken any precautionary measure for the safety of the workers working in the dangerous condition, which resulted in the mishap. Right? In the mishap. Next part. Initially, the authorized officer, that is the deputy director of factories, as provided under section 105 of Factories Act, filed the report. Filed the complaint with the jurisdictional magistrate alleging commission of the offence punishable under section 92 of Factories Act for contravention of various provisions under the said act. The learned magistrate took cognizance of offence and summoned the accused. 1 and 2. There, accused number 1 and 2 are the present petitioners.
My lord, only before only accused number 1 has now come before the owner firm who has come before the court. Whereas there, my lord, one Robbie Joseph. Right. Robbie Joseph, my lord, is treated as accused number 1.
No, Raju Rohalke
ಹೌದು.
and Robbie Joseph, accused number 1 and 2.
ಅದು ಇದ್ರೊಳಗೆ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
ಅಲ್ಲ, Factories Act ಇದಕ್ಕೆ 92.
Factories Act, my lords.
There are 2 accused, one Raju and Robbie.
No, my lord.
Page number 27, annexure, yes.
27, my lord, that is the police, my lord, report.
Police.
This is page 26 and 27 refers to where the accused were arrested in the course of investigation, my lord.
Factories delide.
Factories Act.
ಅವಾಗ ಹೇಳಿದ್ರಲ್ಲ ಅದೇನು pleaded guilty in
So those are materials are found in the IA, please, my lords.
ಇಲ್ಲ ರೀ ಅದೇ.
In the IA ಎಲ್ಲ documents ಹಾಕಿದ್ವಿ ಅದು.
See page number 28. Acting under 252 CRPC, accused number 1 and 2 are convicted
Yes,
for
yes.
the offence 7A 2E, 7A 2D, 7A 2E, 69, 62, E1, 51, 54,
Yes.
74 of Karnataka.
Exactly, my lords. Exactly. ಅದು ಆ ಪೇಜ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಇದೆ.
ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು?
ರಾಜು ರಾಜು
1 and 2. By name Raju.
He is the managing director of the A1.
Clay. HAKLE, page number 27 allige. And Robbie Joseph. Those accused have appeared before the learned magistrate, that is JMFC second court at Mangaluru, and pleaded guilty. Accordingly, as per order dated 17/9/2022, both the accused were convicted for the offences for contravention of section 7A bracket null 2E, 7A 2 bracket null D, 7A bracket null 2E, 29, 62 bracket null 1, 51, 54, 7 bracket null 4 of Karnataka Factories Act, and they were sentenced to pay a fine of rupees 1 lakh each, and in default to undergo simple imprisonment for a period of 3 months. It is stated that the said accused 1 and 2 have remitted the fine of rupees 1 lakh each on the very same day, that is on 17/9/2022. Next paragraph. It is the contention of the learned senior advocate for the petitioners that even the compensation as required to be paid under Factories Act is already paid to the victims or their family members. ಅದು ಮೇಲೆ section 7 ಅದೆಲ್ಲ ಹೇಳಿದ್ರು. So and so punishable under section 92 of Factories Act. Next part. Now it is stated that one of the victim lodged the police complaint alleging commission of the offense under the provisions of IPC, that is for the offense under sections 337, 338, 304, read with section 34 of IPC. Accordingly, Bajpur police registered the FIR against accused numbers 1 to 8 illa against accused numbers 1 to 4.
1 to 5, 5 were arrested, my lord, in the course of investigation. 1 to 5 were arrested.
1 to 5. 1 to 4.
1 to 4 ಮತ್ತೊಬ್ಬ 5 ಒಬ್ಬ arrest ಆಗಿ ಕಾಣಿಸಲ್ಲ.
And the investigation was undertaken. This FIR was registered on 17/4/2023.
It's 1 to 5 because one more accused was subsequently arrested, my lords.
I think FIR is against case number 1 to 4. In the meantime, the complaint under section 105 of Factories Act was came to be filed. Accused pleaded guilty. They were convicted, sentenced to pay fine, which is already deposited on 17/9/2022. Next, the petitioners being the accused number 1 and 4 have approached this court seeking to quash the criminal proceedings initiated against them. An interim order staying the investigation was passed by this court. Next part, it is the contention of the senior advocate for the petitioner that when invoking section 92 of the Factories Act, which is an exhaustive enactment governing the safety and protection of the workers in the factory, and when the accused are already convicted and sentenced, a parallel proceedings under the provisions of IPC would not lie. Learned counsel places reliance on the decision of this court in Anand Kumar versus State of Karnataka, where the coordinate bench of this court considered a similar mishap occurred within the factory premises. And formed an opinion that the police could not have registered a case alleging commission of the offense punishable under section 304A of IPC when already a complaint as per section 105 of Factories Act was filed. Learned counsel has also placed reliance on the decision in G.V. Prasad versus Balasubramanian, 22 August 2024, where the coordinate bench of this court, placing reliance on Anant Kumar Supra, extracted para 10 para 9, 10 and 14, and formed an opinion that in view of the prosecution under section section 92 of Factories Act, parallel prosecution for the offence under section 304A of IPC is not permissible. Then counsel also drawn the attention of the court to the decision of the apex court in Yuvraj Lakshmi Lal Kanthar versus another versus State of Maharashtra, 2025 SEC Online SC 520, where a mishap had occurred in the factory premises, and it is alleged that the accused persons had not taken proper care and caution for the safety of the laborers by providing safety shoes, safety belt, etc. Considered at length as to whether the offence under section 304 part 2 or 304A of IPC could be invoked under such circumstances, and formed an opinion that there are no prima facie materials to proceed against the accused for committing the offence under section 304A or section 304 part 2 of IPC, as the ingredients to attract those penal provisions are conspicuously missing, even if the allegations made in the FIR is to be taken into consideration. Thus, in view of the various decisions, refer to the position of law is very well settled. Under such circumstances, the allegations made in the first information regarding the mishap that had resulted in death of 3 and injuries to other 5 cannot attract either section 337, 338, 304, read with section 34 of IPC. Next, it is pertinent to note that it is an undisputed fact that a complaint as required under section 105 of Factories Act was filed by the authorized officer, that is the Deputy Director of Factories, alleging contravention of various provisions of Factories Act, punishable under section 92 of the said Act. Admittedly, the accused therein were convicted on they are pleading guilty and the fine is imposed. It is contended by the petitioners that even the compensation that is payable to the family members of the victim, either victim or their family members, are already paid. In view of all these facts and circumstances, I am of the opinion that none of the penal provisions under IPC could be known to the facts and circumstances of the case. When section 92 of Factories Act provides for general penalty for the offences under the Act, and the allegations squarely attracts the provisions of attracts the contravention under the special enactment, that is Factories Act, which will prevail over the general provisions under IPC. In view of the above, I am of the opinion that the proceedings initiated against the petitioners is an abuse of process of law, and the same is liable to be set as damages and liable to be quashed. Accordingly, I am supposed to find this also. Yes, petitions are allowed.
Most great.
Serial number 6, S. Rashekar.
View of disposal of so and so.
Appear for petition, can pay the process. My lords. Earlier, not my lords, the complaint was served, my lords, it was unrepresented. Insofar as accused number 3, my lords, has preferred petition, my lords.
You know, service of notice.
Insofar as accused number 3, my lords, has preferred criminal petition, my lords, wherein very mentioning very same address, my lords. The notice was served upon him.
Although already disposed of,
Disposed of.
whether they are served,
In that petition, my lords, it was served, my lords.
served and represented.
Unrepresented.
File a memo to that effect.
Please.
File a memo. Not a pass over.
Serial number 7.
Appear for the petition in the connected matter, my lord.
Yes. He has to comply with the office objections on the statement.
Please, my
Take
lords.
up on next week.
Please. Date may
For respondent undertakes to comply with the office objections based on the statement of objection. List of.
Interim order may be kindly extended, my lord.
Interim orders. 19th, my lord.
Nodi, date kodtare.
Because urgency is this, my lord. It's my fault. Urgency is this, my lord.
Date kodtare.
Please.
Yes.
Interim order may be kindly extended, my lord.
Kempraju Gopal Singh.
Appearing for the petitioner, my lord. My lord, 9.
For all 2, my lords, kindly it may be passed over. Sin is on the way.
Sir, pass over. You have to go on with the matter.
My lord, we've
He's on
sought
the
to
way.
quash, my lord, charge sheet for the offence under section 376 2N of IPC, my lord, and section 6 and 10 of POCSO Act, my lord. My lord, petitioner and the respondent number 2 are husband and wife, my lord. Married, my lord, it is an arranged marriage. My lord, date
For
of
the
birth-
husband and wife.
petitioner is the husband, R2 is the wife.
She is a minor.
She's a major, my lord. At the time of incident, she says she's minor, my lord. After that, they're married. After 6 years, she files a complaint. My lord, date of birth of the respondent number 2 is 10/7/2002. My lord, the engagement, my lord, was arranged, my lord, by the family members on 22/4/2015, my lord. Marriage, my lord, was on 10/2/2019. My lord, marriage was dissolved, my lord, on 5/8/2021. Date of birth is 10/7/2002, my lord. Engagement is on 22/4/2015. Marriage, my lord, was solemnized on 10/2/2019. Dissolved, my lord, on 5/8/2021.
By decree of
My lord, I will take my lordship to that, my lord. It is, my lord, the marriage, my lord, is held, my lord, according to the customs, my lord. They hail from Rajasthan, my lord.
dissolution of marriage.
Dissolution of marriage, my lord, is as per their traditions passed on by their
I will come, my lord. An OP is filed. OP petition is filed by the petitioner in OP number 577 of 21 before Family Court of Hyderabad seeking for annulment of marriage, my lord, which is filed by the petitioner. Subsequently, my lord, the wife files for a DV Act, my lord, in CMIS number 98 of 21. CMIS 98 of 21 on 17/9/2021 in Bangalore, my lord, before the Family Court, Bangalore. After which, my lord,
Seeking maintenance.
she sought for maintenance in CMIS 98 of 2021 on 17/9/2021, my lord. My lord, the father of the petitioner files, my lord, a criminal case against R2 and her father for the offence under section 420, 406, 120B on, my lord, 10/11/2021 in crime number 238 of 21 in Rajasthan.
Crime number?
On 10/11/2021.
Crime number?
Crime number 238 of 21, my lord, in Rajasthan. My lord, the present complaint, my lord, was filed on 5/3/2022. The present complaint where we sought for quashment is filed on 5/3/2022, my lord. I'll take my lordship to the complaint, my
What are
lord.
the offence now?
Offence, my lord, are 376(2)(n) of IPC and section 6 and 10 of POCSO Act, my lord. I'll take my lordship to the complaint, my lord, which is in page number 15. FIR is in 15, complaint is in 19, my lord. Charge sheet is also filed, my lord. Page number 15 is the OP petition 577 of 21 is transferred to Bangalore court, my lord. It is no longer pending in Hyderabad. May I take my lordship to complaint, my lord?
Yes.
Page number 19, my lord. The complaint, my lord, is registered on 5/3/2022. FIR is in 15, 19 is the complaint, my lord. May I, my lord?
Yes.
I am the third daughter of my parents, Shri Chinmaram and Srimati Kanya Devi. I am born on 10/7/2000, and I have done my second year PUC from CBIB.
10/7/2000.
Please, my lord, 10/7/2000. She's date of birth is 10/7/2000, my lord.
1 minute, 1 minute.
10/7/2000, my lord. Engagement 22/4/2015. Marriage 10/2/2019 after attending majority. Marriage, my lord, dissolved as per their community rules, my lord, is on 15/8/2021. OP petition 21 ನಲ್ಲಿ, my lord. ಆಮೇಲೆ DV petition is filed on 17/9/2021. A criminal case against R2 is registered on 10/11/2021.
Criminal miscellaneous 98 of 2021.
Please, my lord.
It is under DV Act or under 125?
It is DV Act.
DV Act. Maintenance.
Maintenance, my lord.
There is
See,
no other allegation.
no, my lord.
Yes.
Please. Present complaint registered on 5/3/2022, my lord.
Yes.
Please. Page number 19, my lord, is the complaint.
Yes.
Third line, Ali, my lord. I have two elder sisters named Durga and Hema. An alliance for marriage was found for me in the year 2015. When my age was about 15 years, offered by the family of Shri Manjilal. My elder sister Durga was aligned with Shri Sujan Ram and Srimat and Miss Hema with Mr. Jagdish. One of the offer of alliance from Miss Mangilal, my marriage was fixed with Nirmal Soil. That is a petitioner, my lord. Then aged about 23 years. My father is a
The
business.
sole accused?
Please, my lord, is the sole accused. Petitioner is sole accused, my lord. An engagement ceremony. My father is a businessman and he has a business in the name of Navrang Silk Creation and Jumma Masjid Road, Bangalore. An engagement ceremony was held on 22/4/2015 for myself and Nirmal Soil, son of Mangilal. Nirmal Soil was said to be an educated person and a businessman having business in jewelry and pawn brokering in the city of Hyderabad. We are from Sirvi community, and as per our customs and practice, an engagement ceremony is performed and the girl is sent after her attending majority to the marital home. Under a ceremonial ritual conducted as is practiced in the community on 10/2/2019, the ceremony of sending off was organized and held at Sri Prasanna Gangadhara Swami Temple opposite Dharamasraya Swami Temple, Nagaratpet, Bangalore. And I was sent with customary gifts completing the rituals. In between the engagement, which was held on 22/4/2015, and the sending of ceremony 10/2/2019, Nirmal Soil, with whom I was married to, had visited Bangalore plenty of times. Very soon after the engagement, he began to reach out contacting me because I was minor and of tender age. I had no mobile phone of my own.
Yes.
My mother had a mobile phone bearing number so and so. Nirmal Soil used to make calls on my mother's mobile phone and would speak to me. He would insist upon meeting me personally. I had told him about the restrictions in the house, but he used to make frequent calls and please me. I had my birthday on 10/7/2015. I was studying 10th at that point of time. Few days after the birthday, Nirmal had come to Bangalore and called me on the mobile phone and asked me to meet outside. I insisted upon meeting in my house. He did come to the house and celebrated the birthday with the family members. Thereafter, he asked me to go out, and we had been to amusement centers, restaurants, and malls. He took me to a cinema theater in the city market located and exploited me in the dark. We were alone much of the times, and whenever he had the chance, he exploited me sexually. Though I resisted because of his pleasing words, I could not prevent him from exploiting me. Thereafter, he returned to Hyderabad, and whenever he could call, thereafter would demand sexual favors, and his talks dominated explicit ones. He even invited me to come over to Hyderabad and told that he will arrange airway tickets to and fro and would arrange a hotel room for me. I was surprised by his boldness and told it is not possible. Days passed by and he kept calling me and repeating his demands whenever he would find it right. On 14/1, that is the first alleged date of sexual assault, my lord. On 14/1/2016, he again came to Bangalore. He told that his arrival is secret and not known to his parents coming to Bangalore. He altered in his sister's house at Cottonpet, Bangalore. My house was at Ganigari Lane, Bangalore. I was taken to Cottonpet, his sister Sangan's house at about 4 p.m. No other person was at that house. Till about 8 p.m., Nirmal Soil and myself were in the house, and during that time, he had forcible sex with me. It was an unexpected assault. Thereafter, I could do nothing. He told me not to tell anyone about the meeting, and at about 9 p.m. he brought me back to my house and left. On that day, he had sex thrice, and it was painful night for me. In the month of March 2016, I and myself had attended the post-death ritual ceremony in the house of Nirmal Soil. As there was a death in his native place at the village Wopari district, Pali state, Rajasthan, we had to stay for 2 days in that house, and there Nirmal Soil again had sex with me. Having had twice sexual assault, he was free, and whenever he would make a call and ask for sexual pleasure. Many a times Nirmal Soil had sex with me, and whenever he would visit Bangalore, had sex with against my wish. Time passed by. And on 10/7/2018, I attended majority, and the parents of either side finalized the completion of marriage formalities. And on 10/2/2019, I was sent under a ceremony that was arranged at Sri Prasanna Gangadhara Swami Temple opposite so and so, Bangalore. Nirmal Soil after marriage completion after marriage completion ceremony on 10/2/2019 had changed a lot. His behavior was now rude and exploitative. I was treated worthless. He began to say that he has liking for another girl named Nirmala. He began to ignore me and praise Nirmala whenever he would find an opportunity. I was annoyed by his behavior and told my parents about the happenings. Thereafter, I was driven out of the house for having protested his offensive acts. Retaliating to it, Nirmal Sohan had got married to his liked girl Nirmala on 22/7/2021 and has posted the photographs on the social media website and circulated to me too. Beforehand, a panchayat was arranged and there too Nirmal had disowned me. Because he has money power, he is influencing the community persons, the panchayats and everyone where from I can get help. Finally, I had to take legal advice, and when I had narrated my happenings, I was told that I am a victim of sexual assault and that I have had sex with him when I was a minor, and that the act of Nirmal Soil are criminal ones. Exercising my rights, I had reported the happening and the act of sexual assault, which are offences punishable in a section under the POCSO Act, to the authorities whenever I can find justice from, and I am told that the aggregative penetrative act was acted in the jurisdiction of the Kabanpet police station. Hence, I am advised to report the complaint to the police station. Please do needful. Is the complaint, my lord? My lord, investigation is completed. Charge sheet is filed, my lord. In the complaint, my lord, she makes an allegation that, my lord, Nirmal, the petitioner, my lord, was married to a Nirmala. Since, my lord, no materials were forthcoming while filing of charge sheet, offence under section 494 was not invoked, my lord. In the entire charge sheet, my lord, there is no materials to show that, my lord, that the petitioner was married to one Miss Nirmala, my lord. Now, my lord, charge sheet allegations, column number 17, my lord, are in page number 26.
Page number.
Column number 17 of the charge sheet, 26 ಅಲ್ಲಿ ಸ್ವಾಮಿ. ಈ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಅಂಕಣ ನಂಬರ್ 3ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ ಮತ್ತು ಸಾಕ್ಷಿ 1ರವರು ಪತಿ ಪತ್ನಿಯಾಗಿದ್ದು, ಸಾಕ್ಷಿ 1ರವರಿಗೆ ದಿನಾಂಕ 22/4/2015 ಆರೋಪಿಯೊಂದಿಗೆ ನಿಶ್ಚಿತಾರ್ಥವಾಗಿದ್ದು, ಸಾಕ್ಷಿ 2-3ರವರು ಸಾಕ್ಷಿ 1ರವರು ಪ್ರೌಢಾವಸ್ಥೆಗೆ ಬಂದ ನಂತರ ತಮ್ಮ ಸಂಪ್ರದಾಯದಂತೆ ಆರೋಪಿಯೊಂದಿಗೆ ದಿನಾಂಕ 10/2/2019 ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ 1ರವರು ಜನ್ಮ ದಿನಾಂಕ 10/7/2000 ಆಗಿದ್ದು, ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಆರೋಪಿಯೊಂದಿಗೆ ದಿನಾಂಕ 22/4/2015 ನಿಶ್ಚಿತಾರ್ಥವಾದಾಗ 15 ವರ್ಷಗಳಾಗಿದ್ದು, ಅಪ್ರಾಪ್ತ ವಯಸ್ಥಳಾಗಿರುತ್ತಾರೆ. ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1ರವರು ಅಪ್ರಾಪ್ತ ವಯಸ್ಥರೆಂದು ತಿಳಿದಿದ್ದರೂ ಸಹ ದಿನಾಂಕ 10/7/2015 ಸಾಕ್ಷಿ 1ರವರ ಜನ್ಮ ದಿನದಂದು ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1ರವರನ್ನು ಸಿಟಿ ಮಾರ್ಕೆಟ್ ಬಳಿ ಅಪ್ಸರಾ ಥಿಯೇಟರ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಕತ್ತಲೆಯಲ್ಲಿ ಸಾಕ್ಷಿ 1ರವರ ಖಾಸಗಿ ಅಂಗಾಂಗಗಳನ್ನು ಮುಟ್ಟಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವೆಸಗಿರುತ್ತಾನೆ. ದಿನಾಂಕ 14/1/2016 ಸಂಜೆ ಸುಮಾರು 4 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ತನ್ನ ಅಕ್ಕ ಸಾಕ್ಷಿ 12ರವರನ್ನು ಪರಿಚಯ ಮಾಡಿಸುವುದಾಗಿ ಹೇಳಿ ಕಾಟನ್ಪೇಟೆ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ ಸುಬ್ರಹ್ಮಣ್ಯ ಲೇಔಟ್ ಮನೆ ನಂಬರ್ 6 1ನೇ ಮಹಡಿಯ ಮನೆಗೆ ಯಾರೂ ಇಲ್ಲದ ಸಮಯ ನೋಡಿಕೊಂಡು ಸಾಕ್ಷಿ 1ರವರನ್ನು ಕರೆದುಕೊಂಡು ಬಂದು ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1ರವರ ಇಚ್ಛೆಯ ವಿರುದ್ಧವಾಗಿ 3 ಬಾರಿ ಬಲವಂತವಾಗಿ ಸಂಭೋಗ ಮಾಡಿರುತ್ತಾನೆ. ನಂತರ 2016ನೇ ಸಾಲಿನ ಮಾರ್ಚ್ ತಿಂಗಳಿನಲ್ಲಿ ಆರೋಪಿರವರ ತಾತನವರು ಮೃತಪಟ್ಟಿದ್ದು, ಈ ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿ 1ರವರು ಸಾಕ್ಷಿ 2-3 ಹಾಗೂ ಆರೋಪಿಯೊಂದಿಗೆ ರಾಜಸ್ಥಾನದ ಪಾಲಿ ಜಿಲ್ಲೆ ಸೋನ್ಸೋ ಗ್ರಾಮದ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗಿ 2 ದಿನ ಅಲ್ಲಿಯೇ ತಂಗಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಸಾಕ್ಷಿ 1ರವರನ್ನು 2 ಬಾರಿ ಬಲವಂತವಾಗಿ ಸಂಭೋಗ ಮಾಡಿರುತ್ತಾರೆ. ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1ರವರು ಅಪ್ರಾಪ್ತ ವಯಸ್ಸವಳೆಂದು ತಿಳಿದಿದ್ದರೂ ಸಹ ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಖಾಸಗಿ ಅಂಗಗಳನ್ನು ಮುಟ್ಟಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವೆಸಗಿ ಸಾಕ್ಷಿ 1ರವರ ಇಚ್ಛೆಗೆ ವಿರುದ್ಧವಾಗಿ ಹಲವಾರು ಬಾರಿ ಅತ್ಯಾಚಾರವೆಸಗಿ ಮೇಲ್ಕಂಡ ಕಾಲಂ ಸೋ ಅಂಡ್ ಸೋ ಇಸ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲಿಗೇಷನ್.
Yes.
My lord, may I take my lordship to page number 104, my lord? On my lord, 15 typed copy of Hindi in the Swami. Typed copy is in page number 105. On 15/8/2020, 105. 104 is the actual copy, my lord. Translated copy is in 105.
What is this?
My lord, on 15/8/2021, my lord, the respond number 2, I am Radha, daughter of so and so, belong to so and so. My marriage was with Nirmal, who was resident of.
What is this?
My lord, this is a letter, my lord, where she, my lord, in front of the members, my lord, of the village, about 15 elders, my lord, she undertakes, my lord, saying that marriage is dissolved. She says that, my lord, we both willingly consent to divorce, dissolve a relationship in the presence of local leaders. Hence, I, Radha, who voluntarily signed that I will never go to sue our marital dispute before any other court with any law. If I do, I will become guilty before my family society. My lord, page number 106 in the 200 Tanka, my lord, is the letter, my lord, the affidavit. Page number 106, my lord. Translated copy, my lord, is in page number 109. 15 local leaders, my lord, of the society, my lord, as per the tradition passed on, my lord, in their, my lord, community in Rajasthan, they, my lord, had panchayat, my lord. May I read, my lord? All the affidavits, my lord, are same. I will read one translated copy, my lord, page number 109. I solemnly declare that the truth that I, so and so, age 73 years, caste Sirvi, resident of Upari, Tahsil, Marwar Junction, I am resident of district
Who is
Pali.
she? Who is it?
My lord, he is one of the, my lord, the resident of the native and, my lord, member of the local leader and member of the panchayat, my lord. My lord, when such incidents takes place, my lord, in Rajasthan, in their community, they, my lord, first go to their local leaders, my lord, they sit down and try to dissolve the issue. When, my lord, he, my lord, has in detail spoken about it, my lord. I'll just read one affidavit where one of the leaders have spoken. All the rest, my lord, are the same. I solemnly declare that I, so and so, caste so and so, resident and so. Third para, my lord, I declare that the truth that marriage of Nirmal was completed as per Hindu customs to Radha in village so and so is when a bride, my lord, Mukhwala, is when a bride goes to her in-laws home after marriage. Second ceremonial visit of bride to her in-laws after marriage was done on 10/2/2019, which is after attending majority, my lord, in which I also participated, happened. I also solemnly declared the truth that after Mukhwala, Radha came to her in-laws house, only Manjilal, my lord, father of the petitioner, and his family members tried his best to bring his daughter-in-law Radha to his in-laws house, but Chinma and Radha also kept on giving only assurance of sending Radha to her in-laws house after completion of her studies. Then after getting tired and exhausted, Manjilal told his grief to me and important people of society. I also solemnly declared the truth that Manjilal Ji's on repeated request, I and important people of the society asked Chinmaram Ji about relationship. Chimnaram Ji decided to answer the people of the society at the social level and fixed the date on 15/8/2021 at a social place, Vader Temple in village Sinchana. On verbal request of Chinmaramji, I and important people of the society gathered, and on being asked, Chinmaramji and his daughter Radha clearly expressed their inability to maintain this relationship. Then the important people of the society divorced both the parties with consent by upholding the tradition passed on from generation social custom, Chindi Deka Talak, and also took the divorce in writing and with the consent of both the parties. On 15/8/2021, both the families ended the marital relationship in the presence of important people of the society. From page number 106 to 200, my lord.
How many panchayatdars?
15, my lord. 15 panchayatdars.
Yes.
My lord, may I pass on the additional documents of my lord filing the DV petition, my lord, which is filed before Bangalore, is in page number 5, my lord. Page number
Pending.
It is pending. Page number 5, only, my lord. On 17/9/2021, criminal miss 98 of 21. A petition came to be filed in Bangalore, my lord.
Yes.
Petitioner, my lord, is A1, and rest, my lord, the family members, there are in all 6 parties. Page number 6 is for me. R2, Radha, and my lord, respondents are Nirmal Soil and
Then-
family members. Please, my lord. My lord, if I may take my lordship, my lord, to page number 95. 95, my lord. My lord, on dated 10/11/2021.
Yes.
Father of the petitioner, my lord, files a complaint, my lord, against respond number 2 and her father for the offense under section 420, 406, 120B of IPC
Yes.
before Rajasthan Police, my lord, in crime number 238 of 21, page number 95, my lord. Translated copy, my lord, of the complaint, my lord, is in the additional document which I just gave before my lordship.
Yes.
Page number 1 ಅಲ್ಲಿ ಅಲ್ಲ ಈ ಹೊಸ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟೆ ಮಲೋಡ್ ಅದ್ರ 1 ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಕಾಪಿ ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಓದ್ತೀನಿ ಅದು
ಏಪ್ಪ ಇದು
ಅಲ್ಲ,
gist ಇದೆ
ಅದು-
ಇದ್ರಲ್ಲಿ 101, 102.
ಅದ್ರಲ್ಲಿ ಸರಿ ಇಲ್ಲ ಮಲೋಡ್ ಅದು ಇಟ್ಸ್ ನಾಟ್ ಪ್ರಾಪರ್. I, Mangilal, son of Sri Narayan Lal Caste Sirvi. The neatly done translated copy is in page number 1 of the additional document. I, Manjilal, son of Narayan Lal Caste Sirvi. I'm a native of Beda.
You are reading, it runs into several pages.
Please, my lord, I just want to take my lordship to the important points to show my lordship that, my lord, during my lord dissolution of marriage as per their customs followed down, they, my lord, are undertook, my lord, to exchange jewelries, my lord. In the complaint that the father-in-law gives against respond number 2, he detailedly narrates the fact that, my lord, the undertake, my lord, saying that they will return back the jewelry. We had returned back the jewelry that we had with them. They undertook and
Whether in the petition in criminal miscellaneous 98 of 2021,
Please.
or in the complaint in crime number 238 of 2021,
Please.
is there any allegation regarding this
not
sexual harassment?
Not at all, my lord. Nowhere in the documents, my lord, not one allegation show that such incident has happened. Subsequently, after 6 years, my lord, after filing these many petitions, the respond number 2, my lord, goes before the police and says that incident took place. She even clearly narrates the fact that, my lord, she took legal advice and it was brought to her knowledge, my lord, to say that such act falls under POCSO Act. In the entire charge sheet, my lord, no documents nor medical to show that, my lord, or any supporting materials to show that, my lord, such incident had taken place, my lord. No documents, even in a petition, nor in the complaint, or in the, all the documents, nowhere, my lord, they've stated. After these many complaints, the present complaint is registered, my lord. Annulment of marriage is still pending. DV petition is pending before the court. All the petitions are pending, my lord. Crime number 238 of 21 is still pending, my lord, in the Rajasthan court. May I take my lordship to section 198 clause 6 of CRPC, my lord? (198) clause 6, my lord. Prosecution for offences against marriage. 6 is, Swami. No court shall take cognizance of an offence. 198 of 6, my lord. No,
Yes,
no court shall take cognizance of an offence under section 376 of IPC where such offence consists of sexual intercourse by a man with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from the date of commencement of offence. In the present case, my lord, there is delay of 6 years, my lord, of filing the complaint. And delay also, my lord, nowhere explained in the entire complaint, my lord.
yes.
Please, in the complaint that the father-in-law has registered, that is the father of petition number 1, he clearly, my lord, narrates to the fact that very next day of the marriage, my lord, respondent number 2 went to her parents' house. Several attempts were made to bring her back. Even on spite of several requests, my lord, she did not come back to marital home, my lord. Detailed, my lord, complaint is there. If I may be permitted, I'll read. If not, my lord, complaintally, typed copy of the complaint. 6, para number 6 in the, my lord. I'll be little quick, my lord. It is stated that I told the people of my community, residents of Bangalore, about the problem of not sending Radha. Then in the month of April 2000, my brother, Kularam, resident of Hyderabad, along with the treasurer of Girji community, Shri Sujaramji, and my friend so-and-so, resident of Bangalore, went to Chimnaramji's house to bring the daughter-in-law. But Chimnaramji neither talked to us properly nor called us to the house, but asked us to come to his shop. When we went to his shop, the people of the community and I requested him to send my daughter-in-law Radha to her in-laws' house. Then Chimnaramji refused to send her daughter-in-law and said that my daughter does not want to keep this relationship anymore. Do not ever come to our house to take her in future. It is that after in May 2002, Chimnaramji went to Bangalore again in a private vehicle with his elder brother Shri so-and-so to bring his daughter-in-law. On seeing us, Chimnaramji became furious and said that despite repeated warning, you are not ashamed of...
Yes, where is the final report? Only the page number?
Rashid, my lord, 26, my lord, page number 26. Column number 17 is in page number 26.
Who are these witnesses?
My lord, witnesses, my lord, is British respondent number 2 and my lord, her relatives. There are 21 witnesses, my lord. She, my lord, is the resident of Bangalore. Illi our relatives, but the rest are official witnesses, my lord.
What is the medical evidence?
Medical evidence, my lord, I'll take my lordship, my lord, to the medical, which is in page number 58. It says that, my lord, from history and examination of Miss Radha, I am of the opinion that she is used to an act like that of sexual intercourse, and hence there is no evidence of recent sexual activity.
And what is this CW18 FSL?
My lord, FSL report, my lord, they've sent, my lord, in so far as the page number 62, my lord, FSL, my lord, in so far as the petitioner's outfits and the clothes of the respondent number 2, my lord.
Any report?
No, my lord, no such study certificate is produced to prove her age, and then medical, my lord, FSL
Yes.
is in.
Yes, what is it?
Yes, my lord. For the respondent number 2, my lord. Lord, the submission of the learned counsel for the petitioner was wrong, that she has not stated anything regarding the assault in the application she has filed under the Protection of Women under Domestic Violence Act, my lord. On September 9, 2021, she files a domestic violence petition before the Honorable Magistrate. She explains all the events and the facts which has been stated in this complaint, my lord, are completely there in that petition, my lord.
Only the petition copy is
I'll produce, my lord.
not produced.
Not produced.
Bidding. Next.
Then she has reported the complaint first to the City Market Police Station, where she was first assaulted in a theatre, my lord. That falls within the jurisdiction of the City Market Police Station. And that was 6 months back before the filing of this complaint, my lord. The police had taken
Meeting of this respondent number 2 with the petitioner was known to her family members.
once, my lord, the day when he had come for the birthday celebration in the house, my lord. So that was the 16th birthday of the girl.
On the same day, according to
Had taken.
respondent number 2, there was sexual harassment.
She was taken to a cinema hall.
The consent of parents, they
No,
gone.
she was not told to the house, my lord,
Why?
because it was an engagement with the respondent
So
petitioner.
it is a consent.
Consent of the parents.
Huh?
No,
It
the
was
girl-
known to the parents.
Might
They
be-
allowed them to go out.
uh,
They have gone to the cinema, not to any room and all
but
that.
sending to cinema is not that authorizing that he can do
Of
anything.
course, then in Rajasthan, she had gone along with her parents.
That was the death ceremony of
Maybe
in the house
she-
of
She had not gone there alone.
with the father.
Yes, with the father, she had
Yes,
gone there.
but ladies will be
And
in the
even then, there is no
no, my lord.
allegation.
There, ladies will be in the ladies' compartment or houses.
Hmm.
Gents will be in the gents' lord.
Definitely, he will
Because-
not be allowed to
because-
enter that.
bec- Pardon?
Petitioner will not be permitted to enter.
Because it was in their house, my lord. In the petitioner's house, the death had happened, and they had gone to the petitioner's
Why
house and petitioner's
respondent-
village.
Why respondent number 2 has not complained?
My lord, that is what she had explained in the complaint, my lord, that because she was about to go to.
So she again
She was,
consented. for
once
that.
she was of the tender age, she was just studied 10, my lord, at that point of time, and she was about to get married to the petitioner. Therefore, she kept quiet. And when their legal actions followed in the year 2021, my lord, and she had
Why
discussed.
6 years? After
No, no.
6 years, you suddenly thought of making all
No,
sorts of.
that was when
allegations?
the relations strained because the petitioner
Yes,
had
that is
contacted.
what.
Yes, my lord, the petitioner had contacted a second marriage with a girl named Nirmala. He had posted the photographs. The posted are in the charge sheet also, my lord, that this person has a contact with the.
You take action for second marriage.
That is
not
there, my
for
lord.
other. You cannot make such allegations, sir.
No, it's
There must be some basis.
because she was driven out, my lord.
Yes, maybe.
She was driven out.
You take necessary legal action for driving you out.
It is
For
there.
the petitioner marrying for the second time.
Yes, my
But
lord.
not
No,
making
I,
such allegations.
I'm just narrating the incidents that had taken place. The complainant, that is the respondent number 2, was driven out of the house. There were actions against her because she should not go to the police and she should not report the complaint because there is a domination of the male there. You know, they had taken the binding that she will not give any complaints at all. They knew that there may be police complaints against the petitioner. Therefore, these people who had been assembled there, they had taken the bindings that we will give back your jewels.
So respondent number 2 has not informed any of these incidents either to her father or even to her mother.
As per the statement,
filing of the complaint.
as per the statement, my lord, after the incident, it has been told, my lord,
Told to
parent, mother, Kanya Devi.
mother.
Yes,
Whether she has told her to her husband,
that
whether there is any allegation in the complaint that was filed in Rajasthan.
no, complaint was filed by the petitioner, my lord.
No, before that.
No,
There
no
was another
complaint. No-
complaint by the father
No, my lord. No.
with Rajasthan police.
Because these people were taken to police station, they were intimidated, my lord, that they will not take.
Very weak case, sir.
Lord, this is that engagement is not doubted. Meeting by the petitioner with the respondent number 2 is not denied.
Yes.
Even in the DV Act cross-examination, he has admitted that he had come.
Correct.
He had been to the cinema halls. He had been to the sister's house, which was alone, and nobody was there within the limits of the Cottonpet police station. Immediately, when there were legal actions, my lord, taken and against each other, she had reported the matter, my lord. She had reported the matter to the City Market police station. She had
After
reported.
6 years.
Yes, it is
After
there.
6 years.
Obviously, it is there, my lord. But
When the relationship is strained.
but when she came to know that yes, there is an assault on her and that falls under an offense, my lord, she has reported the complaint, my lord.
No.
There are many instances, my lord, that when she was a minor, aged 15 years and odd,
That is why I allowed her to read the entire complaint.
yes, she has
Otherwise,
explained.
I would not have permitted her
I understand, my lord.
to know
But
the conduct of the parties.
here the victim girl has explained her ordeal, what she has gone through, my lord.
In the charge sheet, what is the material? Except your oral testimony.
There are, my lord, the visits to the places of incident where has
May
been made.
visit, sir. Admittedly, you are engaged to him. Your marriage was fixed.
But engagement
You
is-
later married her.
Engagement is not marriage, my lord.
I understand. I
Yes,
know
ma'am.
that.
Yes,
It is not a new thing.
yes, ma'am, sorry.
Ah,
But no, what the explanation was given that because she was going to
But
marry.
is there so unnatural to visit to Bangalore after engagement?
Yeah,
If they, see, we are concerned about the incident, now we
no,
are
it
alleging.
did not happen, my lord. That was that he.
My only question, what made the respondent number 2 not informing her mother, her father, and why the parents have not taken any action, at least,
They are from,
if not the girl?
my lord, they are from rustic community, my lord.
Oh,
And further, my lord, this person, the petitioner, he is a master's graduate, my lord. He was 25 years of age at that point of time.
what is your educational qualification?
12, my lord.
Hmm.
So at that point of time, she was just 10th, my lord, studying in a girls' college, girls' school, my lord.
Yes. Have you produced the criminal petition in criminal miscellaneous?
Please, my lord, I have.
Yeah.
ಈಗ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ, criminal miss ಕೊಟ್ಟಿಲ್ಲ.
ಇದು ಡಿವಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಕ್ರಿಮಿನಲ್ ಮಿಸ್ ಪಿಟಿಷನ್.
ಅದೇ.
ಅದು ಪೇಜ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಇದೆ. ಯಾವತ್ತು ಫೈಲ್ ಆಗಿತ್ತು ಅಂತ ಕೊಟ್ಟಿನಿ my lord. To show that prior to this she files DV. Subsequently, my lord,
I'll produce it.
I've
Not
produced.
necessary. Yes.
My lord, it clearly shows to the fact that, my lord, it is abuse of process
Yes.
of law.
My lord, as per SSLC mass card, at the time of incident,
There is no dispute with regard to the age.
my lord, 164
Investigating officer,
delay is there, my
accept
lord.
the statement of the victim. What
And-
is the incriminating material?
And CW4 one Dinesh Bandari, my lord, victim relative, and CW5 friend of
Family
victim.
members, all the relatives of the victim.
Yes, ma'am.
Medical records are not there. That
Ye-
cannot
yes.
be because they were married subsequently.
In page number 59, the I-man is absent.
She was married admittedly. She led the marital life.
ಅಲ್ಲ ಒಂದೇ ಒಂದ್ಸರಿ ಬಂದಿರೋದಂತ ಪಂಚ
ಅದೇ ಸಲ ಬರ್ಲಿ sir.
ಪಂಚ್ ಸ್ಟೇಟೆಡ್
The wife of the petitioner.
ಬಟ್ ಪಂಚ್ ಸ್ಟೇಟೆಡ್ ಓನ್ಲಿ ಒನ್ಸ್ ಬಂದಿದ್ದಾರೆ ಇದಕ್ಕೆ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಹೌಸ್ಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಐ-ಮ್ಯಾನ್ ಇಸ್ as per medical record, I-man is absent.
Yes.
And my lord,
That will not help you in any manner. When admittedly they were married in the year 2019.
yes, my lord.
Complaint is in the year 22.
Yes, my lord. Trace,
Absence of hymen, how will
Peer and
will
trace-
inure to your benefit?
my lord, peer and trace.
Hmm?
She may not be told. ಅಂದ್ರೆ ಮರ್ಯಾದೆಗೆ
Yes.
ಮ್ಯಾರೇಜ್ ಆಗ್ತಿದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು ಇದು ಹೇಳಿಲ್ಲ. ಆಮೇಲೆ ಅಜಾಲ್ಟು ಅದು ಇದು ಬಂದ್ಮೇಲೆ ಆಮೇಲೆ ಎಲ್ಲ ಸ್ಟೋರಿನೂ ಹೇಳಿದ್ರು.
ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಾನು ಕನ್ಸೆಂಟಿಂಗ್ ಆಕ್ಟ್ ಅಂತ. Now since the relationship is strained, file every complaint, make allegation. What is there?
No, they are saying that the marriage is dissolved, my lord. Repeatedly they are saying, but it is not, my lord.
Yeah, may not be. I told her.
And they contacted.
Because there is a decree
No, the
for
petitioner has
dissolution,
contacted
it
the
is
second
not.
marriage because he had a liking for another
But
girl.
definitely there was strained relationship.
Because
Relationship was already strained. It is only thereafter the allegations came.
the girl did not wanted the marriage to end, my lord,
Correct.
but she was driven out forcefully, and then there was a second marriage for this.
Take necessary actions, not making allegations under POCSO.
I have said this in the DV Act petition, my lord. Everything is said, my lord.
Petitioner being the accused. In a special case number 868 of 2022, pending on the file of the learned additional city civil and sessions judge FTSA2 Bengaluru for offence punishable under section 376(2)(n of IPC and under section 6 and 10 of POCSO Act is seeking to quash the criminal proceedings initiated against him. Heard so and so, affirmative for the following reasons. The admitted facts of the case are that respondent number 2 was born on 10/7/2000. She was engaged to the petitioner on 22/4/2015 when she was aged 15 years. The marriage of the petitioner with respondent number 2 was performed on 10/2/2019 after respondent number 2 attaining the age of majority. Next, it is the contention of the petitioner that the relationship between the petitioner and respondent number 2 was strained, and there was dissolution of marriage as per customs prevailing in the community in the presence of the Panchas on 5/8/2021. It is also the contention of the petitioner that respondent number 2 has filed criminal miscellaneous case 98 of 2021 on 17/9/2021 seeking maintenance under the provisions of DV Act from the petitioner and also making allegations against 5 other family members. It is also the contention of the petitioner that the father of respondent number 2 filed a police complaint registered in crime number 238 of 2021 of Rajasthan Police Station, alleging commission of the offence punishable under section 420, 406, 120B of IPC against the petitioner.
Against the respondent number 2.
Hmm?
That case is against the respondent number 2.
Petitioner father files against R2, my lord.
R2.
It is us who files complaints against her.
ನಿಮಿಷ ಅದೇನು ಬಂತು? ಓದಿ. ಅಲ್ಲ, filed by ಯಾರು? By father of petitioner. Against
Respond number 2 and her father, my lord.
respondent number 2 and her father alleging commission of the offence punishable under section 420, 406, 120B, ಅದು on 10/11/2021.
This was after the filing of the DV Act.
Hmm?
That
ಅದು-
ಅಲ್ಲ
ಅದಕ್ಕೆ
9/9/21 ಅಲ್ಲಿ DV Act ಫೈಲ್ ಮಾಡ್ತಾರೆ.
17/9 DV Act 10/11
DV Act ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಎಲ್ಲವೂ ಇದೆ, ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಇದೆ. ಹಾಗಾಗಿ ಅವ್ರು ಕೌಂಟರ್ ಮಾಡೋದಕ್ಕೆ ಅದು ಫೈಲ್ ಮಾಡ್ತಾರೆ.
It is after all these incidents on 5/3/2022 the present complaint was filed by respondent number 2 against the petitioner, which is registered in crime number 27 of 2022.
May I make one submission?
Cottonpate.
My lord, 6 months before this
Which
complaint.
police station?
Cottonpate
Cottonpate.
police station.
Cottonpate Police Station for the offence under section 376(2)(n) of IPC and under section 6 and 10 of POCSO Act. Now the investigation is complete and the final report came to be filed for the aforesaid
ಅವ್ರ
offence.
jurisdiction is illegal.
Petitioner is before this court.
May I make one submission?
aggrieved by initiation of criminal proceedings. Yes.
6 months before this registration of the case, my lord, she had reported the first complaint to the City Market Police Station, my lord. That was in the month of September 2021, my lord. On the point of jurisdiction, they kept it open, my lord. They did not take action, and they had just making for a settlement, my lord. Then on the point of jurisdiction, they said that this offence has taken place in the Cottonpate jurisdiction, my lord. Therefore, she was advised to go to the Cottonpate police station to lodge the complaint, my lord. And before that, she has filed a private complaint also, my lord.
When the first complaint was filed.
This was 6 months before this complaint, my lord.
No such document or statements are stated in the complaint, my lord.
There
No
are, my lord.
materials, my lord.
There are, my lord.
Charge sheet allu ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ,
And the first
complaint
time
ಅಲ್ಲೂ
she has
ಹೇಳಿಲ್ಲ.
disclosed it in the month of September, my lord. After that, the actions against these people followed, my lord. And the police also did not take action because they wanted a settlement, my lord.
In private complaint
ಹಾಕಿದ್ದಾರೆ.
PCR number.
Complaint ಅಲ್ಲಿ charge sheet ಅಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಅದ್ರ ಬಗ್ಗೆ. No such document is even marked in the entire charge sheet. If so, really it had
92 days of time be given, my lord. I'll produce everything, my lord.
entire charge sheet I have produced before my lordship, my lord.
There was a private complaint, my lord. Then there was a complaint to the City Market Police, and then there was to the women cell, my lord.
The materials on record disclose that even though the marriage, even materials on record disclose that the engagement of respondent number 2 with the petitioner was performed on 22/4/2015. As per the allegations made by respondent number 2 in the first information, the petitioner had came to Bengaluru petitioner had came to Bengaluru on 14/1/2016, took her to a movie and committed sexual harassment inside the cinema theater. It is her further contention that during March 2016, she had gone to Rajasthan along with her father. And twice the petitioner has committed penetrative sexual assault. Assault. With these allegations, the respondent number 2 filed the first information alleging commission of the offences as stated above. After these incidents, the petitioner had married respondent number 2 on 10/2/2019, and they had led the marital life quite for some time. Even though it is stated that the marriage is dissolved on 5/8/2021, there is no decree of dissolution of marriage passed by a court having jurisdiction. However, the fact remains that since then, respondent number 2 and the petitioner are not residing together. Next one. Even though the counsel for the respondent number 2 contends that the petitioner had even though learned counsel for respondent number 2 contends that there is allegation regarding this sexual harassment in the criminal miscellaneous petition 98 of 2021 filed on 17/9/2021 under the provisions of DB Act, no scrap of paper is produced before this court to substantiate the same. The first information filed by respondent number 2 discloses that she consulted her advocate along with family members, and as per the advice of the advocate, she has filed the first information alleging commission of the offence under POCSO Act. According to respondent number 2, the petitioner had married another girl by name Nirmala, which led to marital discard, and there was a relationship was strained between the petitioner and respondent number 2. It is only thereafter the present complaint was came to be filed, and in the meantime, more than 6 years have elapsed from the date of incident. Next part. When counsel for the petitioner has drawn the attention of the court to section 198(6) of CRPC, where there is a bar for a court to take cognizance of an offence under section 376 of IPC, where such offence consists of sexual harassment, sexual intercourse by a man with his own wife, and the wife being under the age of 18 years of age, in case more than 1 year has elapsed from the date of commission of the offence. Of course, in the present case, as per the allegations, as on the date of incident, respondent number 2 was not the wife of the petitioner. Their marriage was performed only after respondent number 2 attaining the age of majority. But since the first information was filed after long lapse of 6 years, I do not find any prima facie materials to accept the contention of the petitioner. After the relationship between the petitioner and respondent number 2 strained, after filing the petition under DB Act, the present complaint was came to be filed, and obviously it is at the advice of counsel or an advocate. Next part. The counsel for respondent number 2 contends that about 6 months prior to filing of the present complaint, another complaint was filed by respondent number 2, but the police have not registered the said complaint. He also contends that a private complaint was also filed by respondent number 2 making similar allegations. But unfortunately, there is no reference to any of these complaints, either in the first information or in the statement of respondent number 2 recorded under section 164 of CRPC, nor in the charge sheet filed by the investigating officer. Considering all these facts and circumstances, the only conclusion that I can arrive at is that since the relationship between respondent number 2 and the petitioner has strained for a period of after performing the marriage on 10/2/2019, as per the advice received by respondent number 2, is making allegations regarding the sexual harassment on 14/1/2016 and commission of penetrative sexual assault during March 2016 by filing the first information only on 5/3/2026. Even if the charge final report filed by the investigating officer is considered, only respondent number 2 and her family members and relatives are cited as witnesses. CW 17 is the medical officer of Vani Vilas Hospital, where respondent number 2 was examined. Even though it is stated that the hymen was absent, admittedly, respondent number 2 had married the petitioner on 10/2/2019, and for some time, both of them have led marital life. Therefore, even the said material is not helpful to the prosecution. It is not helpful to respondent number 2 to substantiate her contention. CW 18 is the forensic expert to whom the clothes of the petitioner was referred to. It is stated that the FSL report is not yet received. Even if the FSL report is received, in view of the relationship between the petitioner and respondent number 2, and they being led the marital life as husband and wife, I do not find any prima facie materials to constitute the offence as stated above. In view of the above, I am of the opinion that initiation and continuation of the criminal proceedings against the petitioner is an abuse of process of law, and hence the same is liable to be quashed accordingly. Yes, allowed.
Obliged.
Serial number 10, S. Satyanarayana Chalke, Gopal Gowda, K. N. Shashidhar.
My lord, in this case, I am appealing for the respondent number 2, my lord.
Yes.
Please.
Yes.
Please. Dispute, my lord, between the advocates. My lord, between the advocates. Lord, with regard to an incident, my lord, dated 23/6/2015, 23rd June 2015, at about 6 p.m. Lord, after the court hours, Lord, it appears that a quarrel. My voice itself is being. But a quarrel took place, my lord, between the petitioners
and respondents 2 to 4 on one hand.
Petitioners are accused numbers,
Petitioners are accused numbers 1, 2, 3.
only 3 accused.
Only 3 accused.
What are the offense alleged?
My lord, offences are under sections 323, 324, 506 and 34 of IPC. Lord, crime number 242 of 2015 of Alsurgate Police Station, Lord, came to be registered
Initially
on
only against accused numbers 1 and 2.
accused
and
numbers
15
1, 2
others.
and 3. My lord, initially it was only against accused numbers 1 and 2 that the complaint was filed. Lord, crime number 242 of 2015, Lord, registered on 24th June 2015, Lord, Alsurgate Police Station for the offences under sections 324, 506B and 149 of IPC. Lord, after the completion of investigation, Lord, the investigating agency submitted a B summary report. Lord, notice came to be issued to the first of informant, my lord, that is the second respondent herein. Lord, the second respondent, my lord, did not appear after receipt of the notice. And my lord, on 23/8/2016, my lord, the B report came to be accepted by the court. Sixteen.
16.
Please, my lord.
Date of complaint?
Your date of complaint is 24/6/2015.
On the next day.
No. 23/4/2015, my lord, the next year.
Date of incident 23/6.
23/6/15 is the date of incident.
On the next day.
On the next date, the FIR came to be registered.
Yes, on 31/12/16, the B report was accepted.
Accepted.
Then.
My lord, on 27/4/2017, my lord, the second respondent, my lord, filed his protest petition.
Yes.
Lord, subsequently, my lord, the case was reopened and now it was submitted, Lord, for further investigation. Lord, the second respondent, my lord, filed an application, Lord, stating that the B report may be accepted and that he had no further complaint against the petitioner.
Yavaga.
My lord, during the pendency of the investigation, of the
further
after referring it for further investigation.
Who respondent number 2?
Respondent number 2.
Yen madidru?
He filed an application, Lord, seeking acceptance of the B report. And that he is not interested in taking up investigation against the petitioner's hearing.
Yes.
Lord, this application came to be filed on 13th May 2018. And my lord, on 18th May 2018, my lord, making a note of the submissions made by the respondent number 2, my lord, the B report came to be accepted. And a direction was given to the first respondent police not to investigate into the matter.
Then.
But subsequently, my lord, the respondents 3 and 4, Lord, they filed a protest petition and an application seeking recall of the,
Who are they?
my lord, they are also victims. They claim to be injured in the incident.
Hmm.
Lord, they make an application that the B report was accepted without issuing notice to them, and that as they are injured in the matter, they are the interested party. Lord, what the learned magistrate does is that it recalls the order dated 18/5/2018 on 31/10/2018. And my lord, directs the first respondent police, my lord, to file their police report.
Yes.
My lord, a charge sheet came to be filed subsequently by the first respondent police.
For what offense?
My lord, offences under sections 323, 324, 506, and 34 of IPC. Lord, on 5/2/2019, Lord, cognizance is taken.
Yes.
Please. Now, my lord,
How many were injured?
my lord, 3 injured. The first informant and all, my lord, respondents 2 to 4.
Where is the wound certificate?
Lord, I have produced the charge sheet. ಚಾರ್ಜ್ ಶೀಟ್ ನೀನ್ ಹಾಕಿದ್ದಲ್ಲ ಶಶಿ, ನೀನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಹಾಕಿರ್ಲಿಲ್ಲ, ಫೈಲ್ ಹಾಕಿದೀವಿ.
Yes.
Lord, insofar as R2 is concerned, Lord, tenderness,
Early page number.
Lord, page 21, my lord. Mm.
21.
I'm sorry, my lord, it was, I don't think, ಇದೆಲ್ಲ, it is not in the
copy.
part of the subsequently.
Yes. Yes.
Lord, I'm sorry, I do not know, my lord, because there's no indication whether the entire charge sheet is submitted. It was not filed along with the petition, my lord. I'm sorry, my lord. I will produce it, my lord. Anyway, Lord, I don't think my learned friend is going to dispute with regard to that.
R2 is also injured.
R2, R3, and R4. All the 3 are injured. Lord, all the 3 wound certificates, my Lord.
3 or 4? 3.
3 wound certificates, my Lord. 2 to 4.
ಇದು ಯಾರ ಹೆಸರು? ರಾಮಪ್ಪ.
Ramappa is R2. Ramanappa.
ರಮಣಪ್ಪ.
Ramanappa is R2. Anand Murthy BG is R3. And Kumar Swami DS is R4. My lord, Lord, the grounds, my lord, that are urged by me is, my lord, once the magistrate, my lord, accepts a B report. Lord, whether, my lord, he could recall his own order. Doesn't he become functus officio? Lord, here not once, twice, my lord, the B report is accepted. So, my lord, had it been, Lord, because, my lord, law regarding, my lord, the filing of B reports, Lord, any number of judgments, my lord, by the Honorable Court as well as the Apex Court, stating that once a B report is filed, my lord, the course is open before the learned magistrate. Lord, one, my lord, accept the B report and close the case.
Yes.
Two, reject the B report and refer the matter for further investigation. Lord, three, reject the B report and, my lord, take cognizance as though it is a private complaint. Lord, once the learned magistrate, my lord, chooses the first option of accepting the B report, Lord, whether he could recall his own order, Lord, is the first submission.
Yes.
Lord, the second submission is, my lord, may kindly have a look at annexure F, my lord, the order dated 31/10/2018.
Yes.
Please. Lord, prior to that, my lord, may kindly have a look. Lord, the proceeding sheet at page 33, my lord, annexure D. Lord, on 31/12/2016, notice to complainant served,
Page
called
number-
out absent.
Page.
Page, my lord, 33, my lord, annexure D. The order dated 31/12/2016. Notice to complainant served, called out absent, hence B report is accepted, closed. Lord, then on page 34, my lord, order dated 5/4, protest petition, the complainant files protest petition, call on for hearing 21/4.
Page.
My lord, page 34, my lord. The order dated 5/4, my lord, the protest petition is filed by R2.
Then.
Lord, then, my lord, page 36, order on B report. Lord, at page 40, Lord, the operative portion of the order. Lord, the last paragraph at page 39. It is to be noted here that though in the instant case, the court has accepted the B report, but there is no bar to direct the investigating officer to conduct further investigation. In view of the same, I find proceed to pass the following order. The office is to issue intimation to the IO to make further investigation in the present case and submit his report with case time. So, my lord, if there is an order, my lord, accepting the B report,
But notice was not issued to respondent number 2 and 3.
please, my lord, for that, my lord, Bhagwan Singh's case is there, my lord, notice is required to be issued to the first informant and not to the victims, not to the witnesses.
Whether the say of the injured could totally be ignored.
Please, my lord, but then, my lord, law to that effect is, my lord, if a B report is accepted, it would not stop, my lord, the other victims, my lord, if they are injured, my lord, they can file fresh complaints.
Protest petition in the form of first complaint.
Please, my lord, but protest petition when? Protest petition, my lord, after the B report is accepted.
That is why, see, they were not.
That is what I am trying to say. My lord,
having notice of filing the B report and acceptance of the
yes, yes, my lord, that is why, my lord, I am not speaking here anything on the merits, my lord. It is only on the procedural thing, my lord, whether the magistrate, my lord, Adalat Prasad's case says that once the magistrate passes an order, my lord, he cannot recall his own order unless and until, my lord, he is directed, my lord, by a superior court to do so. That is why, my lord, my lord, generally, my lord, when I am before your lordship, my lord, under 482, my lord, I would not speak up on the merits, my lord, because we have to see. I am only on the procedural aspects. And here, there is a procedural irregularity not once, but twice. And the order here, he doesn't say he has rejected the B report. My lord, he says, although I have accepted the B report, you do further investigation. My lord, that is bad in law. My lord, he should have said the B report is rejected and you take up further investigation.
Well,
Here-
hair splitting argument antar.
So, my lord, ultimately, my lord, a role, my lord, which I can only get it to your lordship, that, my lord, there is a procedural irregularity, but which ultimately, my lord, results in, my lord, failure of justice.
No, prima facie they are the injured victims.
My lord, I would not, and there is material to such effect. My lord, I would not come on that. That is why, my lord, I categorically began my arguments stating that both are respected members of the bar. So, my lord, in fact, both you and Shashidhar and me, we both have tried, my lord, but ultimately, my lord, perhaps the egos, my lord, are coming in the way.
Let them attend the court. Let them attend the court.
Lord, for
Let the respondent enter the witness box. Let the other enter the dock.
Lord, the procedural aspects here, my lord, would
The
have to be.
ego will gradually reduce.
But I think now, my lord, proceedings of 2015, we are in 25, 10 years, my lord, dragging on the proceedings, my lord, should be sufficient is, my lord, what I, from 2015, my lord, we are in 2026, my lord, more than 11 years.
Now final report is filed by the investigating officer.
My lord, even once a final report is filed, my lord, taking of cognizance, section 190, my lord, the aspect is different. But under section 204, my lord, there has got to be an application of mind while issuing process, my lord. That is what the law says. My lord, if my lord would have a look at the order, but absolutely no.
No, taking cognizance, the magistrate need not have to pass a
While
detailed
taking
order.
cognizance, yes. My lord, under section 190, yes. But my lord, scope of 190 is, my lord, only with regard to whether the ingredients disclose the commission of an offense. My lord, with regard to section 204, my lord, if there is a commission of offense, who has prima facie conducted, what is the role played by these accused towards the offense should have been. My lord, may
N 204
issuance of process to the accused, my lord.
under a private complaint.
No, my lord, 204 is common, my lord, for both the private complaint as well as the police report.
Correct.
But my lord, 204, there has to be an opinion of the magistrate before issuing process. My lord, law is that a detailed, my lord, record need not be mentioned. But there has got to be something, my lord, to indicate application of
If
mind.
the learned magistrate refused to take cognizance, he has to write a detailed order.
Lord, for taking cognizance is taken not against the offender, my lord. Cognizance is taken of the offense.
Yes, correct.
So that is, my lord, the scope under section, my lord, that is why, my lord, perhaps, my lord, the CRPC different stages.
If we were, it is your contention that in the charge sheet, there are no prima facie materials to enable the magistrate to take cognizance.
Please,
You may address the argument.
please, my lord.
But
I would,
there are prima
I would,
facie
I would still
materials.
say, my lord, for an offense under section 324, my lord, there has got to be a weapon, my lord, which results in a thing. My lord,
It is
here,
all-
my lord, there is no recovery.
See, there are prima facie, there are wound certificates.
Please, my lord, wound certificate, my lord, does not indicate, my lord, that the injuries sustained are by a weapon. My lord, the assault that is shown,
These are all the arguments you may have to address before the court
No, my
while.
lord, for 323
While framing charge. That's all. Not for quashing it. Charge hearing before charge ಅಂತ ಒಂದು stage ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ, ಇದೆ.
ಅವಾಗ you have to say
But my lord,
whether
there are-
323 alone, whether 324, whether 326, 307 ಎಲ್ಲ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. ಇಬ್ರು ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ, ಅದು ಹೇಳ್ಬೋದು, ಅದಿಲ್ಲ. ಬಟ್ ನಾನು ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
On the basis
My
of
lord,
that,
I never, my lord, generally argue on merits, my lord. Is the case, my lord, under 482. But here, my lord, there is, my lord, whether the magistrate can do it.
Where is the bar, sir? Where is the bar?
My lord, again, my lord, these are the procedures as to how.
That is purely
once-
on facts of the case. Facts of the case.
No. On technicalities, my lord, the procedure, my lord, Justice Panindra, my lord, says once a B report is filed,
That is an irregularity.
it's a irregularity, my lord. So perhaps it has to go back. But here, my lord, as the magistrate has already accepted the B report, my lord, further investigation can be directed only if a B report is rejected. Even, my lord, while referring for further investigation, the learned magistrate does not reject.
Now, what do you want this court to do?
My lord, the order, my lord, making a reference, my lord, has got to be set at naught.
And then accept the B report.
My lord, it is already accepted, my lord.
What should happen to the final report filed by the investigating officer?
My lord, that
I
becomes
should
a,
ignore that.
my lord, that has to be ignored, my lord. And my lord, again, my lord, post reference. Under one, my lord, post reference, my lord, there is no investigation that is conducted.
Maybe it is a criminal case, sir.
No.
Are prima facie materials to show that 3 of them have sustained injuries.
Please.
It cannot be ignored so lightly,
My lord.
saying there is procedural irregularity, so I am accepting the B report, ignoring the charge sheet.
My lord, 31, please, my lord, 31/10/2018. My lord, is the reference made, my lord?
ಆಯ್ತು ಅದೆಲ್ಲ ಆಯ್ತು.
ಇಲ್ಲ, 31/10/2018 ಆದ್ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇಲ್ಲ.
What is the answer I can give to the victim, sir? ಹೊಡೆಸ್ಕೊಂಡಿದ್ದೀರಿ, ಸುಮ್ನೆ ಹೋಗಿ ಪರವಾಗಿಲ್ಲ ಒರೆಸ್ಕೊಂಡು ಅಂತ ಹೇಳೋದ?
ಅಲ್ಲ.
That is why this is the court of law.
No, it is.
Court
But
of justice.
yes. My lord, but 31/10/2018.
Hey, don't worry, you go away.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿದೆ 11 ವರ್ಷ ಆಗಿದೆ. My lord, poetic justice is already done. My lord. But my lord, 31/10/2018, my lord, after the court passes an order directing the investigating agency to conduct an investigation, my lord, there is no investigation which is conducted.
Only on these technicalities that cannot be quashed.
Lord, other than technicalities, my lord, I never come to the court. Lord, and I will not make any submissions, my lord, on merits.
If only respondent number 2 is the only injured, and if he says I have no objection, you are right.
And my lord, respondent number 2, my lord, agrees, my lord, and he has filed.
He has filed a memo.
He has filed, and he continues.
Now
Lord,
he is not the aggrieved. He is not the
he is
victim.
not the aggrieved, although he is a witness.
Other 2 injured are there. They are respondent number 3 and 4.
3 and 4.
Ah.
Yeah. My lord, that is what I said, my lord. With regard to the merits, my lord, I will not make any
Since
submission.
they are the victims, since they are the injured eyewitnesses, why their version is to be disbelieved?
My lord, but my lord, insofar as the injured eyewitness says, my lord, insofar as the role of the petitioner number 3 is concerned, my lord, absolutely there is no material. Lord, even in the wound certificate, my lord,
It is for the trial court to
no,
appreciate.
no,
the
my lord, there is even their statements. If my lord would say, my lord, the role played by the accused number 3, my lord, there is no mention. My lord, neither in the wound certificate before the.
34 ಇದೆಯಲ್ವಾ?
Please, my lord.
34.
34 is there. But it is 1, 2, and 15 others. So he is one among that 15, and there is no investigation to such effect.
Even then. And now the charge sheet is filed.
It is
Initially,
filed.
of course, 15. Now the charge sheet is there.
Lord, that is the order, my lord, which I have challenged, my lord, the order taking cognizance, 5/2/2019. That is the order which I have challenged. My lord, page 68, my lord.
Order and challenge ಮಾಡಿಲ್ಲ ನೀವು.
Page 68, my lord. Ade,
Crime number 242 of 2015. Quash annexure F. Quash entire proceedings.
entire proceedings, my lord. The second prayer, my lord, in CC 3813 of 2019.
Entire proceedings.
Annexure G, my lord.
Entire proceedings quash.
Please, my lord. So proceedings is, my lord, subsequent to taking
Order
cognizance.
ಏನು ಮಾಡಿಲ್ಲ ನೀವು. Quash they set aside the order and accept the
The
report.
proceedings in CC anta ide. So CC
Entire
happens
proceeding.
once the court takes cognizance. CC once the court takes cognizance.
ಇದು ಟೂ ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ ನಲ್ಲಿ ಅಲೋ ಮಾಡ್ದಂಗಾಗುತ್ತೆ. No, may not be proper.
Lord, cognizance is taken in respect of these offences.
Answer to respondent number 3 and 4.
Please, my lord.
3 and 4.
Yes, my lord.
What answer
ma-
the court can have?
Certainly, my lord. Sir. My lord, that is why I made my submission, my lord. I will never argue on merits.
Correct.
And I am here only, my lord. If, my lord, I succeed, it is only on the technicality, my lord. If the court would not want to interfere on the technicalities, my lord, then I would leave to this court. I would leave.
Maybe technically you may have some grounds. That cannot be the ground for
My
quashing
lord,
the
because, my
proceeding.
lord, once the B report is accepted, my lord, there cannot be an investigation.
Sir,
Or
in
the court
accepting-
cannot take cognizance.
In accepting B report also, the court was in a hurry to accept the B report.
My lord, subsequent, that is what I am telling. My lord, subsequently, my lord, while ordering further investigation, the court does not say that the B report is rejected. It says, although I have allowed the B report, you do investigation.
There is, according to the learned magistrate, there is no bar.
No bar, yes. My lord, no bar, my lord, once the B report is accepted, still, my lord, if a case is, my lord, yes. But unless and until the B report is rejected by the court, here, my lord, there is no order on rejection of the B report. That is why, my lord, other than this, my lord, I have no arguments.
If we start interfering with these orders, almost 50% of the cognizance we have to set aside.
My lord, that is what the law says.
We should not be very too technical, sir. Two
Lord,
and
I'll
three
take-
persons,
I'll-
at least
Lord-
2 persons have sustained injuries. One, of course, he has no objection. Let him go.
My lord, the injuries are, my lord, tenderness, my lord, which is not an injury in medical jurisprudence. my lord.
ಏನ್ ಮಾಡೋಣ?
That is not a medical injury in medical jurisprudence.
ನೀವು ಬಿಡ್ತೀರಾ ಈಗ ಯಾರು ಬಂದು
Pain, tenderness, my lord, this cannot be an injury. My lord.
ಯಾರಾದ್ರೂ ಬಂದು ನಿಮ್ಗೆ ಹೊಡೆದು ಹೋದ್ರೆ ಬಿಟ್ಬಿಡ್ತೀರಾ? ಹೋಗ್ಲಿ ಬಿಡೋದು ಏನೋ ಅವ್ರು ಹೊಡೆದಿದ್ದಾನೆ ಅಂತ. No?
I would not, my lord. Ultimately, my lord, I am standing as a member of the bar, my lord.
Correct.
And here, my lord, the bar is on behalf of both the sides.
They are also members of the bar.
Yeah. So that is what I said, my lord. I will never make any submission on merits, my
This
lord.
way,
My lord. Yes, my lord. That is why, my lord.
whether they are the members of the bar or any common
Yes, yes,
citizen.
yes.
Why should the court say even if you are injured, just ignore that? No court can say that.
No, it cannot. Certainly not, my lord. Certainly not. My lord.
You should
My lord, I would only say, my lord, it is an incident.
reach
That is why, my lord,
conclusion ಬರಲೇಬೇಕು. ಏನಾಗಿದೆ?
ನಾನು ಈಗಲೂ ಅದೇ ಹೇಳ್ತೀನಿ, my lord, if there is a possibility of a settlement, my
ಅದು
lord, it will
ನಿಮಗೆ
be
ಬಿಟ್ಟಿದ್ದು.
explored. That ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. Other than that, my lord, I would not make any other submissions. My lord, if there is something which, my lord, the respondent want an apology or anything, my lord, I would certainly, my lord, that would happen. But ultimately, my lord, we cannot force a person.
Respondent number
3 and 4.
3 and 4. ಏನ್ ನಿಮ್ದೇನು?
See, the respondent number 2 loaded with them and he has closed it. So far as acceptance of their report is concerned.
Where is the provision notice to the other injured? Which is the provision that enables the court? Which is the provision that enables the court? Observation ಬೇಡ ನಾನು. Is any provision in requiring the magistrate to issue notice to all the victims?
No, not all the.
On filing of the B report, what is the procedure? Complainant is to be notified.
Even under section 327, when the compounding of offense.
ಅದು ಬೇರೆ, ಅದು ಕಾಂಪೌಂಡಿಂಗ್ ಇಲ್ಲ ಇಲ್ಲಿ.
Also,
ಕಾಂಪೌಂಡಿಂಗ್ ಇಲ್ವೇ ಇಲ್ಲ. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ, ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ. What is wrong in it?
the report acceptance and earlier notice has to, without giving the notice, even notice has been.
Sir, ನೀವು ಮತ್ತೆ ಡಿವೇಟ್ ಮಾಡಬೇಡಿ. I am posing a very specific question. Is there any provision under CRPC requiring the magistrate to issue notice to each of the injured?
There is no.
Then what is wrong in
They
it?
have not issued, magistrate has not issued the notice. We have not brought to the knowledge.
Whether
of the
you
court.
can, you can file protest, who can file the protest petition? Only the complainant can file.
Complaint has filed.
Witnesses cannot file.
Complaint has filed the protest petition. Your Lord.
So now he has no objection now.
No, my lord, a protest petition and the last may kindly see the hard sheet dated.
ನಾನು ಅದು ಯಾವುದೂ ನೋಡಲ್ಲ. ನಿಮಗೆ provision of position of law, I am asking you
Yes, filed the.
whether a witness can file a protest petition. ನಿಮ್ಮದು ಅಷ್ಟೇ ಕಷ್ಟ ಇದೆ, ಅವ್ರಿಗೆ ಎಷ್ಟು ಕಷ್ಟ ಇದೆಯೋ ಅದಕ್ಕಿಂತ ಹೆಚ್ಚು ನಿಮಗೆ ಕಷ್ಟ ಇದೆ. Don't be under the impression that you are safe. No, no. Where is the provision to enable the witness to file the protest petition? Invariably, protest petition will be filed by the complainant, not by any other person. Where is the procedure? You may be having other remedies, but not filing protest petition, sir. Lord will not permit you.
Already charge sheet was ready.
ಅದು ಏನಾದ್ರೂ ಇರಲಿ, CRPC, we have to follow the CRPC. You see, unknown to CRPC.
Last may kindly entire charge sheet, my lord. The charge sheet was ready.
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಬಂದಿದ್ದು ಆಮೇಲೆ ಸರ್. ಅದ್ರ ಮೊದಲಿಂದ ಎಲ್ಲ ಕತೆ ಹೇಳಿದರು. On facts, there is no dispute.
Accepting of the report second and the charge sheet was ready. The report has come.
You are not.
I was filed the report, charge sheet and was ready.
Sir,
It will be filed.
legal aspect to accept the complainant, the court is not required to issue notice to the victims, other victims. Secondly, it is only the complainant who can file the protest petition and not the witnesses. The B report is already accepted, not once, twice.
Second time.
According to him, the learned magistrate becomes punctus officio.
There is a judgment is regard of one report judgment.
What is that? Recall at whose instance? Somebody, some person will come under the learned magistrate recalls it. Person will come under the learned magistrate recalls. Complainant. I can understand. What is the basis? What is the basis? What is the basis?
It was referred to the investigation. Again, he files a memo on 2/5/2018. It has been rejected once. So once it has been referred for investigation, it cannot be.
Sir, now respondent number 2 is not having any grievance.
Sir, now respondent number 2 is not having.
ಅದೇನ್ರಿ ಅದನ್ನ ಮ್ಯೂಟ್ ಮಾಡಿ ಅವ್ರು
ಅದನ್ನ
ಮ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ.
ಮ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Mr. Gopal Gowda, you have to mute your mic.
Please, my lord.
Mute your mic.
Please, my lord.
ಇನ್ನು ಮ್ಯೂಟ್ ಮಾಡಿಲ್ವಾ? ಮಾಡಿ ನೀವು. Yes.
Even during the writing of the complaint also, they have
So
done.
what is your ಏನದು locus standi?
We are injured, my lord.
Injured, sorry sir, under which provision you file the protest petition?
Protest petition is filed under.
How the magistrate, under what provision the magistrate can take no judicial notice of your protest petition? Is there any provision under CPC? There is no provision. Then what is the remedy for a victim?
Again, further complaint has to be lodged.
First, that is permissible under law. CRPC do not bar you from filing the complaint.
Even the
Go and file the complaint.
the thing, my lord, your lordship may kindly introduce the order dated 31 May.
Order ಎಲ್ಲ ನಾನು ನೋಡಾಗಿದೆ, ಎಲ್ಲ ಮಾಡೇ ಆಗಿದೆ. Show me one provision
Here, 24
justifying the orders passed by the learned magistrate. ಈ provision ಕೆಳಗೆ ನಾವು ಮಾಡಿದೀವಿ, we are justified, even the learned magistrate is justified.
Since it is a pre-cognizant stage, my
Huh?
lord. Pre-cognizant
At
stage.
any stage for that matter, at any stage, there must be some provision under CRPC. There is provision enabling only the complainant to file protest petition. It is unknown to law. Victim filing the protest petition. You could have filed a complaint directly. Even the private complaint you could have filed.
Again, the procedure.
Then if the learned magistrate has taken cognizance, yes, he was right.
Lordship may kindly introduce the orders, my lord. What the magistrate has observed.
He will, definitely he will make some observation, sir. I am not bound by that. I am asking you, where is the provision of law?
Yes, he has not, earlier order ಏನಿದೆ ಅದನ್ನ restore, he has only restored the earlier order.
Under which provision? What is the authority of the learned magistrate?
When once the second time acceptance, when the matter is referred for further investigation, the magistrate has to wait for the investigation. But in the meantime, what has
Oh,
happened?
once he has
Referred for further investigation.
once he accepted B report, how he can order for further investigation?
That's what the judgment is there. Complaint himself has filed the protest petition.
ಆಯ್ತು, ಆಮೇಲೆಲ್ಲ ಆಯ್ತಲ್ಲ, ನಾನು I have no objection ಅಂತ.
Complaint during the course of investigation, the complaint again comes and files the memo stating that the report accepted. Then once magistrate has referred for further investigation, he cannot do the same thing. That's what the observation, and your lordship may kindly see earlier to that. He files a same memo and it has been rejected.
Sir,
One day earlier,
you
he
cannot-
files the same memo.
you cannot depend upon the memo filed by respondent number 2. What is your locus standi? I am asking you. Respondent number 3 and 4.
3 and 4, we are injured, my lord.
ಇಂಜೂರ್ಡ್ ಎಲ್ಲಿದೆ? ಮತ್ತೆ ಅದೇ ಪ್ರಶ್ನೆಗೆ ಬರಬೇಡಿ ದಯವಿಟ್ಟು.
Only thing is that matter has been referred for investigation. Further investigation has been completed. That's what the report filed by you. The lordship will kindly produce the document.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್?
Investigation. Police know earlier when the notice was issued with regard to the investigation.
ಎಲ್ಲಿ
ಈ report accept ಮಾಡಕ್ಕೆ earlier charge sheet ready ಆಗಿದೆ ಅಂತ. They have filed the report.
ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ?
Magistrate.
ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ?
3/2/2018.
ಏನದು?
It is the report
ಹ್ಮ್.
which has been filed by the High Court. Investigation has been completed and charge sheet is ready.
ಯಾವಾಗ?
3/2/2018.
ಏನು? What is the significance of that date?
Subsequent to that, the B report has been accepted. Charge sheet ready ಆದ್ಮೇಲೆ charge sheet file ಮಾಡೋ time Charge sheet is ready in the building.
But it was not filed into the court.
It has been filed for the court. It's the copy of the court.
Order sheet adu.
Charge sheet, I
Lord.
report. It has been come in the charge sheet. I was stating that I have filed report.
My lord, page 42 is the order sheet, my lord. No such mention. Page 42 is the order sheet. And there is also no signature of the learned magistrate on that document, my lord. Page 42, my lord, is the order dated 3/2/2018. Complainant present, await final report. Call on.
Hmm. And even on the next date of hearing, await report, await final.
Await final report, my lord. There is no such mention. And my lord, the document which he is referring to, my lord, there is no signature of the learned magistrate on that date.
It is a part of the file, Your Honor. Certified copies have been
Subsequently, it might have been filed.
Kodi.
very clearly.
Praying time. ಅದಕ್ಕೆ ಆಮೇಲೆ next date ಗೆ the court has mentioned the investigation is still pending.
Yes.
Order dated 2/5/2018. ಎಲ್ಲಿದೆ? ಸಿದ್ಧಪಡಿಸಿ
ಆರೋಪಿಗಳ ವಿರುದ್ಧ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯನ್ನು ಸಿದ್ಧಪಡಿಸಿದ್ದು.
ಸಿದ್ಧಪಡಿಸಿಕೊಂಡು ಅವ್ರು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. How the magistrate is concerned. He has to officially file it in accordance with law. Then
That's why. That's been.
unless it is officially filed, the investigation will be pending.
Your lordship may kindly terms the order dated 2/5/2018.
Hmm.
2/5/2018.
Yes,
Complaint is this council and a file ready to withdraw the case, but investigation is still
pending.
pending. Hence the same cannot be closed.
Yes.
And once the magistrate passes this order, again it, based on the same memo, it closes the case.
ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ? No chance of compromise?
We will refer to the mediation.
Mediation ಯಾಕೆ ಸರ್? ಅದಕ್ಕೆ ಅಷ್ಟೊಂದು ದೊಡ್ಡದು ಯಾಕೆ ಬೇಕು? Both are advocates.
Some personal issues are there. It has to be clear. That's what.
No, we will sit down, Shashi. Now ನೀವು ಮಾತಾಡೋಣ. Personal issues ಏನಿದ್ರು ಹೇಳಿ. It is across the bar, my lord. Let it be settled in the bar, my lord. Is what I would.
See, it may not be a difficulty for me to dispose of the petition. Either I can dismiss the petition, even I can allow the petition.
Please, my lord, please.
That is not a difficulty.
My lord, it may be adjourned by a few days, my lord. We'll explore the possibility again. My lord, now that my lord, we have consumed sufficient court time.
Then I'll dispose of first. I will start dictating ಅದು ಏನ್ ಬರುತ್ತೋ ಹೋಗುತ್ತೆ.
Lord, it may be treated as part heard and it may be called on Monday, my lord. I will again have a talk with.
ಇಲ್ಲ ಸರ್, see the date of incident ಯಾವಾಗಿದು?
2015. 15.
10 ವರ್ಷ ಆಗಿದೆ.
ಅದೇನಾ?
ಇನ್ನೇನಿದೆ?
ಈಗ 10 ವರ್ಷ ಆಗಿದೆ, ಅದಕ್ಕೆ
10 ವರ್ಷ ಆದ್ಮೇಲೂ ಪರ್ಸೂ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತಂದ್ರೆ they are very serious about that.
they are serious.
Yes.
My lord, it is not an incident, my lord, which should be brushed aside also.
Then what is the stage now?
My lord, the order, once, my lord, cognizance was taken and notice was issued.
Charge is not at
No, my lord. Once the notices were issued, my lord, we came before this court and the proceedings are stated.
Just go before the court. Go before the court, trial court.
But because of these,
Hearing before charge ಇದೆ, ಅಲ್ಲಿ offense ಇಲ್ಲ ಅಂತಂದಿದ್ದಕ್ಕೆ you can, liberty will be reserved. Here before charge.
Lord, I would leave it to this court, my lord. But my lord, if, my lord, now that we have heard it, my lord, one last attempt.
ಆಗಲ್ಲ ಸರ್, ನೀವು ಒಬ್ರೇ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ನಾನಿಲ್ಲ.
Then
I will talk to my, my lord, as it is an issue
he is
relating
not
to the bar.
interested, why we? I should,
As it is an issue relating to the bar, my lord, I would request the association, my lord, to intervene.
No, the members of the bar should understand.
I do, my lord, I do.
ಅದು
It should not have.
ಅವ್ರೇನೋ ಸ್ಪೆಷಲ್ ಕ್ಯಾಟಗರಿ ಅಂತ ನಾವು ಟ್ರೀಟ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ, ಹೌದು.
ಏನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಹೌದು ಅಂತ ಅನ್ಬೋದು ಅಷ್ಟೇ. That does not mean to say ಇಲ್ಲ members of the bar ಇದೆಲ್ಲ ಸರಿ.
ಇಲ್ಲ,
Why
ಆ
should
ತರ
I
ಇಲ್ಲ.
do that?
As it is relating to the members of the bar, my lord, I am taking this, my lord.
To know it, ಇನ್ನು ಲೇಮನ್ ಯಾರಾದ್ರೂ ಬಂದ್ರೆ ಅವ್ರಿಗೆ
My lord,
ಹೇಳ್ಬೇಕು.
either ways, my lord, an order either ways, my lord, it would be affecting again a member of the bar, my lord.
Let it
That is why, my lord, I am taking this.
They are
I
not-
would be speaking on behalf of both the parties, my lord.
I am not looking at them as the members of the bar. I am looking at them either as complainant or as accused. ಅಷ್ಟೇ.
Because both are dear to me, my lord. As members of the bar, my lord.
ಬೇರೆ ಇದಕ್ಕೆ ಮಾಡೋಣ. ಈ ಫೈಲ್ ಅನ್ನು ಎದುರಿಟ್ಕೊಂಡಾಗ they are only
That's right.
petitioner, respondent, complainant, accused.
That's right. I leave it to the court, my lord. Otherwise, ಏನ್ ಹೇಳ್ತೀರಿ ಶಶಿ?
ತಗೊಳ್ಳಿ. The petitioners. Being accused numbers 1 to 3. ಅದು citations ಹೇಳಿದ್ರಲ್ಲ ಇಬ್ರು ಕೊಟ್ಟು.
Please, man.
Accused number 1 to 3 in crime number 242 of 2015, of which police station?
Pulsugate Police Station.
Pulsugate Police Station. Registered for the office of constable under section 323. Now pending in CC number 3813 of 2019 on the file of the learned 6th additional Chief Metropolitan Magistrate, Bengaluru, are seeking to quash the criminal proceedings initiated against them for the offence punishable under sections.
ಏನಂತೆ?
Final report ಎಲ್ಲಿದೆ? ಸಿಕ್ಕಿದೆ. Yes. For the offence under section 323, 324, 506, read with section 34 of IPC. Third solution, reused. Answer dash for the following reasons. Respondent number 2 as first informant filed the first information. It's also the police against accused number 1 and 2 and 15 others, alleging commission of offence punishable under section 324, 506B, read with section 149 of IPC. The investigation was undertaken and the summary report came to be filed. It is stated that the learned magistrate accepted the B report initially on 31/12/2016. When respondent number 2 has not appeared before the court in spite of service of notice. It is thereafter on 27/4/2017, respondent number 2 filed the protest petition seeking reopening of the case. The magistrate, by setting aside his order dated 31/12/2016, referred the matter for further investigation. When the further investigation with the police was pending, on 13/5/2018, respondent number 2 appears to have filed an application requesting the trial court to accept the B report as he is not interested in prosecuting the matter. As per order dated 18/5/2018, again the B report was accepted. By the trial court by allowing the application filed by respondent number 2. It is thereafter respondent number 3 and 4, who are said to be the injured eyewitnesses, filed the protest petition. Based on the such protest petition, the magistrate recalled his order dated 18/5/2018 and directed the police for further investigation. It is stated that now the charge sheet came to be filed for the offence under section 323, 324, 506, read with section 34 of IPC. And the magistrate has taken cognizance of the offence. Being aggrieved by the same, the petitioners are before this court. According to learned counsel for the petitioner, raised the following questions, following grounds in support of his contention to quash the criminal proceedings. Firstly, when once the learned magistrate accepts the B report, after notifying the complainant, he becomes functus officio and he has no authority or jurisdiction to accept the B report, accept the protest petition and setting aside the B report. According to the learned counsel for the petitioner, the learned magistrate never rejected the B report nor accepted the protest petition, but set aside his order accepting the B report and referred the matter for further investigation, for which he had no authority. Next, the counsel for the petitioner also contended that respondent number 2 has filed an application stating that he has no intention to prosecute the criminal proceedings. And accepting the said application, the learned magistrate again accepted the B report, thereby rejected the protest petition filed by the complainant. Therefore, it is the contention of the learned counsel for the petitioner that when it is only the complainant who can file the protest petition, and when such protest petition is rejected by the trial court by accepting the B report, respondent number 3 and 4, who are the witnesses to the incident, would not have filed the protest petition. This procedure adopted by the learned magistrate is unknown to law. In spite of that, the learned magistrate recalled the order dated 18/5/2018 and directed for further investigation, for which he has no authority. It is relied on by ಇವರು ನಿಮ್ದೇನು ಡಿಸಿಷನ್ ಇದೆಯಾ ಇಲ್ಲ ಏನು ಫಂಕ್ಟಸ್ ಅಫಿಷಿಯೋ ಅಂತಂದ್ರಲ್ಲ ಕೊಡಿ Learned counsel of the petitioner has placed reliance. ಕೊಡಿ. The decision 1985 2 ACC 537 to contend that ಯಾವುದು relevant paragraph to contend that to contend that when a B report is filed by the investigating officer, the learning magistrate may either accept the report and drop the proceedings, or he may disagree with the report if there are sufficient grounds for proceeding further, take cognizance of the offense and issue process, or he may direct further investigation to be made by the police under section 156(3) of CRPC. ಮತ್ಯಾವುದು ಏನಿದೆ ಇದರಲ್ಲಿ? Why you are telling?
clarifies the position, however, we are taking. When we consider the question whether the injured person or relative of the person is not the informant, is entitled to notice when the report comes up for consideration. We cannot allow either from the provisions of CRPC or from the principles of natural justice any obligation on the magistrate to issue notice to the injured person or to a relative of the deceased for providing such person an opportunity to inform at the time of consideration of the report, unless such person is the informant who has lodged the FIR. But even if such person is not entitled to notice from him, he can appear before the magistrate and make his submission when the report is considered by the magistrate for the purpose of deciding what action he should take on the report. The injured person or any relative of the deceased, though not entitled to notice from the magistrate, has notice to appear before the magistrate at the time of consideration of the report. If he otherwise comes to know that the report is going to be considered by the magistrate, and if he wants to make his submission to that report, the magistrate is bound to do it. We may also observe that even though the magistrate is not bound to give notice of the hearing, fixed for consideration of the report to the injured person or to any relative of the deceased, he may, in the exercise of his discretion, if he thinks so fit, give notice to the injured or to any particular relative or relative of the deceased. But not giving of such notice will not have any invalidity effect on the order which he may be made by the magistrate of the court.
He also contended, placing reliance on this decision, that the learned magistrate is not duty bound to issue notice to the injured or the relative of the injured or victim. The court has held that the locus, such witnesses may have the locus to appear before the magistrate only at the time of consideration of the report and make their submission, but definitely not after accepting the B report. Para 4 and 5 ಅಂತ. ಮತ್ತೆ ಅದು ಫಂಕ್ಟಸ್ ಅಫಿಷಿ ಅಂತ ಏನೋ ಹೇಳಿದ್ರು. ಇದು ಯಾರದು ಪಿಟಿಷನರ್?
Karnataka 17.
ನೋಡೋಣ. 230. ಕಂಟಿನ್ಯೂ. ಏನೋ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ, ಹೇಳಿದ್ರು ಕೊಟ್ಟನಲ್ಲ, ಅದರಲ್ಲೇ ಇದೆ ನೋಡಿ. ಎಸ್.
ಕೇಳ್ತೀನಿ ಸರ್, ಫಸ್ಟ್ Matter pertaining to Kalburgi bench, advocate Sidira sir. ಪಾಸು ಇದೆ ಕೇಳ್ತೀನಿ ಯಾವ್ದು ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ಅದು. ಕಲ್ಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಯಾರು ಇಲ್ವಾ? ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕಲ್ಬುರ್ಗಿ. ಸರ್ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದೀರಾ?
ಮೇಡಮ್ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಕಾಣ್ತಾ ಇಲ್ಲ. ಎಕ್ಸಿಟ್ ಮಾಡಿ. ಇದು ಮ್ಯೂಟ್ ಮಾಡಿ. ಸೆಂಟ್ರಲ್
ಪಾಟಲ್ ಇದು ಸಿಕ್ತದು ಫೈಲು ಸಿಕ್ತ ಅದ್ಯಾವುದೋ ಒಂದು ವಾರಿಸಿ ತಂದ್ರ ಆಗಿದ್ಯಾ ಅವರು ಅದು ಯೋಚನೆ ಇಲ್ಲ ಸರ್, ಅದು ಯೋಚನೆ ಇಲ್ಲ. ನೀವು ನಾನು ಒಂದ್ಸತಿ ಕೇಳಿದ್ಕೆ ನೋ ಅಡಿಟ್ಸ್ ಫೌಂಡ್ ಅಂತ ಹೇಳಿದ್ರಿ, ನೋ ಅಪೀಲ್ ಇಸ್ ದೇರ್ ಅಂತ. ಅದರಲ್ಲಿ ನೋ ಅಪೀಲ್ ಇಸ್ ಫೌಂಡ್ ಅಂತ ಬರ್ತಿದ್ದೀರಾ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ ನಾನು ನಿಮ್ಗೆ ಒಂದಷ್ಟು ನಂಬರ್ಸ್, ಇದೆಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ ನೋಡಿ ಸೌಮ್ಯ ಅಂತ. ಅದರಲ್ಲಿ ಅದು ಇಲ್ಲ ಅಂತಾನೆ ಬರ್ದಿದ್ರಿ. ಅದೇ ಇರ್ಬೇಕು.
ಒಂದ್ಸಲಿ ಡಿಸ್ಪೋಸ್ ಆಗಿ ಅವ್ರಿಂದ ಆಮೇಲೆ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಮಾಡ್ಕೊಂಡು ಅದೇನೋ ಕ್ವಶನ್ ಆಫ್ ಲಾಗ್ ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಅಂತ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅದನ್ನೇ ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡಿಸಿದ್ದಾರೆ. ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅದರಲ್ಲಿ ಆಗಿದೆ. ಅದರಲ್ಲಿ ರಿಕಾಲ್ ದಟ್ ಯಾರು ಸೇರಿ
ಕಲಬುರ್ಗಿ ಇದೆ ಸರ್ 5. ನಿಮ್ದು ಎಷ್ಟು ಇದೆ ಸೀರಿಯಲ್ ನಂಬರ್?
Matter pertaining to Kalburgi bench, serial number 1, Arun Kumar,
My
Government
lords,
Advocate.
I appear for petitioners in this case. My lords, petitioners before your lordship are accused number 2 to 4, who are maternal uncles and aunts of accused number 1. Offences alleged are under section 498A, 323, 504, 506, read with section 3 and 4 of DP Act, my lord. However, at the time of filing charge sheet, section 448 and section 3 and 4 of DP Act came to be
Whether
drafted.
earlier petitions have approached this court?
My lord, the petitioners were before your lordship by filing 482 petition. And my lord said the petition came to be withdrawn after arguing for some time, and thereafter I filed, petitioners have invoked section 239 and filed discharge application. Said the 239 petition filed by the petitioners, my lords, came to be dismissed. As such, they were before the learned session judge. Even session judge also confirmed the order of learned magistrate.
That means to say there are prima facie materials to
My lord,
constitute.
looking into taking note of my lord relationship of the petitioners with the accused number 1 and de facto complainant, my lord, they are maternal uncles. The petitioners are accused number 2 to 4 are maternal uncles and their respective wives, my lords.
No.
And taking note of charge sheet allegations, they are omnibus. The police, my lord, this is, my lord, arising out of private complaint initially, my lords, which was referred to police and under section 156(3), and thereafter charge sheet came to be filed. Very fact that, my lord, section 3 and 4 are dropped at the time of filing charge sheet. Allegations alleged are not grave as such, my lord, in order to constitute an offence under section 498A.
No, even section 3 and 4 of DB Act is there.
My lords, it is left out, my lords, at the time of filing charge sheet.
Page
Yes, my
number?
lord. Page, yes, my lord. Page 31 is the charge sheet, my lords.
Hmm.
Yeah, there, my lord, column number 2, Roman 2. ಕೈ ಬಿಡಲಾಗಿದೆ. ಎಸ್, ಕಾಲಮ್ ನಂಬರ್ 448 IPC ಮತ್ತು ಕಾಲಮ್ 3-4 ವರದಕ್ಷಿಣಾ ನಿಷೇಧ ಕಾಯ್ದೆಯನ್ನು ದೋಷಾರೋಪಣಾ ಪತ್ರದಿಂದ ಕೈ ಬಿಡಲಾಗಿದೆ ಅಂತ ಬರ್ತದೆ.
Yes.
Minutes.
In all, how many accused are there?
My lords, total 4, my lords. Out of 4 petitioners are accused number 2 to 4, my lords.
Why you withdraw the earlier petition?
My lords.
No liberty was reserved in your favor.
My lords, it is implied that, my lord, 239 yardstick of 482 and 239 are totally different.
Yes, of course. Earlier you appeared this court under 482
My lords.
after arguing for some time.
Yes, my lords.
After knowing that the petition will not be allowed, you withdraw
No, my lords, the normal practice is, my lords.
Huh? That is the normal practice. When the court
No,
is not inclined to allow your petition,
no.
you make a submission, I am withdrawing the petition.
It was before your lordship only, my lords.
Correct. I know that. Now, once again, why should I consider this?
My lords. My submission at this juncture would be, my lords, 239, scope of 239 and 482 altogether different.
Even that is to be accepted. What is the ground, sir?
My lords, grounds are, according to the petitioners, my lord, there are no material to proceed.
If there are no sufficient grounds for proceeding, definitely your earlier petition under 482 would have been allowed.
My lord's appreciation under 482 and my lord 239, my humble submission would be, my lords, are totally different. And my lordship, nonetheless, of dismissal of 482 can very well look into the materials, charge sheet materials.
Under 482, if it is in abuse, the criminal proceedings is initiated in abuse of process of law, it is liable to be quashed. Under
Yes.
239, if the allegation
Charges are
groundless, and there are no materials to proceed with the matter. That's all.
Yes, my lords. My lords.
It is saying in different terms the same thing. That's all.
My lords, taking note of attitude of my lords, de facto complainant roping all the family members.
Agilva. What is this office objection? What is your submission on office objection?
My lords, if I am not wrong, my lords, manuscript of few pages, my lords, are not furnished. Typed copy as well, my lord, up to date order sheet.
No, you produce the copy of the private complaint, but it does not contain the house title.
Yes, my lords. My lords, any of CC number is reflected on the top of the page, my lords.
So, third learned counsel for the petitioner on office objection at serial number 4. It is noticed that the certificate copy of the private complaint is produced by the learned counsel for the petitioner, which do not contain the cause list. While issuing the certificate copy, the trial court has committed an error. The submission of the learned counsel for the petitioner in that regard is accepted. Subjection at serial number 4 is ignored. Issue notice to respondent number 2. HCGP to take notice for respondent number 1. Notice to respondent number 2. Yes. Issue notice.
Serial number 2, Zakir Hussain.
My lords, I sought for interim order.
Interim order, take out notice. Immediately
Great.
after service, you move the matter, I will take up.
Great, great.
My lords, appearing for the petitioner in serial number 2.
Yes.
My lord, this is the petition filed upon the rejection of a 311 application.
Here also there is a office objection, sir.
Office objection with regard to, my lords, making the parties of accused. This is the
Yes.
petition filed by the complainant.
Yes. What is the relief you are seeking?
My lords, recall of chief examination of IO, my lord. CW 70.
Why complainant is recalling the investigating officer?
Lord, in trial court, prosecution has filed the application and the same was rejected. Being aggrieved by that, my lords, complainant has filed this petition.
Prosecution is not aggrieved then.
Prosecution is aggrieved, but
Prosecution has not challenged that order.
no, my lord, prosecution has not. Lords, offences are 302. Serious
Then
in
why
nature,
the
my lords,
accused
and
are
the
not-
entire
Why the accused are not parties?
no relief is claimed against the accused, my lords. The IO is necessary.
No, the recalling of investigating officer will definitely affect the right of the accused.
But my lord,
It will have an effect on the accused. Definitely the accused will oppose this application, petition
yes, my
rather.
lords, they have contested before the trial court also.
And
But my lord,
behind
was
their back, why should I consider this petition? How many accused are there?
my lords, total 2, my lord.
Implead them.
Total, my lord, 9, my lords.
9.
My lords. Pardon, my lord, 9 accused are.
Serve the notice on the counsel who is representing the accused.
Grateful, my lords.
I will
I will
issue
serve.
notice to respondent. Issue notice to respondents.
Till then, my lords, stay, my lord. Before the trial court, my lords, case is posted for arguments. I have produced the, my lord.
No stay, sir. Immediately you serve on the counsel for the accused and move the memo along with the acknowledgement. I'll take
Any
up the
date may
matter.
be fixed, my lords, next week.
Counsel for the petitioner is permitted to serve the copy of the petition on the counsel representing the accused before the trial. Yeah, you should make them as formal parties in the petition.
My lord, they are not made party.
I will amend the petition, my lord. I will implead.
ಅದು ಇಲ್ವೇ ಇಲ್ಲ ಅಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅನ್ನೋದಕ್ಕೆ ಇವಾಗ ಬೇಡ counsel for the petitioner pays for time to seek amendment of the petition to implead the accused as respondents. This time. Note, in the meantime, if possible, you serve the copy, ask them to appear before the court. But I am not
Lord,
issuing the
till
notice.
then, my lords, not to conclude the trial, my lords, case is posted for arguments.
No. Please serve the copy, immediately file the application, short date ಕೊಡಿಬೇಕು.
Serial number 3, Siddharth Suman, Sanjay Patil.
Please, my lord. My lords, were to recall this to the matter where there was this yadi. It's a matrimonial matter where there was this yadi where the maternal uncle signs saying that there is no dowry, there's nothing, and then he gives a statement to the contrary. On the previous occasion, respondent number 2 was present here with the child, and my lords had asked them to reconsider what they wanted to do, because initially when we went to Kalburgi to then try and settle the matter, there was a demand saying that he would have to come and move to Kalburgi with her, and then he leaves his family here. Then she came here before this honorable court when my colleague was present.
Conciliation.
My lord, I'm okay, but nobody is. I think my learned friend is there.
What my learned friend is saying, I don't think he's been properly instructed. The whole counseling took place in my chamber for about 2 hours. I made a sitting there. All parties were there, but they not so many times I advised them that you have to take the wife back, and she was ready to go. But they told then and there they are taking. I told that cannot be. It cannot be. It's not so easy. The wife and the small daughter immediately they have to accompany the husband at about 4:30 is not a feasible one. Give her some time. She will come down to Gulbarga, to Bangalore, make an alternate arrangement since there is intervention of accused number 2, who is an unmarried elder sister staying with him. Make an alternate arrangement and she is ready to stay with us. ಅದನ್ನೇ ಹೇಳಿದೆ ನಾನು. ನಾವು ಹೇಳ್ತೀವಿ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಿ ಹೋದವ್ರು ಮುಂದೆ did not turn back.
Yes.
No, this I may have to say. In fact, my at least my clients were very happy with what my learned friend, how he at least he was trying to be very neutral when they met him there. This may have happened there subsequent to that, my lord, before on the previous occasion.
Sir, at
before,
least you should have called Mr. Patil.
we have, my lord, we have coordinated because there, my lord, I have my my lord, there's a co-counsel there who's also representing us, my lord, before Kalburgi. They have been coordinating. So here my instructions, my lord, what they say is that there was a condition.
Not ask the wife to come along with
I
you
have not
then
said
and
anything
there.
like that. My lord, she was so what she said is, my lord, she asked for a reconciliation, from their side. They said that yes, they'll come with the son here.
According to Mr. Patil, you
Please.
have to make an alternative recommendation.
That, my lord, so in fact, so this is where
In
we have,
Bengaluru.
this is where there is some, my lord, there is some confusion here. Here, my lord, when she came before this honorable court, before my lords were physically, she said, I have no conditions, I will go back right there itself without any conditions. That was what she was told. That was what was told before this honorable court.
Reconciliation, that is the,
But it's subsequent to, I'm talking about subsequent development before this honorable court.
what is your reply?
My lord, reply to that is, my lord, she can come and stay, my lord, any time with the child itself, my lord. There's a son, very,
She has to stay.
in Bangalore, my lord, she was staying here itself. She's,
Along with,
my lord, I'm staying with my sister. Then, my lords, if my lords were to recall, my lords had also put a question to my lord, my learned friend, saying that, see, why should she move out and go? She's unmarried, where does she go? My lords had put, because she's a spinster. Why should she move out is, my lord, a very, very pertinent question which my lords had itself posed. So here, on the previous occasion, it was an unconditional.
argue the matter.
It was an unconditional, my lord, if my lords was in fact inclined to quash the entire matter because of that one yadi, my lord, that one document, if my lords were to recall, this is Adide. So my lords has taken note of it. In fact, her maternal uncle itself has signed that yadi. And then he gives a statement to the contrary. That is why, my lord, this entire proposal came saying that, see, why don't we then try and settle the matter? I said, yes, I want to see my son. It's been some time since I've seen my son.
Whether she is employed? No.
She's not employed, my lord. But she's a homemaker. I will take care of the child, my lord, no problem at all. As far as she's also concerned, my lord, yes, when she stays with me, obviously I'll take care of everything else.
Not only taking care of the child, sir. What
Everything
about
for her,
the
my
wife?
lord. If she's with me, my lord, definitely have to take care of her.
It is your incapacity to take care of her.
100%, my lord.
Sure. You should
100%.
assure her.
Absolutely no problem. In fact, that's why, my lord, on the previous occasion, when this demand was made saying that I have no demands at all, I'll come directly, please come. After that, I have not heard anything. And it's not an ego issue here, my lord, that I will not call somebody. My lord, my counterpart is also there in Gulbarga. They have been communicating.
I was present throughout the meeting, man.
That's my counterpart, my lord. We're throughout, we're ready.
No conciliation now?
And suggested is, not what I suggested is not, let the wife and the husband with the small child be separately for about 3 months. The second accused can accompany the third and fourth accused who are very well staying there in Bangalore, who is a elder sister of accused number 2. May give a chance for their leading family, let them settle their family, thereafter you can come and join them. Not, it's not that I'm saying she should be made homeless. She is there also with the accused number 3 and 4 who are staying at Bangalore only, who are none else than the blood related sister. And in the interest of the child, which is about 3 to 4 years, give a chance, make an opportunity of giving 3 months, let them stay separately so that they can meet to each other, they can concile each other. Thereafter, it's left to the accused number 2 as well as the complainant. If everything is going well in the interest of the child, there ends the matter.
Petitioner is not ready for that?
ಅದು ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ ನನ್ನ ಜೊತೆ ಮಾತೇ ಆಡಿಲ್ಲ ಅವ್ರು ಮುಂದೆ ಬರ್ತೀನಿ ಸ್ವಾಮಿ ಹೋಗಿ ಬರ್ತೀನಿ ಅಂದ್ರೆ ಯಾರು ಬರ್ಲಿಲ್ಲ ನೋ ಒನ್ ಟರ್ನ್ ಬ್ಯಾಕ್ ಇಲ್ಲೇ ಸಂತೋಷ್ ಕುಮಾರ್ ಇದಾರೆ ನನ್ನ ಚೇಂಬರ್ಗೆ ಅವ್ರಿಗೂ ಕರೆಸಿದ್ದೆ ಕೇಳಿ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲರ್ನೆಡ್ ಫ್ರೆಂಡ್ ಹೂ ಇಸ್ ಆನ್ ದಿ ಲೆಗ್ಸ್ ದೇರ್ ಬಿಫೋರ್ ಆಲ್ lordships he is not been properly instructed. If he was an eyewitness to this, then he would have come to know the practical issue. ನಾನು ನ್ಯೂಟ್ರಲ್ ಆಗಿ ಕೂತ್ಕೊಂಡು 2 hours ಮಾಡಿ ಮಾರ್ನಿಂಗ್ ಮಧ್ಯಾಹ್ನ ಒಂದು ಸೆಕ್ಷನ್
Mr. Santosh Patil, not Mr. Raf. I think there is.
Ma'am, may I make a submission? I was present till evening. I was present, and as per instructions, I am always ready to take back my wife and son. I love my wife and son. I want them.
What is your reply to the point raised by the Mr. Patil?
I think I may have to reply to that, my lord, because my instructions are fresh on this. Insofar as
it is very difficult, sir. You are not.
Allah, I had to go to my lord Kalburgi. That's the only issue. So that is why my lord, my counterpart helped me out there.
He is not having any instruction.
May I just make one submission? I'll just make one submission, my lords, but then kindly see how the situation would be. Petition number 1, petition number 2, and respondent number 2 used to reside together with the minor son. So basically, petition number 1, my lord, is the husband. Petition number 2 is his older sister. As far as petition number 3 and 4 are concerned, my lord, 3 is my lord, another younger sister insofar as the petition number 1 is concerned. Petition number 4 is her husband. They stay in a joint family with their in-laws. Now, my lord, but kindly see, my lord, what my learned friend is proposing. He says, unmarried sister, please go and stay with that joint family.
You being the husband, you cannot be the helplessness.
Joint family illa sir, adunu nan kelidini.
It is your duty to look after your wife
100%.
as much as your unmarried sister.
Please, 100%.
You cannot
I cannot.
disown either.
So this proposal may not because it's not practical for me to send my unmarried sister to
Maybe
somebody else's house.
That does not mean to say that you can send your wife.
I'm not saying that she went in her own will and volition. My lord, the complaint says that.
See, when difference of opinion
Please.
arises, it is your responsibility as a husband to
Please.
deal with that.
Please,
It is in your incapacity.
please.
You should give some assurance. She should have some assurance.
My lord, then I'll keep the party.
Not say no. If you want, you can come. If you do not,
I'll
want,
keep
you
the
need
party
not
present here, my lord.
My sister will be there. I cannot leave her. That cannot be the
My lord,
trend.
that is not some. It's not a new condition which I put forth, my lord. We were always staying together.
Some misunderstanding, some
Please.
rift has arisen.
Please,
Now you have to iron it out.
please.
You
I would. But then
Stand ತಗೊಂಡು ಇಲ್ಲ,
I'll find.
do
My lord, I'll
whatever
also
you
try to
want.
find
No,
out.
no.
But again, her moving out may not be practical there.
Both of you should step forward.
My lord, may I then request then, if that's the case, because if my learned friend is still saying that, see, this is a proposal which
I
they're
don't
putting
know.
forth.
If there is no, if you say there is no chance of settlement, let us go ahead.
No, I wouldn't say there's no chance of settlement only because a minor child is there, my lord. My lord, as husband and wife, they may not be compatible to that extent, but there's a child here. So that, my lord, looking at the interest of the child, my lord, we'll have to look at something else at least.
Your ego, the child has to suffer.
Please. I understand, my lord. So which is why for the child, we'll have to do something for sure. My lord, may I request then that the parties be present here, my lord, so that at least it's ironed out and closed here itself. My learned friend can appear through video conference. I'm here.
Then again the problem.
There's no problem there, my lord. She'll be here. If my learned friend can then come down here also, she's there, my lord. I think she's accompanying him in the back. That can also be a setup, my lord. Let them be there. I'll bring my party here physically then.
Easy remedy is you go there to the Kalburgi.
Not work out, my lord. My job is here. Everything is, my life is here, my lord.
Everything is here, of course. No. You as an advocate accompany your client
Please.
to Kalburgi.
Please.
Sit for a few hours.
Please. I'll work something out, my lord.
Anyway, we are having long weekend.
It is.
You can avail that.
I'll work something out, my lord.
You have to make something, sir.
Please.
Not that petitioner should go and decide.
I understand. I understand. I mean, me as the advocate. I'll see what is possible.
You along with your client should go to Kalburgi.
Please, I'll work something out.
Speak to Mr. Patil.
Please.
Find out
Please.
if something could be done.
Please.
Child, every young child.
The weather is better here in Bangalore. They can also come down. If
No,
possible.
Kalburgi is very, very pleasant now. Very pleasant now. You can enjoy.
If there's a possibility, if my learned friend can also come.
Mr. Patil.
Yes, ma'am.
Yes.
Very pleasant.
Yes, Kalburgi.
Pleasant than Bangalore. I can assure my friend that it is more pleasant than Bangalore.
Really, I am not
Please,
joking.
please.
It will be very, very pleasant.
Please. But I'll work something out. I'll just speak to
go
the
there.
parties.
You
I'll
can
speak to the
enjoy
parties.
that.
I'll speak to the parties. I'll just,
Last time also I had invited my learned friend, Banni, Jolad Rotti Tinistini, have a good time, relax yourself.
ಬೆಂಗಳೂರಿನವರಿಗೆ ಒಂಥರ ಇರುತ್ತೆ ಅದು ಕಲಬುರ್ಗಿ ಅಂದ್ರೆ ಏನೋ
ಇಲ್ಲ I want to go there. It's just that my logistics sometimes is just
you can definitely enjoy your stay.
My lord, that way, to be very honest, my lord, Dharwad and Kalburgi,
Everything.
in fact, Dharwad and Kalburgi, you can breathe much more, my lord, out there compared to that, my lord. There's no two ways. Please, I'll try, my lord. I'll try. Only feasibility, sometimes logistics, my lord. I'll try something, my lord. Please.
Definitely you will enjoy that.
Please.
That too during this January, February,
Please, my lord.
not beyond March.
Not beyond that.
February
Yes.
ಆದ್ಮೇಲೆ ಇಲ್ಲ.
I'll do something, my lord.
Counsel for the petitioner and respondent will protect. This time.
Interim order to be extended, my lord.
Next.
Serial number 4, Sanjay
Please,
Patil.
obliged.
Yes, serial number 4.
Sanjay Patil.
Hello.
Sanjay.
Yes,
pray
serial
for-
number 4.
I pray for some time I could not, just 1 week time, not next week.
Next.
Please.
Serial number 5, SB Sangolagi. SB Sangolagi.
Sangolagi. LCGP takes notice for respondent, private idara. Issue notice. Same. Yes.
Matter pertaining to Bangalore bench. Serial number. Serial number 10, Satyanarayana Estalke, Gopal Gowda, K.N. Shashidhar.
Petitioner. No, why you are relying on so many decisions?
Lord, the second decision, my Lord, Justice Panindra, ILR 2018, Karnataka 1725, but he gives the procedure.
ಎಲ್ಲಿದೆ ILR ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ?
Lord, Dr. Ravi Kumar versus KMC Vasanta and
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಅದು. ಅದು ಸೈಟೇಷನ್ ಇಲ್ಲ, ಏನೋ ಒಂದು ಕೊಡ್ತೀರಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಸರ್ ಪಾರ್ಟೀಸ್ ನೇಮ್ ಎದುರುಗಡೆ ಸೈಟೇಷನ್ ಬರಿಬೇಕಾಗುತ್ತೆ.
I'm extremely sorry. Write everything again. So it has given A, B, C, D, E.
ಯಾವ portion? Why you are relying on this?
My Lord, this is, my Lord, the procedure when a B report is filed.
So why you are relying on this procedure?
My Lord, here, my
I
Lord, the
understand.
procedure has not been followed. Once a B report is filed, Lord, once you accept it, that's it, my Lord.
ಎಲ್ಲಿದೆ ಅದು?
Please, Lord, the learned magistrate has to pass orders on the B summary report before taking cognizance on the protest petition.
ಎಲ್ಲಿದೆ?
My Lord, para A, my Lord, the first page itself.
ಅದು ಹೆಡ್ ನೋಟ್ ಬೇಡ ಸರ್. ನೀವು ಹೊಸದಾಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋರಾಗ
I'm
ಮಾಡ್ತೀರಾ?
extremely sorry, my Lord. My Lord, may kindly turn to page number 1732, my Lord, paragraph 5, my Lord. The procedure followed by the learned magistrate is not in accordance with law. It is well recognized principle of law that once the police submit a B summary report and protest petition is filed to the same, irrespective of the contents of the protest petition, the court has to examine the contents of the B summary report so as to ascertain whether the police have done investigation in a proper manner or not. And if the court is of the opinion that the investigation has not been conducted properly, the court has got some options to be followed, which are: one, the court, after going through the contents of the investigating report, is of the opinion that the investigation has not been done properly, the court has no jurisdiction to direct the police to file a charge sheet. However, the court may direct the police to or further investigate and submit a report, which power is inherent under section 156(3) CRPC. But before taking cognizance, such exercise has to be done. This is the view supported by the apex court in the matter of Abhinandan Jha versus Dinesh Mishra. 2. If the court is of the opinion that the material available in the B summary report makes out a cognizable case against the accused and the same is sufficient to take cognizance and to issue process, then the court has to record its opinion under section 204 of CRPC, and the court has got the power to take cognizance on the contents of the B summary report and to proceed against the accused by issuance of process. If the court is of the opinion that the B summary report submitted by the police has to be rejected, then by expressing its judicious opinion after applying its mind to the contents of the B report, the court has to reject the B summary report. After rejection of the B summary report, the court has to look into the private complaint or the protest petition as the case may be and the contents therein to ascertain whether the allegations made in the private complaint or in the protest petition constitute any cognizable offense, and then it can take cognizance of those offenses and thereafter provide opportunity to the complainant to give sworn statement and to record so and so. 5. If the court is of the opinion that the materials collected by the police in the report submitted are not so sufficient, however, there are sufficient materials which discloses that a cognizable offense has been committed by the accused, court can still take cognizance under 190 read with 200 on the basis of the original complaint or the protest petition as the case may be. After taking cognizance and recording sworn statement of the complainant and statement of witnesses, if any, and also looking into the complaint, protest petition and contents therein, if the magistrate is of the opinion that to ascertain the truth or falsity of the allegations further, inquiry is required and he thinks fit to postpone alone the issue of process, he can still direct the investigation under 202 of CRPC to be made by a police officer or by such officer as he thinks fit to investigate and submit a report for the purpose of deciding whether or not there is sufficient ground for proceeding against the accused. In the above eventuality, care should be taken that the case shall not be referred to the police under 156(3) CRPC once the magistrate takes cognizance and starts inquiring into the matter himself. 6. After taking such report under section 202 CRPC and looking into the entire materials on record, if the magistrate is of the opinion that there are no grounds to proceed against the accused, the magistrate is bound to dismiss the complaint or the protest petition under 203. 7. If in the opinion of the magistrate there are sufficient grounds to proceed against the accused on examination of the allegations made in the protest petition or in the complaint as the case may be, and after perusal of the sworn statement, then he can record his opinion judicially and issue summons. This is, my lord, which is the directions issued by this honorable court as to how the trial courts have got to proceed.
You said once the B report is accepted, the learned magistrate will become functus officio.
Please, my lord. My lord, I have not produced that judgment, but my lord, I did not get any judgment, my lord, directly, my lord, with regard to, my lord, once the B report is filed. But my lord, there are judgments that there is no inherent jurisdiction in the magistrate. My lord, Adalat Prasad versus Naveen Jindal. My lord, right now, my lord, my lord, it is not with me. My lord, the procedure is, my lord, magistrate does not have the inherent jurisdiction to recall his own orders. My lord, is the settled position of law.
That is not the claim.
But my lord, if I remember correctly, my lord, there is a judgment, my lord, of the apex court, my lord, which says that once a B report is accepted, my lord, the magistrate can accept the protest petition. But my lord, I am not exactly able to go through the facts as to whether it is after the acceptance of the report whether they can do it.
Get it?
I would, my lord, I would.
The council also placed reliance on the decision of this court in ILR 2018 Karnataka 1725 to contend that the coordinate bench of this court has laid down a detailed procedure that is to be adopted by the learned magistrate when a B summary report is filed, none of these procedures, as highlighted in para 5, was followed by the London magistrate, and therefore the order passed by the trial court is vitiated. Next, when advocate for the petitioner contends that the learned magistrate will not have any jurisdiction to recall his own order accepting the B report and to direct the investigation into the matter. That too, when respondent number 2 has filed an application stating that he has no objection to accept the B report. Therefore, there is a grave procedural irregularities followed by the learned magistrate, which resulted in injustice to the petitioner. Therefore, he prays for allowing the petition. ಅದನ್ನ ಪಾಯಿಂಟ್ ಎಲ್ಲ ಕೆಳಗಡೆ ಹಾಕಿ ಮೇಲೆ ಫಾರ್ಮಲ್ ಆಗಿ ಕೌನ್ಸಿಲ್ ಕಂಟೆಂಟ್ಸ್ ಅಂತ ಹಾಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಒಂದು ಬ್ರಾಕೆಟ್ನಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. Learned counsel for the petitioner undertakes to produce the citation that the learned magistrate will not have any authority to recall his own orders accepting the B report. Per contra, learned counsel for the respondent opposing the contention taken by the petitioner contended that learned counsel for the petitioner also contended that respondent number 3 and 4 are not the complainant, are not the informant bar complainant. CRPC do not contemplate a procedure to issue notice to the victims or the injured on filing of the B summary report. The trial court rightly issued the notice only to the informant and later accepted the B report. The witnesses or the injured filing the protest petition and the same being accepted by the learned magistrate is unknown to law. ಅದಷ್ಟನ್ನು ಅಲ್ಲಿಗೆ ಹಾಕಿ. ನೆಕ್ಸ್ಟ್ ಪರ್ ಕಾಂಟ್ರಾ ಅದೇ ಹೇಳ್ತಿದ್ದೀನಿ. Yes, what is your contention?
Reason is that the magistrate is having power to recall the order and it is accepted. The last man kindly
ಯಾವುದು
ಹೆಸರು ಹೇಳಿ ಜಡ್ಜ್ಮೆಂಟ್
ILR 2005 KR Lingama versus Karnataka versus Matrimonial.
ಲಿಂಗಮ್ಮ ಎಲ್ಲಿದೆ ಸರ್ ಅಲ್ಲಿ? ಹಾ, ILR 2005 ಅಲ್ಲ, ಸೈಟೇಷನ್ ತಪ್ಪು, ಹೆಸರು ತಪ್ಪು. ಹಾ, ಎಸ್. ಎಲ್ಲಿದೆ? ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? ಪ್ಯಾರಾ 4 ನಲ್ಲಿ ಏನಿದೆ?
Complaint has not been served with the notice of the report submitted by the police to the learned magistrate. After completing the investigation on the complaint filed by.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ? ಪಾರಾ ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿ ಓದ್ತಾ ಇಲ್ವಾ?
Para 4.
Yes. Page number 4019.
4017.
ಇದೊಂದು ಕೆಳಗೊಂದು ಮತ್ತೆ 4 ಬಂದಿದೆ, ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರ. Learned counsel for the revision petitioner submitted that. ಏನಿದು?
It is para 4019.
ಆಯ್ತು.
It's clear that from the above rulings of the court that acceptance of the report is only a tentative judicial order, and the learned magistrate has got always power to order for further investigation in the case, even after the acceptance of the report submitted by the police. When permission is sought for the report on sale, analogy, it must be added that the learned magistrate is also entitled to hear the complaint even after the acceptance
Entitled to hear the complainant.
and decide whether there are any grounds to order for further investigation or to call upon. The magistrate is having the power to
ಆಮೇಲೆ
recall the order. Second is the question.
There also complainant. Magistrate has to call upon the complainant, not the witnesses.
Regarding the witness, they have produced the judgment. The judgment is very clear.
ಯಾವ್ದ್ರಲ್ಲಿ?
Bhagwan Singh.
ಇದನ್ನೇನು ರಿಲೇ ಮಾಡಿಲ್ಲಲ್ಲ, ಇದು ಪಿಟಿಷನರ್ ಇದು. ಇದು ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Lord, that is the procedure, my lord. Both the Supreme Court judgment.
ಭಗವಂತ್ ಸಿಂಗ್.
Lord, Bhagwan Singh, my lord, I read out paras 4 and 5, my lord.
4 and 5 already ಬಂದಿದಲ್ಲ.
ಬರ್ದಿದೆ, already it has come.
ಯಾವ್ದ್ರಲ್ಲಿ? You are relying on that.
4 and 5. 4 only, it is ending 5th line. Page 542. Page 542. We are accordingly of the view that in case where the magistrate to whom a report is forwarded under subsection 2(1) of section 173 says not to take cognizance of it.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ರಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 542.
Last in the 6th line.
Beginning ಏನಿದೆ? We are accordingly.
We are accordingly of the view that in a case where the magistrate to whom a report is forwarded under subsection 2(1) of section 173 decides not to take cognizance of it and to drop the proceeding or takes the view that there is no sufficient ground for proceeding against some of the persons mentioned in the first information, the magistrate must give notice to the informant and provide him an opportunity to be heard at the time of consideration of it. It was urged before us on behalf of the respondent that in such a case notice is required to be given to the informant. It might result in
ಎಲ್ಲದ ಇನ್ಫಾರ್ಮೆಂಟ್ ಸರಿ ಸರ್. ನಿಮ್ದು ಎಲ್ಲಿದೆ ಅಂತ.
I will come to the next one. Verify. The position may, however, be a little different when we consider the question whether the injured person or a relative of the deceased who is not the informant is entitled to notice when the report comes for consideration.
Correct. ಅದರಲ್ಲಿ ಎಲ್ಲ ಇರೋದು when the B report is being considered by the learned magistrate, not after. Not after.
Although it is considered at the time of consideration, even we can appear and we can. There is no. I can't say that there is no lack of stand.
ಎಲ್ಲಿದೆ ಪ್ರಾವಿಷನ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
Provision is not but Supreme Court direction.
Supreme Court ಹೇಳ್ತದೆ when the learned magistrate considers the B report, the injured may appear.
Any relative of the deceased who not entitled to notice from the magistrate as purpose to appear before the magistrate at the time of consideration of the report. If he otherwise comes to know that report is going to be considered by the magistrate and if he wants to make a submission.
Yes. Per control under counsel for respondent number 3 and 4 opposing the petition submitted that respondent number 3 and 4 are the injured eyewitnesses. They are the victims of crime. They came to know about filing of B report and appeared before the learned magistrate, filed the protest petition, which was taken into consideration by the learned magistrate. There is nothing wrong committed by the learned magistrate. The further investigation was undertaken and the police filed charge sheet which makes out strong prima facie case against the petitioner. Learned counsel for respondent 3 and 4 also places reliance on the decision of Bhagwan Singh Supra to contend that in the para 5 the Honorable Apex Court referred to a situation where the injured, where it is held that even the injured can appear before the learned magistrate and file the protest petition even though he is not entitled for any notice from the learned magistrate. Next, learned counsel placed reliance on the decision of this court in ILR 2000 Karnataka 4015 to contend that the coordinate bench of this court has categorically held that acceptance of B report is only a tentative judicial order, and the learned magistrate will always have the power to order for further investigation, even in a case where the B report was already accepted. Placing reliance on these decisions, the learned counsel for the respondent number 3 and 4 contends that minor deviation from the procedure as contemplated under CRPC will not vitiate the entire order passed by the learned magistrate. When there are sufficient materials that are placed before the court to constitute the offense against the accused, the petitioners are not entitled for any relief accordingly placed for dismissal of the petition. ನೋಡಿ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಯಾವಾಗ
My lord, it may be tomorrow, my lord. Tomorrow I'll produce.
Tomorrow ಅಷ್ಟೇ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಅಷ್ಟೇ. ಟುಮಾರೋನಾ ಮಂಡೇನಾ? ಹಾಂ ಆಯ್ತು ಆಯ್ತು ಟುಮಾರೋ ಫಸ್ಟೇ ಬರೋದು. ಮಂಡೇ ಮಾಡ್ಕೊಳ್ಳೋದಿರಿ. ಅದನ್ನು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿ ಫಾರ್ಮೆಟ್. ಫಸ್ಟೇ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಸಬ್ಮಿಷನ್, ಆಮೇಲೆ ರೆಸ್ಪಾಂಡೆಂಟ್, ಆಮೇಲೆ ಎಸ್ ನೆಕ್ಸ್ಟ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ವೀರೇನ್ ಅಜಿತ್ ಗಿರಿ, ಸುನೀಲ್ ಎಸ್ ನಾರಾಯಣ್.
ಕೊಡಿ. Counsel for the petitioner is absent, no representation. This time.
Serial number 12 adjourned. 13 Ashok B. Patil, KL Srinivas.
ಅದರಲ್ಲಿ 11 ಅಲ್ಲಿ ಇಂಟರ್ವ್ಯೂ ಮಾಡೋದನ್ನು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕಾಗಿದೆ. ಅಬ್ಸೆಂಟ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ನೆಕ್ಸ್ಟ್ 14.
Please, Lords.
Yes.
It's basic for a week's time, Lords. Slight fever is adike.
Okay. Counsel for the petitioner, praise for time.
It is an interim order till today, my lord.
Yes.
Kindly be extended.
Next.
14 Rajaram.
Petitioner in this case, offense punishable under section 12 and 18 of DV Act. And 498A and 506.
Who are the petitioners?
When 1 to 4.
A1 no husband, huh?
Yeah.
2, 3, 4.
2 mother. 3 and 4 brothers. So petition number 1.
ಏನು ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಹಾಕಿದಾರಾ ಡಿವಿ ಆಕ್ಟ್ ನಲ್ಲಿ?
ಎಸ್. ಅದಾದ ನಂತರ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಹಾಕ್ತಾರೆ ಅಟ್ ಸುಳ್ಯ. ನೆಕ್ಸ್ಟ್
ಇದ್ಯಾಕೆ ಕ್ರೈಮ್ ನಂಬರ್ 7 ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಆಯ್ತು?
498.
That is another complaint.
ಹೌದು.
Initially DV Act.
ಹೌದು.
First. Criminal miscellaneous 19 of 20. ಏನು ಯಾವ್ದು ಸೆಕ್ಷನ್ ಅದಕ್ಕೆ?
Please, ma'am.
ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ನಲ್ಲಿ ಯಾವ ಪ್ರೊವಿಷನ್?
Criminal miscellaneous, section 12 and 18 of DV Act.
ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್.
ಹೌದು. ಅದಾದ ನಂತರ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಹಾಕ್ತಾರೆ. While granting the decree of divorce.
Date of marriage?
Date of marriage, my lordship, 10/11/2019.
Any children born out of the marriage? ಮಕ್ಕಳಿದಾರ ಅಂತ?
ಇಲ್ಲ ಇಲ್ಲ. ಡಿಗ್ರಿ ಆಗ್ತದೆ, ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿಯಲ್ಲಿ ಡಿಗ್ರಿ ಆಗ್ತದೆ. ಇನ್ ಪೇಜ್ ನಂಬರ್
ಏನ್ ಡಿಗ್ರಿ ಆಗುತ್ತೆ? ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್.
ಡಿಸಲ್ಯೂಷನ್ ಆಫ್.
ಅದರ MC ನಂಬರ್?
MC number 12/2021.
12/21. Filed by?
Filed by the husband and wife, both are compromised. In page number 87.
ಅದಕ್ಕೆ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು.
ಅಲ್ವಾ?
ಹೌದು.
ಹೇಳ್ಬೇಕು.
Please.
ಯು ಆರ್ ಅನ್ ಅಡ್ವೊಕೇಟ್. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಗೆ ಇರ್ಬೇಕು.
Please.
ಇದು ಯಾರೋ ಹೇಳಿದಾಗೆ ಇದು ಅದು ಹಾಕ್ತಾರೆ ಇದು ಹಾಕ್ತಾರೆ ಅನ್ನೋದಲ್ಲ.
Please. Page number 87, my lordship. Annexure J.
Decree of divorce was granted.
Granted.
By mutual consent.
Please, ma'am.
ಅದನ್ನೇ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಇದ್ದಾರೆ ನೀವು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರೆ. ಅದರಲ್ಲಿ ಇವಳು ಹೇಳ್ತಾಳೆ.
ಅದು ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲ, ಅದು ಡೈವೋರ್ಸ್ ಬೈ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್.
ಅಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಆಗುತ್ತೆ ಅದರಲ್ಲಿ.
ಅಲ್ಲಿ
ಇನ್ ಪೇಜ್ ನಂಬರ್ annexure H, page number 82, my lordship. 82. Senior civil judge and JMFC Sulya. And page number 87, my lordship.
ಈ DV Act ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ 19 ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ವಿ?
19 ಅದೇ. ಇನ್ ಪೇಜ್ ನಂಬರ್.
ಡೇಟ್ ಗೊತ್ತಿದೆಯಾ?
ಹೌದು. annexure A.
ಎಲ್ಲ ಹುಡುಕಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ 6 ಗಂಟೆ ಆಗುತ್ತೆ.
annexure A, my lordship, page number 20. DV Act 12/18. Intersection 12 and 18 DV Act. Page number 20.
What happened to the DV Act petition? You come prepared, sir.
Please.
Please start.
Serial number 15, Anumanta Parve. 15.
Counsel for the petitioner is absent, no representation. Next.
Serial number 16, Vandana PL, Manjunath Prasad.
Here for the respondent in this case.
Vandana PL.
Counsel for the petitioner is absent, no representation. Counsel for respondent is present. List off.
17, Venkatesh Nayak, Sheila Krishna.
That's appearing for the respondent in this matter. I would like to file the memo for production of the trial court's order, my lords. The matter was dismissed for non-prosecution, my lords.
Which one?
The trial court matter.
Before trial court was what was there?
TC 2932 of 2016.
For what offense?
My lords, it is dismissed for non-prosecution from our side only, my lords.
138 NI.
138.
Already dismissed.
Yes.
So this petition is rendered infructuous.
Yes.
Counsel for the petition, respondent. Counsel for the petitioner is absent, no representation. And the counsel for respondent filed a memo producing the copy of the order ಇದು ಯಾವಾಗ ಡೇಟ್ ಯಾವಾಗ ಇದೆ?
29/12/2022.
29,
29/12/2022.
2022. In CC 292.
First additional civil judge JMXT Mysore.
On the file of the Learned First Additional Civil Judge in JMX Mysore and submits that the criminal case for the offense under section 138 of NI is already dismissed for default, that is for non-prosecution, and therefore the present petition is rendered infructuous. Memo and the submissions are placed on record. Petition is dismissed as the same is rendered infructuous. Next.
Serial number 18.
Please.
Suyogede, R. Ravi.
For petitioner counsel. Last time when we filed synopsis, the other side was not appearing.
Sorry.
I think it is also noted in the order sheet also. Because lost interest also, because my lord, it is a case where initially divorce was granted. After lapse of 2 years, she challenged the divorce by mutual consent. Then, my lord, she files a case before SC/ST commission.
Petitioners are accused numbers.
My lord, petitioners are accused number 1 to 7. And in that, my lord, accused number 3, petition number 3 and 4 are no more. During the pendency of the petition, they passed away.
One to 7.
Petitioner number, accused number 1 to 7. Lord, there are 7 accused. Now, petitioner number 3 and 4 passed away, my lord. That is to say, accused number 2 and 3. Lord, the petitioner number 1 is the husband of the respondent number 2.
Yes.
Petitioner number 2 is the present wife. Lord, after divorce, she got married the second petitioner.
Yes.
Now, petitioner number 3 and 4 are parents of the petitioner number 1. They are now no more, my lord. But,
Then 5.
5, 6 and 7, my lord, the parents of the present wife and brother.
Present wife petition number 2 and Tandrala.
Present wife is petitioner number 2, my lord. Now the petitioner number 5 and 6 are parents of petitioner number 2. In-laws, that is to say. I mean to say, my lord, present in-laws.
Yes. Then 7.
7 is a brother, my lord, of the petitioner number 2. Brother-in-law of petition number 1.
What are the offense alleged?
The offense alleged is, my lord, section 120B, 354 and 416 read with 34 IPC. May I request your lordship to, my lord, take the synopsis for the convenience, my lord. Last time could it be? There are many dates, my lord, events that may be necessary. Lord, 13/8/2006, their marriage was solemnized. Petition number 1 and, my lord, the respondent number 2.
Yes.
Thereafter, my lord, after lapse of 5 years, on 27/5/2011, my lord, a matrimonial dispute, that is MC number 1687 of 11, that was filed, my lord, was withdrawn. Thereafter, my lord, on 18/6/2013.
No, this MC is under which provision?
But initially, provision. But that was also, my lord, under that petition copy has not been produced, my lord, but it is only a incidental fact, my lord, where that petition was withdrawn.
No, what is the relief claimed in that?
Divorce only, my lord.
Filed by?
Husband only. Petitioner number 1.
Then that is.
Then it was withdrawn. On the because of the mediation and all, with the words given, my lord, to adjust and, my lord, settle the dispute. Then, my lord, the dispute did not settle, my lord. Again, on 18/6/2013, a petition under 13(1) clause IA and section 1 and 3, clause 3 of the Hindu Marriage Act was filed before the family court, my lord. Then on 6/7/2015, it was referred for mediation. Report was also called for. Then my lord, on 8/7, report was also, my lord, submitted on 11/8. And my lord, it was settled that, my lord, 30 lakhs one time as a one-time measure, my lord, and payment was DD was handed over in the court. That was acknowledged. And my lord, on the same date, my lord, at document number 5, the divorce was, my lord, granted by mutual consent.
MC was allowed.
MC was allowed. That is MC 2484 of 13, my lord.
Yes.
Now the next dates are very
That is on 11/8.
11/8/2015, my lord.
Yes.
But after lapse of 2 years, my lord, all these incidents, my lord, started. That is how it is a clear case of abuse of process of law. On 6/2/2017, after lapse of 2 years from the decree of divorce, my lord, their marriage, the petitioner number 1 and 2 got married. Immediately after marriage, my lord, the controversy started. On 18/6/2017, Lord, she started, respondent number 2 started, my lord, harassing the petitioner. And a complaint was lodged, my lord, which was registered as NCR in 568 of 2017 on 18/6/2017, Lord, at page 3.
What is the allegation in that?
Lord, the allegation is, my lord, the page 62, my lord. She alleges, my lord, harassment. Then, my lord, he alleges, my lord, harassment by the ex-wife at page 61 and, my lord, 62 is the acknowledgement. ನನ್ನ ವಿಚ್ಛೇದನ ಪಡೆದಿದ್ದೇನೆ, ಆದರೂ ನನ್ನ ಮಾಜಿ ಪತ್ನಿ ಲತಾ ಚೌಡೇಶ ಪದೇ ಪದೇ ನನಗೆ ನನ್ನ ಕುಟುಂಬಕ್ಕೆ ಜೀವ ಬೆದರಿಕೆ ಜೊತೆಗೆ ಕೆಟ್ಟ ಪದವನ್ನು ನಿಂದಿಸುವುದು ಬಿಟ್ಟಿಲ್ಲ. 18 ಈ ದಿನ 18
by accused number 1.
ಹೌದು,
Accused number 1.
ಹೌದು, ಕಂಪ್ಲೇಂಟ್ ಬೈ accused number.
Against respondent number 2.
Yes, my lord. After his marriage, my lord, she started interfering. Petitioner number 1 and 2 the marriage ಆದ್ಮೇಲೆ respondent number 2 started interfering in their life. Then, my lord, the police, my lord, treated it as, my lord, NCR, left with no option, my lord. The petitioner number, all these petitioners, my lord, they filed suit in OS number 5350 of 2017, seeking permanent injunction restraining the respondent number 2 from trespassing to the residence of the petitioner.
All
and
the
that
petitioners are plaintiffs?
Yes, my lord. But ultimately that the suit was decreed, my lord. That decree, the judgment and the decree is at page 24 of the memo for production of document.
Whether that suit was contested?
She filed written statement. Thereafter, she didn't turn back. Now, my lord, the injunction was granted on 22 April 2024. In the meantime, there was a undertaking given by her in a MFA, my lord, that she will not interfere. But subsequently, now the suit has been decreed. Now, thereafter, my lord, as an afterthought, on 14/7/2017, she files a complaint before the SC/ST Commission, Bengaluru. Lord, that is document number 14 at page 101. Alleging that, my lord, she belongs to SC community and petitioner belongs to other community, and Lord, they ill-treated, all these things, my lord, the allegations are. My lord, come back this issue, my lord. This honorable court has quashed that proceedings. Initially, it was stayed, then subsequently it was quashed.
Crime number?
No, it is not crime, my lord. It is commission, before the commission. She wanted to take cognizance by the commission. She gave complaint to the commission, and commission issued notice also.
So that was quashed.
That has been now quashed, my lord. Lord,
When?
Lord, on 24/8/2017, my lord, at page 4 of the synopsis.
24.
24/8/2017, we submitted a reply. Then, my lord, on 18/9/2017, this honorable court, my lord, stayed the proceedings before SCST commission. And ultimately, my lord, petition but that order is that order dated 3/6/24, SCST commission proceedings were quashed. Document number 22.
3/6.
Please, my lord. Now, my lord,
3/6/24.
page
3/6/24.
3/6/24, my lord.
Yes. Then
my lord, she files the present PCR on 21/10/2017. After the, my lord, commission's proceedings were stayed, she files this complaint, present PCR. And this honorable court, my lord, after hearing, granted interim order. There is no compliance of Priyanka Srivastava, mechanically, my lord, referred for investigation. All these grounds are there. Therefore, my lord, matter was stayed.
Stayed in which matter?
In this matter, my lord, in this matter, the present. My lord, this was on 21/10/2017. The matter was referred for investigation. No, interim order was granted. But after this, on 2/12/2017, she files MFA, challenging the mutual consent divorce decree. So decree of divorce was challenged, my lord, after lapse of 2 years.
On the ground?
On the ground that, my lord, petitioner number 1 has committed fraud, she was misled, lord, all these vague allegations.
Now, what is the ground in this case?
Lord, thereafter, my lord, at page 5 of the synopsis, my lord. Lord, the MFA, my lord, came to be dismissed as not maintainable on 18/1/2019. Then she filed a writ petition challenging the mutual consent order. My lord, the maintainability issue was there in the MFA, my lord. She kept it in, my lord, office objection stage for, my lord, almost 2 years. Then ultimately MFA was dismissed on 18/1/2019 with liberty to, my lord, challenge in accordance with law. Then she files a writ petition challenging the same mutual decree, my lord, mutual consent decree. Then that writ petition also dismissed by this honorable court, my lord. Then, my lord, this suit was decreed. Injunction was granted against, my lord, the respondent. But ultimately, thereafter, my lord, the writ petition 43022 of 2017, challenging the SC/ST commission order, my lord, proceedings, that was allowed. On 22/4/2024, my lord, the injunction was granted, permanent injunction against the respondent number 2.
Now, what are the grounds?
And now the decree of divorce, my lord, ended complete finality, my lord. That is to say, my lord, MFA dismissed on the ground that with the liberty to file writ petition. Now writ petition also dismissed. Ultimately, my lord, the divorce by mutual consent has attained finality. Thereafter, my lord, the proceedings initiated before SC/ST commission also, my lord, quashed by this honorable court.
Supreme Court ಹೋಗಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ.
Now, therefore, my lord, the continuation.
This decree of divorce dated
11/8/2015. Page 2 of the synopsis. 30 lakhs she takes, my lord, acknowledges, she signs the order sheet,
Paid through DD.
DD. That is also noted in the order sheet of the family court. Lord, may I request the court to just, my lord, consider this document number 2, my lord, or document number 19 in the memo dated 17 December, my lord, memo for production of document.
ಅಲ್ಲ ಈಗ ಇದಕ್ಕೇನು ಗ್ರೌಂಡ್ಸ್ ಏನು
So ಇದರಲ್ಲಿ grounds are, my lord, the allegation is vague, bald, and, my lord, the frivolous. Number 1. After 2 years of mutual consent decree of divorce, the frivolous complaint has been filed, my lord, in order to harass and humiliate the petitioners.
Yes.
As a afterthought, my lord, as an unsuccessful, my lord, the litigant pursuing the proceedings before SC/ST commission, then, my lord, before the MFA court, this honorable court, multiple and parallel proceedings before various authorities, the same amounts to abuse of process of law.
ಅದನ್ನೇನು ರೆಫರ್ ಮಾಡಿದಾರಾ?
PCR has been referred for investigation.
No further investigation.
Illa. There is no affidavit filed along with the petition, PCR. Priyanka Srivastava not complied, my lord. Magistrate mechanically refers this to investigation. There is no, my lord, document to say that, my lord, they have lodged prior complaint to the police. She has lodged any complaint, and police refused to register FIR. No such averment or not the material.
Yes, what is?
On the basis of PCR, the learned magistrate order, FIR registered, then stay.
Yes. What?
But one observation, my lord, in the writ petition by the coordinate bench about the conduct and the litigations, how this is an abuse of page 21 of that memo, that may be useful for the purpose, my lord. Memo for production of documents, my lord, dated 17th December. Otherly page 21 onwards. This is, my lord, order in the WP 1117 of challenging the decree of mutual consent. Document number 20 in the mark.
Yes.
Otherly page 21, para 15, my lord.
Yes.
The last 3 lines. It is when the respondent shifted the house in the month of May 2017, petitioner learns about remarriage of the respondent, and therefore all the proceedings are initiated. The allegations between the wife and husband may be manifold. Once the issue is settled before the court, and after the court recording the statement of the parties, merely because the respondent remarries, the petitioner cannot be seen to call in question the settlement itself on whatsoever ground, except it being fraud. I do not see any demonstration of fraud in the entire petition. What was triggered the petition?
Yes.
This is the abuse of process of law. What the coordinator.
Lord, R2 is the contesting party. She is the object.
Yes. The petitioners, accused numbers 1 to 7. In PCR 58902 of 2017 on the file of ಯಾವ ಕೋರ್ಟ್ನಲ್ಲಿದೆ ಇದು PCR ಅಡಿಷನಲ್ ಚೀಫ್ ಮೆಟ್ರೋಪಾಲಿಟನ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಬೆಂಗಳೂರು crime number 603 of 2017 of which police station
ರಾಮಮೂರ್ತಿ ನಗರ PS.
ರಾಮಮೂರ್ತಿ ಅವೆಲ್ಲ ಲಾಸ್ಟ್ ಪಾರದಲ್ಲಿ ಬರಬೇಕು ಡ್ರಾಫ್ಟ್ ಮಾಡೋರು ಏನು ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಯಾವುದು ಅಂತ ಇಲ್ಲ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಇಲ್ಲ ಅಫೆನ್ಸ್ ಏನು ಅಂತ ಇಲ್ಲ for the offense under section 120B 354 505 401 read with section 34 of IPC are seeking to quash the criminal proceedings initiated against them during the pendency of the petition number accused number 2 and 3 reported to have died and the petition filed by them stands abated. Third so respondent number 2 remained absent in spite of service of notice. The materials learned senior advocate for the petitioner drawn the attention of the court to various documents that are produced before the court along with the dates and events mentioned in the synopsis. The materials on record disclose that petition number 1 married respondent number 2 on 13/8/2006. During 2011, petition number 1 filed MC 1687 of 2011 before the family court at Bengaluru seeking dissolution of his marriage with respondent number 2. They stated that said petition was subsequently withdrawn at the instance of the elders. However, the relationship between the parties has not improved and therefore petition number 1 filed MC 2484 of 2013 before the family court at Bengaluru seeking dissolution of his marriage under section 13(1), again 1A and section 1(3) of Hindu Marriage Act on the ground of cruelty. Family court on the ground of cruelty. By mutual consent, the decree for dissolution of marriage was passed as petition number 1 paid rupees 30 lakhs to respondent number 2 through DD dated 6/8/2015. The decree of dissolution of marriage in MC 2484 of 2013 was scheme to be passed on 11/8/2015. Strangely, next part. It is stated that petition number 1 married accused number 2 on 6/2/2017. It is thereafter respondent number 2 said to have started harassing petition number 1 and therefore he filed a complaint with the police. Which is registered in NCR 568 of 2017. In the meantime, the petitioners have filed the suit OS 5350 of 2017 against respondent number 2 seeking permanent injunction. Except filing written statement, respondent number 2 had not contested the matter and ultimately the suit was came to be decreed and the permanent injunction was granted against her. In the meantime, respondent number 2 appears to have filed a complaint before SCST Commission, Bengaluru, making allegations against the petitioners. This court, with a order dated 21/9/2017, this court, with a order dated 3/6/2024, allowed WP 43022 of 2017 filed by the petitioner and quashed the proceedings initiated by respondent number 2 before SCST Commission. In the meantime, respondent number 2 filed the present complaint in PCR 58902 of 2017, alleging commission of the offence punishable under section 120B, 354, 416, read with section 34 of IPC. The learned magistrate referred the complaint for investigation. Being aggrieved by the same, the petitioners are before this court. It is the contention of the learned senior advocate for the petitioner. There is a non-compliance of the requirements and non-compliance of the directions issued by the apex court in Priyanka POCSO of citation. There is no allegation that that respondent but who had approached the police by filing the complaint. No affidavit is supporting the private complaint. Ignoring these facts, the learned magistrate referred the matter for investigation. This contention of the learned senior advocate is not countered in any manner. Next paragraph. The materials on record discloses that after dissolution of marriage of petition number 1 with respondent number 2, by mutual consent, by accepting rupees 30 lakhs through DD, respondent number 2 had made an attempt by filing MFA 9162 of 2017, seeking to set aside the decree of divorce passed by the trial court. The said MFA was came to be dismissed, and subsequently the writ petition 1172 of 2019 was filed by respondent number 2, seeking to set aside the dissolution of marriage on the basis of memorandum of settlement dated 7/8/2015. Even the said writ petition was came to be dismissed with a order dated 2/1/2023. My attention was drawn to the order dated 18/1/2019 passed in MFA 9162 of 2017 by the division bench of this court, where there is a where the court the division bench has recorded that it is only when petition number 1 married petition number 1 remarried after dissolution of the marriage with respondent number 2, respondent number 2 started questioning the validity of decree of divorce dissolving her marriage with petition number 1. The court has recorded a categorical finding that division bench of the division bench ಅಲ್ಲ coordinate bench ಎಲ್ಲ ಕಡೆ ಅದು MFA ಅಲ್ಲ WP 11172 ಮೇಲೆ ಏನೋ ಬಂತು division bench ಅಂದಿದ್ದೀನಿ ಅದು single bench coordinate bench dismissing WP 11172 of 2019 order dated 2/1/2023. My attention was drawn on the matter. Up to 2/1/2023. Passed in WP number 11172 of 2019, where the coordinate bench formed an opinion finding that it do not see any demonstration of fraud in the entire petition. It also recorded its opinion that the petition is the result of also expressed his opinion that what was triggered the petition is the remarriage of petition number 1 after dissolution of his marriage with respondent number 2. Next part. The materials on record disclose that dissolution of marriage of petition number 1 with respondent number 2 has reached finality, even though respondent number 2 has challenged the same by filing miscellaneous first appeal and again the writ petition. The complaint filed by respondent number 2 before the commissioner, SCST commissioner, commission was also came to be quashed by this court. Bold and general allegations are made by respondent number 2 in the private complaint, which do not constitute any offence. Therefore, it is clear that respondent number 2, after getting the decree of divorce, after accepting rupees 30 lakhs in cash through DD, made an attempt to set aside the said decree. She failed in her attempt, made a complaint before the CH-20 commission. There also she failed in her attempt, and now the private complaint is came to be filed, roping in accused number 1 to 7. It is a clear case of abuse of process of law. Therefore, I am of the opinion that in this the criminal proceedings is liable to be quashed. Including the answer is allowed.
Grateful.
Yeah, 18 ಈಗ ಆಗಿದೆ ಅದು ಆಯ್ತು ಅದು ಯಾವುದೂ ಆಗಿಲ್ಲ ಇಲ್ಲ ಮಂಡೇ ರಿಪೀಟ್ ಮಾಡಿ ಆಗಿದೆ ಯಾವಾಗಾದ್ರೂ ಪಾಸ್ವರ್ಡ್ ಯಾವುದಿದೆ ಕರಿ
Procedural matter, serial number 4, A Sampath.
It's gone through the document, my lord. They took signature and got it identified that it belongs to my tablet belongs to me and it's manufactured by me. They have not given the sample, my lord.
Sample are not supposed to be given to the manufacturer, my
No,
lordship.
but you collected 4 portions.
Please, my lordship. One portion was given where the this one sample was drawn, my lordship, and the second portion was given to the warehouse from where the retailer, my lordship. Since it's a government warehouse, it has been given to the third portion, my lordship.
ಒಂದು ಕೋರ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ರಿ.
One second portion was given sent to the lab, my lordship, under
Lab ಗೆ
form
ಹೋಗಿದೆ.
Form 18, my lordship. They are supposed to challenge that report, my lordship. Then only that sample will be sent to the central laboratory, my lordship. They have not challenged that report, my lordship. Lab report.
Lords, even if report is not said, that the judgment of the Honorable Supreme Court, even the report is not challenged, they have to give the sample, my lord. My lord, that Supreme Court, Honorable Supreme Court judgment that.
ಕೇಳಿ ರೈಟಿಂಗ್ ನಲ್ಲಿ ಕೇಳಿ ಕೊಡಿ ಅಂತ.
My lords, Lords, I checked with them, my lords. What I enclosed, that is responding to one of the letter, my lord. I got it now. Avatte we are given it, my lords. But there is no acknowledgement. But they say it's with their custody. It's divorce of, my lord. I challenge it or not, my lord.
With the court permission, they can seek, my lordship. With the court
ಈಗ
permission.
ನಾವು you are before the court.
Please,
ಅಲ್ಲೇ ಕೇಳ್ಬೇಕಲ್ಲ.
no, my lords. Divorce, my lord. That
ಕೋರ್ಟ್ ಹತ್ರನೂ ಒಂದು ಸ್ಯಾಂಪಲ್ ಇರುತ್ತಲ್ವಾ.
court to sample. But, my lord, the point now, my lord, the shelf life of the tablet is expired. No, my lord, divorce of, my lord.
Wrong ಅದು. Unnecessarily you approach this court.
No, my lord.
2017 ಇಂದ ಇವತ್ತಿನವರೆಗೂ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ರಿ. Interim order ಇದೆ, stay.
There is no interim order.
No. Then what is the stage before the trial?
Let's say I've been check await report, await orders.
Await orders ಅಂತಾನೆ ಬರ್ತಾ ಇದೆ, my lordship ಅದರಲ್ಲಿ.
Interim order ಇಲ್ಲದೆ ಇದ್ರು ಏನು what is to be awaited?
No, my lords.
ನೀವೇ ಹೇಳಿರ್ತೀರಿ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಇದೆ ಅಂತ.
ಇಲ್ಲ.
Threatening the magistrate.
No, my lords.
ಮತ್ತಿನ್ನೇನು? That is what it is happening.
No, my lords.
No stay, nothing. ಅಲ್ಲಿ ಹೇಳೋದು ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಇದೆ ಅಂತ.
ಇಲ್ಲ, ನಾವು ಕೇಳಿದ್ವಿ ಸ್ವಾಮಿ, ಆತರ ಏನು ಅವರು ಹೇಳಿಲ್ಲ. ಬಟ್ my lords, in this case, my lords may just
I may have to make very serious observations.
My lords, even I'm sorry, my lord, regarding that. Let's say on 8/4/2017, my lord, there was interim order was granted. No, my lord, that was not extended, I believe, my lord.
Then you should fairly concede before the trial court that there is no stay. ಮತ್ತೇನು await orders? There is the question of awaiting orders.
Please, my lord, initial ಇಂದ ಹಂಗೆ ಹೋಗ್ತಿದೆ, my lord. Even
initial ಹಾಗಲ್ಲ ಅದು, unless you make such submission court ಮಾಡಲ್ಲ ಅದು.
Please.
ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಹೇಳಿದ್ರು ಕೇಳಲ್ಲ. ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಇದೆ, ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಏನಿದೆ, nobody knows. That is how you are misusing ಅಷ್ಟೇ.
ನಮ್ಮಲ್ಲಿ ಸಿ ಕೇಸ್ ಎಲ್ಲ ಆತರ
ಎಲ್ಲ ಆಯ್ತು ತಗೊಳ್ಳಿ.
No, my lords, I'm sorry, my lords. My lords, that point, my lord, will not, my lords.
ಇಲ್ಲ
My lords,
ಅದು ಅವರು ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
No, my lords, may just I may be permitted to make this submission last. My lords, divorce, I challenged it or requested it not, my lord. The law mandates that they have to give it to me, my lords. My lords, may just again trouble, my lords, reading these, my lords, how the
ಅದೆಲ್ಲ ಗೊತ್ತಾಗಿದೆ ಸರ್. According to the prosecutor that there is compliance of the procedure.
No, my lord, that is
portions were collected, one to the petitioner, one to the lab, one to the retailer warehouse, one to the court.
No, my lords, 4 portion is not collected is submission. My lord, none of the letters I checked it, my lord, 4 portions ತಗೊಂಡಿನ ಅಂತಿಲ್ಲ. Plus may just lords may very, plus I also got it. Now
ಎಲ್ಲಿದೆ ಇದು ಪಂಚನಾಮ ಇಲ್ವಾ?
ಪಂಚನಾಮ ಇಲ್ಲ,
my lordship.
No, my lord.
I have marked and kept it here, my lordship. Everything is
4 portions ಅಂತ ಹೇಳೇ ಇಲ್ಲ ಸ್ವಾಮಿ. No, one of the letter they did not say nothing.
If she is able to show it,
please, my lord, the letter, my lord, what?
Take it very seriously.
No, my lord, the letter, my lord, what's? Please, adli nan tagonde, but one letter, my lords, they say. Please, my lord, one that letter, my lord, they say only given to the retailer, and that copy of the letter is given to me.
Retailer ಗೆ ಹೋಗಿದೆ.
Please,
lab ಗೆ ಕಳಿಸಿದ್ದಾರೆ.
Court ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. To me, my lord, not been given.
My lordship, when the letter was sent to the retailer, CC has been sent to them also. If there is any dispute, please approach within 28 days. It is clearly mentioned, my lordship. They have not approached at all. I'll show you.
ಅವಾಗ ಇವರು ಇರ್ಲಿಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಅವ್ರು ಸುಮ್ಮನೆ ಆದ್ರು. ಅಡ್ವೊಕೇಟ್ ಇದ್ದಿದ್ರೆ ಅದು ಮಾಡ್ತಿದ್ರು.
ನಮ್ಮ lords, that letter my senior ಕೊಟ್ರೆ ಒಂದು ಲೆಟರ್ ಅಲ್ಲಿ they took only signature. ನಮ್ಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ ಕಾಪಿ. There's only
There is some.
not they like to identify whether it is manufactured from me or not, because it was collected from one of the hospital ಇಂದ collect ಮಾಡಿದ್ದಾರೆ.
Accept ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ.
ಇಲ್ಲ ಮಲೋಡ್ಸ್, that's a reality ಮಲೋಡ್ಸ್. If it is not other case ಮಲೋಡ್, I would not trouble, but ಇದರಲ್ಲಿ
The disputed question go before the trial court. You are showing one certificate. It is of standard quality.
Malods, that certificate Malods is obtained by us when they inform that Malod this like Malod that my tablets is
So
wrong.
what was sent to the lab then?
Malods, my own product, my tablet was sent separately Malod for to check whether my tablets are wrong. I sent it Malods. No Malods, what on two.
Advised you.
And a particular
Malods,
batch
I got
number-
this letter. Malod, I'll just one of the communication I'll just take. Malod, this letter is dated 12/1/2015. Our letter we are responded to Malod in the.
Even if your contention is to be considered,
Please.
There is a disputed question of fact.
No, Malod,
That is to be considered by the trial court, not a ground for quashing.
No, Malod, 4/2/2015 Malod letter Malod. ಅದರಲ್ಲಿ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ that letter only I will trouble. 4/2/2015 Malod file ಅಲ್ಲಿ ಇದ್ರೆ.
ಏನ್ letter?
Malod, they gave the sample. Just identify ಮಾಡಿ ಇದು ನಿಮ್ ಟ್ಯಾಬ್ಲೆಟ್ ನಿಮ್ಮಿಂದ
That is the
ಸಪ್ಲೈ.
fourth
No, I'll
sample.
just complete.
That is the fourth sample, my lordship, which was produced to them, whether it belongs to you. They have completely identified and with the acknowledgement given. That
I
is
said
page number
it's-
87. It is there, my lordship, in that record.
I said this belongs to me, but copy has not been given. Malod, I'll just take this Malod. A 12/1/2015 letter once ನೋಡಿ so to retailer how they gave it Malod 12/1/2015 Malod. To the retailer Malod, the warehouse in charge district Malod. The last two paras Malod has required under section 25(2). To retailer Malod, they gave a sample, they gave a report, but sample has not been given to me. But what they give it to me is 4/2/2015 Malod. So that they also addressed one of the letter Malod, which is at page 85, which is dated Malod 2/2/2015 Malod. It is addressed to me. Malod, I've been only asked to give the details of the company. Malod, one more Malod. E point ಇಲ್ಲ ಅಂದ್ರೆ another point Malod.
ಯಾವುದು ಇಲ್ಲ ಸುಮ್ಮನೆ.
Malod, sample ಕೊಟ್ಟಿಲ್ಲ Malod. Last 1.1 ಇನ್ನೊಂದು I'm sorry Malod, the accused number 2 and 3 not the person who was in charge Malod. ಅವರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ they are not in charge.
Prove ಮಾಡಿ trial court ಗೆ. For control and HGP opposing the petition submitted that. Petition number 1 is the manufacturer, 2 is the managing director, 3 is the authorized signature.
Please Malod, the complaint ಅಲ್ಲಿ Malod, the person who was responsible ಅವ್ರ ಮೇಲೆ responsible ಅಂತ ಹೇಳ್ತಾರೆ.
None of them are responsible.
Malod, the person who was day to day in charge Malod,
ಯಾರು appoint ಮಾಡಿದ್ದೀರಾ?
Malod, accused number 1 is liable, but 2 and 3 is not liable. That's what Malod, a complaint ಅಲ್ಲಿ Malod, they themselves says Malod, they are responsible ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. Last page 20 Malod, I'll just request page 20 of the company. Last Malod, I will not trouble.
20 of the
petition Malod, the complaint Malod, it is a complaint government. Malod, number C Malod. THV Narsimal is approved manufacturer chemist of A1 firm and is responsible for manufacture of a subject drug, and Sri Madina Basha is an approved analytic chemist of A1 is of A1 firm responsible for analysis of the subject. However, whereabouts of these persons could not be traced and their statement could not be obtained during the investigation. No, they are responsible. They gave a letter to, they addressed a letter to them. That Malords find it
No,
page
you are
19.
not disputing the capacity of this petition number 2 is being the managing
Yes,
director.
we are the man, but Malord, section 34, Malord, please Malord.
Number 3 being the authorized.
Malord, he is only signature, authorized signature when the investigation is going on. Malord, I was in the in charge when they come up with the material saying that there is a complaint. So on that, Malord, I assisted, I gave the documents. I'm only authorized signature, Malord. I'm not at all, I'm not even analyzing.
Provision of law you are seeking.
Malord, section 34 of the Drugs and Cosmetics Act. 34. my lord.
Yes.
Offences by companies. Where an offence under this act has been committed by a company, every person who at the time the offence was committed was in charge of and was responsible to the company for the conduct of business of the company, as well as the company, shall be deemed to be guilty of the offences and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in subsection shall render any such person liable to a punishment provided in this act if he proves that the offence was committed without his knowledge. My lords, took adu ಏನ್ ಬರಲ್ಲ. But my lord, the person who was in charge, my lords, the honorable coordinate bench also,
Who was in charge?
my lords, that is my lord, the THV Narsimhan and Madina Basha.
Because both of them are not there.
No, my lord, they issued a communication, it was served, they did not respond, my lord.
Sir, managing director is not in charge.
Was managing director, but the offense committed, my lord, he was not connected to day-to-day affairs, my lord, because it has to be done by, my lord, the chemical analysis, my lord, chemical analysis and the manufacturer, my lord. My lord, that is just trouble with one of the honorable coordinate bench judgment, my lord, because in which, my lord, directors were arrayed.
Directors I can understand.
My lord, I am the
As all the directors are not parties.
As per my instruction, my lordship, unless until chemical analyst approves, the product will not go out of the factory, my
So
lordship.
that is why they are the chemical analysis. My lord, they say they are the responsible, but since their whereabouts is not, their whereabouts is also available, but our plus I given the letter, they sent a letter, my lord. That letter, my lords, I just
Not absolve you, sir. If he is available, he is also responsible.
accused number 1, my lords.
That ಅವ್ರಿಲ್ಲ ಅಂತ ನೀವೇನ್ ಮಾಡಿದಾರೆ ಅಂತ ಅಲ್ಲ.
ಇಲ್ಲ, my lords, accused number 3 is only signatory, my lords. He when, my lords, your letter
ಅಂತಂದ್ರೆ why he should sign?
My lords,
ಸಿಗ್ನೇಚರ್ ಇದೆ ಅಂತ ಸೈನ್ ಮಾಡ್ಬೇಕಾ?
my lords, ಅವ್ರ ನಮ್ಮಲ್ಲಿ
He is responsible, he is the signatory.
my lords, at the time of offense ನಾವು ಇರ್ಲಿಲ್ಲ, so my lords, page 3 ಅಲ್ಲಿ they only say, my lords, they issued a notice also to those persons, my lord, response ಬಂದಿಲ್ಲ ಅಂತ they want.
Matter of trial only.
The honorable coordinate bench.
Send bus rate ಮೇಲೆ ಬರಲ್ಲ. ತಗೊಳ್ಳಿ. The petitioner. Sorry. CGP opposing the petition submitted that all the procedure as contemplated under the Drugs and Cosmetics Act 1940 are complied in letter and spirit. 4 portions of the samples were drawn by the drug inspector. One was given to the retailer. One portion is produced before the court. One is sent to FSL and the other portion is sent to the petitioner. Copy of the letter addressed to the retailer / manufacturer is also forwarded to the petitioner, asking the petitioners to approach the complainant within 28 days if they are having any grievance. They never approached the complainant with any grievance. She contends that the petitioners have not raised any of these contentions even before the trial court, even though there is no stay granted by this court which is operating. The petitioners managed to stall the proceedings before the trial court without any reasons. The sample that was sent to the laboratory was examined and the report discloses that the drug was not of standard quality. Therefore, the offence is made out. Hence, the petitioner is not entitled for any relief. There is the materials on the point for consideration negative for the following reasons. The drug inspector has drawn the sample for test and analysis in form number 17 on 14/8/2014. It is not in dispute that petition number 1 is the company which is manufacturing the drug in question. Petition number 2 is the managing director and 3 is this authorized signatory. The contention of the learned counsel for the petitioner that even though that the drug in question is being manufactured by petition number 1 is admitted, it cannot be said that petition number 2 and 3 were in charge and were responsible for manufacture of the drug. Such contention cannot be accepted at this stage. Merely because in the complaint there is reference to the drug analyst yes, Madina Basha, who is referred to as the approved analytical chemist of accused number 1, that will not absolve the responsibility of accused number 2 and 3. Next. The SCGP has produced the letter dated 12/1/2015 addressed to the warehouse in charge, District Drug Warehouse, Davangere, forwarding the sample reporting drawing of the sample, forwarding one portion for the laboratory, receipt of the report as it is not of standard quality, and also marking the said letter to petition number 1, calling upon it to have its say within 28 days. Admittedly, the petitioners have not approached the complainant with any grievance. The materials on record prima facie discloses that the drug inspector has followed a procedure as contemplated under law by drawing the samples as required and forwarding the same, drawing the sample and forwarding the same to the concerned as required under law. When the same is disputed by the petitioner, at the most it may be the defense that can be taken by the petitioners before the trial court. It is pertinent to note that the petitioners have not raised any of these contentions before the trial court, nor the petitioners have sought for sending the sample that is submitted to the court for referring it to the lab for analysis. It is also important to note that the petitioners have produced informal sample report along with the petition, according to which the sample of the drug was sent to Chief Scientific Officer, sent to Drug Testing Laboratory, Government of Karnataka, Bengaluru, and the Chief Scientific Officer said to have tested the sample and issued the certificate with the conclusion that the sample conforms to IP standard with respect to above test. When the petitioner has taken the precaution of sending the sample drug to drug testing laboratory, And getting the report, they could have disputed receipt of the sample, one portion of the sample, which they have not made. When there is a complaints of the requirements of law, to a great extent, the contention taken by the petitioners cannot be accepted to quash the criminal proceedings on flimsy grounds. However, petitioners are at liberty to raise the dispute, to take the defense before the trial court during trial. But the same cannot be a ground for quashing the criminal proceedings. Accordingly, I answered the above point. It's dismissed.
Serial number 6 is Rajshekhar.
Regarding the submission made by the learned counsel for learned HCGP, the trial court must be alert while deferring the trial, awaiting the orders from this court, mindful of the fact that there is no stay granted by this court. The trial court is very well. The trial court can very well verify the daily orders of this court through an NJDG number. ನಮ್ಮ daily orders website through our website to confirm that there is a stay of further proceedings before the trial court. Without doing any of those exercise, adjourning the matter indefinitely, awaiting the orders of this court, cause damage, cause prejudice to the complainant. Yes, next.
Is Rajshekhar.
R2, my lords.
In this notice has to be served upon respondent number 2, my lords. Against this accused number 3, the proceedings has been quashed by this honorable court only. But the allegations are quite different on the accused number 3, my lords. And upon these petitioners, the allegations are very serious. And they have assaulted the complainant in the presence of a police officer, my lords, in the police station.
What is the difficulty in serving the notice?
But my lords, very same address, my lords, earlier location would have served.
So according to her,
they have not furnished the
Please,
copies,
my lords.
my lords, and the PF.
Earlier, my lords, furnished, my lords, anyway.
no, according to her, there was no such serious allegations against the other respondent.
As she was
accused.
Please, my lords,
April,
I'll
and she
take
was
out the
aged about
first step.
21.
Please, my lords.
Take notice.
That memo, that time.
ಅದು ಬೇಡ ಅದೇ ಕೊಡಬೇಕು ಕೊಡಿ ಫ್ರೆಶ್ PF counsel for the petitioner pays for time to file and undertake to file a PF for issuance of notice to respond number 2.
Great.
If PF is paid, issue notice. Next. told.
Serial number 20, V. Manjunath, Gurraj Joshi.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ನಿಮ್ದು
5 to 10 minutes
ಅಷ್ಟೇನಾ ಅದು ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಐ ಮೇ ನಾಟ್ ಟೇಕ್ ಅಪ್ ನೋಡಿ ಅದು ಇದು ಕೊಡಿ ನೆಕ್ಸ್ಟ್
Interim orders will be extended.
Serial number 36, a date may kindly be given.
ಕೊಡ್ತಾರೆ ಮೇಲೆ ಎಲ್ಲ ಕೊಡೋದು yes. Please take the date from the court officer. Wherever interim orders are there, that will be extended. Yes. Who is the petitioner? Sole accused.
My lord, petitioner aggrieved by the order dated 19 July 2019
ಯಾರು ಇವರು ಪಿಟಿಷನರು?
Please, my lord.
ಪಿಟಿಷನರ್ ಯಾರು ಸರ್? ಅಕ್ಯೂಸ್ಡಾ?
Accused, my lord.
ಒಬ್ಬರೇ ಅಕ್ಯೂಸ್ಡ್?
ಒಬ್ಬರೇ accused, my lord.
ಏನು ಅಫೆನ್ಸು?
Offense under section 231A, read with 37 of the Air Act.
231.
1981. Regarding stone crushing company, you know.
21, 31, 37.
Yes, my lord.
231 ಎಲ್ಲಿದೆ?
231A, read with 37.
ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 21, 31 and 37 ಹಾಕಿದೆ. 2 ಎಲ್ಲಿಂದ ಬಂತು?
It was supposed to be 2, my lord, please.
ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲೂ 21, 31A, 37 ಇರೋದು.
Yes, my lord.
FIR ಆಗಿದೆ?
21 ಇದೆ ಸ್ವಾಮಿ, please.
ಮತ್ತೆ 2 ಎಲ್ಲಿಂದ ಬಂತು?
Yes, my lord. 21, 31A and read with section 37. my lord.
ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ಹೇಳೋದು ಅದು.
Lord, petitioner was running a stone crusher, having a license. July 13 the license ಇದೆ madam.
ಇದು ಏರ್ ಆಕ್ಟ್.
Please.
ಏರ್ ಆಕ್ಟ್ ಅಷ್ಟೇನಾ? ಏರ್ ಆಕ್ಟ್ ಅಂತ ಅಷ್ಟೇ ಇರೋದಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಹಾ?
ಹೌದು my lord.
ಹೌದಾ?
Yes, ma'am.
ಬರೀ ಏರ್ ಆಕ್ಟ್
Air Act.
ನೋಡಿದೀರಾ? ಅದು ಬೇರೆ ಆಕ್ಟ್ ಆದ್ರೂ ತೆಗೆದು ನೋಡಿದೀರಾ?
Air Act. Air Act ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಅಷ್ಟೇ.
Please.
ಬೇರೆ ಆಕ್ಟ್ ನೋಡಿದೀರಾ? ಪ್ರಾವಿಷನ್ ನೋಡಿದೀರಾ? ಅದನ್ನ ತೆಗೆದು ನೋಡಿದ್ರೆ ನೀವು ಸೆಕ್ಷನ್ 2 ಅಂತ ಎಲ್ಲ ಹೇಳ್ತಿರ್ಲಿಲ್ಲ.
Please, my lord. Apologies.
ಅಪಾಲಜಿ ಏನು ಸರ್? ಫೋನ್ ಇದೆಯಲ್ವಾ ನಿಮ್ ಕೈನಲ್ಲಿ? ಆಂಡ್ರಾಯ್ಡ್
ಇದೆ sir.
ವಾಟ್ಸ್ಆಪ್ ನೋಡ್ತೀರಾ ಇಲ್ಲ?
Yes, sir.
ಫೇಸ್ಬುಕ್ ನೋಡ್ತೀರಾ ಇಲ್ಲ?
ಹೌದು sir.
ಹಾ, ಅದ್ರಲ್ಲೇ ಒಂದು ಏರ್ ಆಕ್ಟ್ ನೀವೇನೋ ಹೇಳ್ತಿರಲ್ಲ, ಹಾಕಿದ್ರು ಬರುತ್ತಾ ಇಲ್ಲ?
ಹೌದು.
ಮತ್ತೆ ಅದು ಕಷ್ಟ ಆಗುತ್ತಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. Please.
It is not only Air Act. Air Act Prevention and Control of Pollution Act.
Yes, my lord.
ಅದು ನಿಮ್ ಪ್ರಕಾರ Air Act. ಏನು ಕ್ರಷರ್ ಇವ್ರದ್ದು?
ಹೌದು ಸ್ವಾಮಿ. They were running crusher. They had license July 8 July 2013 the license they had. In between license was lapsed, it was up for renewal. Actually, they have initiated complaint ಮಾಡ್ಬಿಟ್ಟು initiated proceedings 2016.
When the license lapsed?
It was there for 3 years, my lord.
ಆಯ್ತು, when it was lapsed?
14, 16. July 16th, my lord. 2016.
Thereafter it was not renewed.
It was up for renewal. It was not renewed as such.
When the complaint was filed?
Complaint was filed in the year 2019, my lord. Private complaint filed in 2019 after lapse of 3 years. They initiated all the proceedings. ಅದಾದ್ಮೇಲೆ 2019 ಅಲ್ಲಿ PCR ಫೈಲ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್.
ಏನು ಅಲಿಗೇಷನ್? From 16 to 19 you have not renewed the license.
18 ದಲ್ಲಿ ಮತ್ತೆ ರಿನ್ಯೂ ಆಗಿದೆ ಮೇಡಮ್.
ಎಲ್ಲಿದೆ ಲೈಸೆನ್ಸ್?
ಲೈಸೆನ್ಸ್ ಕಾಪಿ ಎನ್ಕ್ಲೋಸ್ ಆಗಿದೆ ಮೇಡಮ್. 19 and 20 page number. ನಲ್ಲಿ ರಿನ್ಯೂವಲ್ ಆದ್ಮೇಲೆ Deputy Environment Officer has filed a PCR without having any authority, my lord.
So according to you, as on the date of filing the private complaint, you had the license?
Yes, my lord. ಅಲ್ಲಿಂದ ಎಲ್ಲೂ ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲೂ ಗ್ಯಾಪ್ ಇಲ್ಲದೆ ಇಟ್ ವಾಸ್ ಕಂಟಿನ್ಯೂಸ್, my lord. 18 ಆದ್ಮೇಲೆ it was there for 5 years. 5 years license, my lord. ಅದಾದ್ಮೇಲೆ ಇವ್ರದೆಲ್ಲ PCR ಎಲ್ಲ ಇದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂಸ್ ಹರಾಸ್ಮೆಂಟ್ ಇಂದ ಲಾಸ್ಟ್ 2 years ಇಂದ ಕ್ರಷರ್ ಬಂದ್ ಮಾಡಿದ್ವಿ, my lord. Because
What is the ground for crashing?
ground is without having any authority, Deputy Environment Officer has initiated PCR proceedings. Complaint issue ಮಾಡಿದ್ದಾರೆ. Yeah. Page number 29 may be seen, my lord. It is their office memorandum. Second paragraph, the board is in 160 to 162nd meeting held on 13/2/2007 has authorized Deputy Environment Officer, Assistant Environment Officer to file cases on behalf of the board in the courts for violation under Water Act 1974 and Air Act
You come
1981
to
after obtaining approval from the chairman. Approval ತಗೊಂಡಿರೋದ್ ಬಗ್ಗೆ ಎಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ಅಪ್ರೂವಲ್ ಲೆಟರ್ ಕೂಡ ಯಾವುದು ಇಲ್ಲ. It is only he, wherever documents are there, only he is signed.
Sir, you have to tell me about the allegations made against the accused. Page number 26.
Please, my lord.
Para number 6.
Please, my lord. The complainant for the board held that had issued the closure order to the crusher as per Honorable Supreme Court order dated 8/4/2009 in civil appeal number. Order Honorable High Court of Karnataka, Bangalore dated 18/2/2011 in WP number 6616 of 21. Accordingly, closure direction was issued wide number so and so dated 7/8/2013, copy enclosed. The accused had not obtained any consent for operation by filing the requisite application in prescribed format. Thus, the operation subsequent to 1713 by accused is without valid authorization or consent for operation, and thereby the acts or any operations in any manner whatsoever attracts penal provisions under Air Act. ಅದಾದ್ಮೇಲೆ 2016 ಅಲ್ಲಿ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, my lord. 7 ಅಲ್ಲಿ the complainant board office at Monday has received copies of complaint on 21/1/2019 received from KSPCB Mysore wide PCB number so and so. The contents of the complaint disclose allegations leveled by Sri Ningaraju, President Karnataka Rakshana Vedike. Rakshana Vedike ಅವರು ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ they have acted against the accused.
ಕೊಟ್ರೆ ಅದನ್ನ ಹರಿದಾಕ್ಬೇಕು ಅಂತ ಇದೆಯಾ?
ಇಲ್ಲ ಮೇಡಮ್, I'm just
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಮಾಡ್ಬೋದು, ಯಾರಾದ್ರೂ ಮಾಡ್ಬೋದು. Yes, my lord. Based on the complaint of the officer, board inspected stone crusher on 8/2/2016. Reply was given to complainant Sri Ningaraju on 18/3. Copy of the inspection report dated 8/2/2016. Letter addressed to complainant Ningaraju are enclosed. Next paragraph, my lord. Accused, as the accused failed to comply to directions stated in supra, the complaint board officers have inspected the premises of the accused on 21/4/2017. ಇಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೆ 2019 ಅಲ್ಲಿ they have filed a PCR, my lord, after lapse of almost 2.5 years plus.
ಆಯ್ತು.
So reason best known to them. Chairman 29 prakara without obtaining permissions from chairman, the deputy environment officer has initiated proceedings against the accused.
According to you, only license is sufficient. You need not have to take the consent order to run the stone crusher.
Consent order earlier we had, my lord, it was up for renewal. ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿತ್ತು ಮಿಲಾಡ್ 2024 ವರೆಗೂ ಇತ್ತು ಬಟ್ ಲಾಸ್ಟ್ 2 years ಇಂದ ವಿ ಹ್ಯಾವ್ ಕ್ಲೋಸ್ ದ ಯೂನಿಟ್ ಸಿನ್ಸ್ ಶಿ ಇಸ್ ಅ ವಿಡೋ ಅಂಡ್
That, sir, at the time of filing when the offense is alleged, where is the compliance of the requirement?
PCR ಫೈಲ್ ಮಾಡಿದಾಗ ವಿ ಹ್ಯಾಡ್ ಲೈಸೆನ್ಸ್ ಮಿಲಾಡ್
ಎಲ್ಲಿದೆ?
2000
ಆಯ್ತು ಸರ್.
ಪ್ಲೀಸ್
Consent to operate, ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
that license has got all
Consent
the
for operation by KSPCB.
Yes, ma'am.
Pollution Control Board. License was issued by
page number 19 only.
ಲೈಸೆನ್ಸ್ ಎಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ.
Issued by ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಜಿಲ್ಲಾ ಕಲ್ಲುಪುಡಿ ಮಾಡುವ ಘಟಕಗಳ ನಿಯಂತ್ರಣ ಸಮಿತಿ. Annexure B, page number 19 Milord. Page number 19 Milord, Annexure B.
Mandya District Licensing Authority, ಅಷ್ಟೇ.
Yes, ma'am. Page number 21 may also be seen. Member Secretary and Senior Geologist Licensing Authority, Mandya District.
Do you mean to say that you need not have to get the consent letter for operation from Pollution Control Board?
My lord, they have a license, my lord, but they don't have the consent for operation.
That is what? Which provision requires such a consent for operation?
According to the Air Act.
Really,
And
the provision.
my lord,
It is, my lord, page number 22 may also be seen.
1 minute. ಯಾವುದು?
my lord, my senior is hospitalized today. He will be coming, my lord. So I don't have the proper instructions.
ಮತ್ತೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಿ ಕಂಬ ನಿಂತಂಗೆ?
My lord, I came.
At the beginning you should have mentioned. ಅದ್ರ ಹಿಂದೆ ಗೊತ್ತಿಲ್ಲ ಮುಂದೆ ಗೊತ್ತಿಲ್ಲ.
No, my lord, my senior told me to attend, so it's.
Pray for time. Next.
My lord, date may be given, my lord, please. NBW issue ಮಾಡಿಬಿಟ್ಟು ತುಂಬಾ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್.
ಮಾಡ್ಲಿ. ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ, ಅವರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ಅಲಿಗೇಷನ್ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಕನ್ಸೆಂಟ್ ಲೆಟರ್ಗೆ ಪ್ರಾವಿಷನ್ ಯಾವುದು ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ, ಅವರಿಗೂ ಗೊತ್ತಿಲ್ಲ.
ಮಿಲಾಡ್ ಕನ್ಸೆಂಟ್ ಲೆಟರ್ ಇಸ್ ದೇರ್ ಮಿಲಾಡ್. ಕಂಡೀಷನ್ಸ್ ಎಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಮಿಲಾಡ್.
ಎಲ್ಲಿದೆ ಕನ್ಸೆಂಟ್ ಲೆಟರ್?
Not consent, conditions to be followed by pharmacy license holder.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇದೆಯಾ ಇಲ್ವಾ?
Yes, ಮಿಲಾಡ್.
ಪೊಲ್ಯೂಷನ್ ಕಂಟ್ರೋಲ್ ಬೋರ್ಡ್ ಇಶ್ಯೂ ಮಾಡಿದಂತ ಲೆಟರ್ ಫಾರ್ ಆಪರೇಷನ್ ಎಲ್ಲಿದೆ? ಕನ್ಸೆಂಟ್ ಫಾರ್ ಆಪರೇಷನ್ ಎಲ್ಲಿದೆ? That is the allegation made in the complaint.
Yes, Milord.
Have you gone through the complaint?
Yes, Milord.
What is your answer to that? No answer. License ittu. ಆದ್ರೂ ಏನು ಪೊಲಿಟಿಕಲಿ ಮೋಟಿವೇಟೆಡ್ ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ರೆ ಕ್ವಾಶ್ ಆಗುತ್ತಾ?
ನೋಡಿ 2 ವರ್ಷ ಆಯ್ತು ನಾನು ಅದು ಕ್ರಷರ್ ಬಂದ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ. ನನ್ಗೆ ಐ ಮೀನ್ ಐ ಆಮ್ ಎ ವಿಡೋ.
That is not the
close down that crusher unit also.
You may close down, but at the time of commission of the offence, crusher was functioning as per the complainant.
Yes,
yes, ಅಷ್ಟೇ.